52 matters, my lord. Already I filed I for early hearing application. So this is second time, my lord, moving that memo, my lord. Yes, put it.
Non-compliance of office objections for fourth time. Serial number 1, Veerangoda Mali Patil.
Weeks time.
Finally, 2 weeks are granted at the request of learned counsel for the appellant for compliance of office objections.
Serial number 2, Bhimaraya M.
1 week, my lord. That's chance.
Idu aste. Finally, 2 weeks.
End of month.
Serial number 3,
But I praise of 2 weeks,
advocates.
2 weeks, my lord. I
Same order.
please.
Serial number 4, Harshavardhan Mali Patil.
Request for 2 weeks time, Lord.
Huh?
Pray for weeks.
Same order, same order.
Like-
2 weeks finally.
Serial number 5, AM Biradar.
6 per time, 2 week time with regard to payment of.
Same, please. 2 weeks.
Non-compliance of office objections for fifth time. Serial number 6, Chaitanya Kumar Chandriki.
Kumar Chandriki's brother has expired today. Lord.
A submission is made on behalf of learned counsel for the appellant that there is a bereavement in the family. Full stop. Release this matter on 25th of November for compliance of office objections.
Orders. Serial number 7, Singan Baswa B Patil.
My lord, last date application, my lord, the learned counsel for the respondent has submitted that the filing the affidavit in respect of my lord, guardian what's act, the child residing at mother of the minor, my lord, you not intend to proceed the matter, my lord. ಅವ್ರಿಗೆ ಪಾರ್ಟಿಗೆ ಆರಾಮಿಲ್ಲ ಅಂತ ತಿಳ್ಕೊಂಡು ಟೈಮ್ ತಗೊಂಡಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್.
ಇಲ್ಲ ಅವ್ರು ಸಬ್ಮಿಷನ್ ಮಾಡಿದಲ್ಲ.
ಹೌದು ಸರ್. ಹೌದು ಸರ್.
ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ ಇನ್ನೂ ಹಾಕಿಲ್ಲ ಸರ್.
ಪ್ರೈವೇಟ್ ಹಾಕಿಲ್ಲ.
ಇನ್ನೂ ಹಾಕಿಲ್ಲ.
ಪಾಸ್ ಓವರ್.
Serial number 8, Singan Baswa B Patil.
Appear, my lord. My lord, value of the subject matter, my lord, less than 15 lakh, my lord. The value of the subject matter, my lord,
The representation is to comply the order dated 24/1/2020
Please,
in WP number so and so. In the said proceedings, directions were
was
issued
issued to the
to enter
respondent
the name of the petitioner in respect of property bearing number so and so.
so and so.
Ah,
Direction is issued in this case. And I was directed to file one more representation.
ah,
As per annexure D, D1 and D2,
ah.
I filed one more
Consider representation and pass orders
orders in
within
accordance.
3 months.
Please.
They have passed orders.
This is the order which holds that it is a Inam property, Inam land.
We are not
And-
concerned
and-
with what has been stated in the endorsement. The direction was that your representation should be considered and appropriate order should be passed. They have passed orders. If you are not happy with this, you challenge this.
My submission is, my lord, civil court has already declared me as owner. And
Sir,
this
we-
man,
This is a contempt court. We can't go into all those aspects.
one second, I'll explain. There was a dispute between me and the government. Ultimately, I approached the civil court. Civil court declared me as a owner and directed the authorities to enter my name. In spite of that, they did not do it.
That is what we
Therefore,
are
I
saying,
filed a
sir.
writ
You are
petition.
talking on the merits of the matter,
Please,
that this kind of an endorsement could not have been issued.
correct.
So therefore,
Finding is given.
we are giving you liberty, so you challenge this one.
Finding is given saying that it is
We are
Inam
only
land
required
despite.
to consider whether the directions issued by the learned single judge is complied or not.
That is complied, my lord.
ಅಷ್ಟೇ
Finding is,
ಬರ್ಕೊಳ್ಳಿ.
I may be given liberty to file.
ಅದನ್ನೇ ಸರ್ ಹೇಳ್ತಾ ಇರೋದು ನಾವು. That is what we are telling. Learned government advocate takes notice for respondent number 2. Next para. Office has rightly raised objection regarding maintainability of the contempt petition. Since the first respondent has issued an endorsement dated 13/10/2023, which has been produced by the complainant at annexure E, comma, pursuant to the directions issued by the learned single judge. Full stop. Next para. The complainant had filed a writ petition number 2000505 of 2023. Seeking a writ of mandamus, directing the respondents to consider the representations given by the petitioner. Full stop. Accordingly, the writ petition was disposed of on 15th of February 2023, directing the first respondent herein to consider the representation and pass orders in accordance with law, comma, within 3 months from the date of receipt of a certified copy of the order. Full stop. Although there is a delay in considering the endorsement, representations given by the petitioner, comma, nevertheless, the first respondent, comma, while considering the representation, has issued an endorsement on 13/10/2023, citing reasons for rejecting the representation given by the petitioner. Full stop. We are therefore satisfied that the directions issued by the learned single judge have been complied. Full stop. However, if the complainant is not satisfied with the endorsement, comma, they are at liberty to question the endorsement in accordance with law, or take any other steps which are available for the complainants to redress their grievance. Full stop. Next para. Accordingly, the contempt petition is dismissed.
Public.
CL number 10, Ganesh Chandra Kalaburagi.
In this matter, I am filing application for additional evidence. It could be passed over, your lordship, I'll
My
file
lord,
it.
with your lordships. I'm sorry, my lord.
Your lordships, in this matter, I am filing application for production of additional evidence, your lords. It could be passed over, your lordship.
Evidence.
How those? Both parties are present, your lordships.
What did we discuss last time?
Your lordships, in fact, there is a certificate of registration, your lordships, of marriage registration.
Ah,
And your lordships, in the previous proceedings, which was instituted by the respondent seeking conjugal rights, restitution of conjugal rights, in that your lordships, he has specifically stated that your lordships marriage has performed before the sub-registrar on the 13/10/2017.
Ah.
Your lordships, in fact, the DW2 in the present case, who was RW2 in that case, your lordships, a specific question was posed to him, whether there was a marriage performed before the registration of marriage or not. He says, your lordships, it has not happened. And thereafter, your lordships, in the subsequent proceedings, he comes and says that the place of marriage and the date of marriage, your lordship. That is the documents which were not produced before the family court, your lordship.
no. We were discussing regarding your, whether you had raised the ground regarding the rituals.
Customs and usage, I have,
And
Usage.
rituals.
yes, your lordships. I have raised that ground, your lordships.
You have not raised that ground.
I have stated that your lordships, customs and rituals has not been performed.
Aste,
ಅಷ್ಟೇ ತಗೊಂಡಿದ್ದೇವೆ.
ಹಾ.
And with regard to your lordship, there is another judgment of the Honorable
at least
Supreme.
in your examination in chief, you should have said, these are the customs. For required to be followed, they are not followed. Adunu helilla. That is what we discussed last time.
Yes, yes.
What do you want to do now?
Your lordship, I would like to produce the document, that is the petition and
What is the
chief
use of-
examination of the respondent and your lordship, the evidence of DW2, your lordship,
Ah.
which were not produced before. ಇಲ್ಲ, ಇದು ಕೇಸ್ ಅಲ್ಲಲ್ಲ ಸ್ವಾಮಿ.
ನೋಡ್ಲಿಲ್ಲ.
ಇದ್ರಲ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ಮುಂಚೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲೇ.
ಹಾ?
ಮುಂಚೆ ಪ್ರೊಸೀಡಿಂಗ್ ಇನ್ ದ ಪೆಟಿಷನ್
ಹಾ.
seeking restitution of conjugal rights.
ಹಾ.
The petition copy was not produced, the chief examination was not produced, the evidence of DW2 in the present case was not produced.
Ah.
That documents I would like to seek permission to produce those before this honorable court, your lordship.
All that cannot be done here, sir. What's the use of doing all that now here?
Your lordships, I'll produce, if your lordships can look into those documents and remand back to the family court for fresh consideration, it would suffice, your lordships. It is evident, your lordships. I will, it could be passed over, your lordships. I'll produce those documents. Application is getting it. I'm getting it stitched, your lordship.
Huh?
I'm getting it stitched, your lordship, the application. It could be passed over, your lordship. I'll produce those.
ಆಯ್ತು, ಪಾಸು.
Scale number 11, Harshvardhan R. Mali Patil.
The council submission is regarding, my lord, discrepancy in the factor that is applied. There is one table in the, my lord, judgment, even page, where, my lord, factor is shown as 1. In the operative portion, my lord, paragraph number 2. The factor is, my lord, this is,
Office objection at serial number 8.
yes,
ಏನದು?
the office has sought for, my lord, clarification regarding, my lord, the factor. which-
Value of the factor
Yes, my lord.
differs between judgment and award. Seem to be clarified.
Yes, my lord.
Ah.
My lord, I have clarified that, my lord, factor 2 is considered. It is, my lord, in the operative portion at paragraph 2.
Page number?
My lord, page number, I believe it is 19, my lord, internal page 19, 26. my lord. Running page 26, judgment page number.
Ah. Type page number?
Petitioner is entitled for so and so, market value plus factor 2 plus, my lord, 100%. My lord, on the previous page, my lord, there is a table extracted in paragraph 19, my lord. There, my lord, it is shown as factor 1. My lord, this is the, my lord, clarification the court has, my lord, sought, the registry has sought for. I have valued, my lord, considering factor 2.
Factor by which the market value is to be multiplied.
Yes,
In the case of rural areas.
rural area.
ಅದಾ?
ಹೌದು.
ಹಾ.
Rural area.
ಅದು factor 2 applicable ಆಗುತ್ತೆ ಅಂತ beyond, my lord, 5 kilometers. My clarification is, my lord, the factor two mentioned in.
This is only the extraction of what is found in first schedule.
Yes.
Where is the calculation?
Lordships may kindly see, my lord, paragraph 19.
19.
Yes, judgment paragraph 19.
Ah,
The petitioner is entitled, there is a table, my lord, extracted. Item one is, my lord, the value.
ah,
Item two, my lord, is the factor.
ah.
It's shown as
Factor 1.
factor one anta torsidare. But while totaling, my lord,
1
the-
to 2.
in the
Based
operate,
on the distance of project from urban area. So but it is taken that you are in the rural area.
yes,
Huh?
my lord, the code says both things, my lord. In the table, it says factor one.
Ah,
In the operative portion, it says factor two. My claim is, my lord, based on factor two, my lord, I have valued it that way. And I'm saying that, my lord, factor application of factor two is proper.
how are you claiming that you are in urban area?
My lord, my claim, my lord, it's more like, my lord, not urban and it's, my lord, in general terms, urban and rural, but the specific.
In that first schedule, it is clearly stated.
Yes.
Factor 1 refers to market value to be multiplied in case of rural areas.
Yes.
And next column only,
How?
based on the distance of the project from urban area.
Urban.
Huh?
Yes.
What is your contention and
my-
what is the finding?
This is
In that regard, what is the finding?
the finding is, my lord, both are, my lord, considered in the
Hinge,
judgment alli one anta tagonತಾರೆ in paragraph 19.
there has to be a discussion.
Yes.
As to whether it falls under factor 1 or factor 2.
Yes.
ಅದನ್ನೇ ಅವರು ಕ್ಲಾರಿಟಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ how do you proceed to calculate?
But what will happen is, my lord, while determining award by the SLO,
ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ?
our factor two ಹಿಡಿದಿದ್ದಾರೆ.
Factor 2. So
Lord,
therefore,
Yes.
if your contention is no, it falls under factor 1. Where is the discussion and what is the finding of the?
My case is, I am claiming, my lord, factor two is applicable. If your lordship
What
sees
is the
my,
conclusion of the reference code?
this is, my lord, this is the only, my lord. Factor one anta ತಗೊಂಡ್ಬಿಟ್ಟು. How it's, my lord, in factor one, my lord.
ಹಂಗಾದ್ರೆ there's something wrong. We'll have to remand the matter. See, if you don't even come to a conclusion.
Yes.
As to whether it is in urban area or rural area. The finding itself the reasoning itself is not found, which can be appreciated.
No, while determining, my lord, they have assessed.
SLA was taken it as factor 2.
Yes.
The reference court also has taken it as factor 2. You see page number 32. In page number 32. ಯಾವ್ದು? Decree.
It's a fresh matter, my lord, notice has to go. But, my lord, I followed, my lord, your lordships. When there is no answer why it is factor one or two, it requires, my lord, consideration. My my lord, argument was, it ought to have awarded, my lord, factor two. Determination, my lord, is based on, my lord, the sale deeds that are produced. ಯಾವ್ದು? ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಫ್ಯಾಕ್ಟರ್ ಟೂ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಆ ಟೇಬಲ್ ಅಲ್ಲಿ ಫ್ಯಾಕ್ಟರ್ ಒನ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಸೊ ದಿ ಆಫೀಸ್ ಹ್ಯಾಸ್ ಸಾಟ್ ಫಾರ್ ಎ ಕ್ಲಾರಿಫಿಕೇಶನ್ ವೆದರ್ ಇಸ್ ಫ್ಯಾಕ್ಟರ್ ಒನ್ ಆರ್ ಟೂ. ಐ ಹ್ಯಾವ್ ಆನ್ಸರ್ಡ್ ಇಟ್ ಇಸ್ ಫ್ಯಾಕ್ಟರ್ ಟೂ ಅಂಡ್ ಐ ಹ್ಯಾವ್ ಆಲ್ಸೋ ಕ್ಲೇಮ್ಡ್ ಫ್ಯಾಕ್ಟರ್ ಟೂ ಓನ್ಲಿ.
ಇಲ್ಲಿ ಅಲ್ಲೇ ರಿವ್ಯೂ ಹಾಕ್ಬೇಕಾಯ್ತು. ಈ ಫ್ಯಾಕ್ಟರ್ ಓನ್ಲಿ
ಟೈಪೋಗ್ರಫಿ.
See, although it is taken as factor 2, but it is typed as factor
ಟೈಪ್
1.
ಡೈವ್ ಇಸ್ my lord ಫ್ಯಾಕ್ಟರ್.
ಫ್ಯಾಕ್ಟರ್ 2 ಆದ್ರೆ ಒಂದು 1,37 ಲಕ್ಷ. ಫ್ಯಾಕ್ಟರ್ 2 ಆದ್ರೂ ಅಷ್ಟೇನ ಬರೋದು?
Yes.
1+1.
Yes.
Correct
1+1.
ಅಮೌಂಟ್ ಕರೆಕ್ಟ್ ಐತೆ ನೋಡಿ.
So ಇದು ಟೈಪೋಗ್ರಫಿ.
ಅದನ್ನು ಟೂ ಬರೋ ಬದಲು ಒನ್ ಬರ್ದಿದ್ದಾರೆ
ಅಷ್ಟೇ
ಟೇಬಲ್ ಅಲ್ಲಿ.
ಫ್ಯಾಕ್ಟರ್ 1 ಆಗಿದ್ರೆ ಹಾಫ್ ಬರೋದು.
ಹೌದು.
1.5.
ಹೌದು.
ಇಲ್ಲಿ ಡಬಲ್ ಬಂದಿದೆ.
ಡಬಲ್ ಬಂದು 75 + 75 ತಗೋ.
ಒಂದು ಟೈಪೋಗ್ರಫಿದಲ್ಲಿ ಎರರ್.
ಬರ್ಕೊಳ್ಳಿ. regarding office objection at serial number 8. That the factor in terms of the first schedule differs from what is shown in the judgment and award. Learned counsel submits that the SLAO has considered the case under factor 2, and the award also clearly shows that the reference court has also taken it as factor 2. Full stop. However, in paragraph number 19, there is a typographical error wherein it is shown as factor 1. But the amount determined is in terms of factor 2. Full stop. Next para. The submission of the learned counsel for the appellant is accepted. Office objection at serial number 8 is overruled.
Great.
What about court fee?
Court fee, my lord, I filed that application. Respondent's notice could be ordered, my lord, pending consideration.
Other than either. Same ಅಥವಾ ಬೇರೆ
Same,
matter
same,
ಇದು?
same project.
ಬೇರೆ matter.
ಬೇರೆ matter, same project.
Next para. Pending consideration of IA 1 of 2023 for enlargement of time for payment of court fee, comma,
Government advocate.
learned government advocate is directed to take notice for respond number 3.
Please.
2 and 3, na?
All three.
All of them,
3, 1 to 3.
huh? To take notice for all the respondents. Learned counsel for the appellant is directed to serve copies of the appeal memo along with the annexures on the learned government advocate.
Great.
Yes.
Government advocate.
Appear for the appellant, my lord. R2 is the, my lord, minor, represented by the R3, my lord. R3 is already represented by the council, my lord. What's to direct him to take notice for R2 also.
I undertake, my lord.
ನೀವೇ ತಗೋತೀರಾ?
Please.
Learned counsel Shri Sanganam Basava B. Patil undertakes to appear for respond number 2 also.
Yes.
A week's time is granted to the learned counsel to file wakala.
Yes.
Yes.
Serial number 13, one page party.
In this matter, my lord, I appear for the responder 1. I filed the affidavit for compliance, my lord. There is a direction, my lord, by the learned single judge to consider the representation of the complainant. What page number 11, my lord. Para number 6, my lord, it is page number 10.
Ah.
Directed to consider the representation submitted with petitioner on 1/4/2022 wide annexure C and C1. Act in accordance with the law for the implementation of the order dated 18/5/2023 wide annexure J.
Hmm.
Then, my lord, we directed the Jilla Panchayat to submit the report, whether the work is carried out or not. Then they submitted the report, my lord, regarding, my lord, not to carry the work, my lord, in accordance with the law. Thereafter, my lord, annexure R4, my lord, for a moment, page number 19.
Copies.
To expedite the process of releasing the amount
Yes, my lord.
pursuant to order dated 8/5/2023.
That is the request, my lord, by the complainant.
Ah.
Then, my lord, annexure R4, my lord, This is the written letter to the, my lord, Jilla Panchayat. Page number 20, my lord, operative.
Who has to
portion.
pay the amount?
That is, my lord, not required to pay back because, my lord, that is not taken into, my lord, there is no approval for the work also. There is a, my lord, committee submitted the report regarding that none of the work is, my lord, to obtain the approval from the higher authority. That is, my lord, even PD is also, the PDO is also suspended in this matter. Then, my lord, Jilla Panchayat issued the, my lord, endorsement, Annexure R6, my lord, last portion, my lord, page number 27. Rejected the claim of the, my lord, complainant.
That affidavit copy is not served, my lord. I will collect the copy and I will make
Copy
submission
is
on next
already
day.
served. Put it there.
No copy.
Already paragraph number 5 ಅಲ್ಲಿ,
Please,
in that order, page number 10,
This one.
learned SCGP for respondents 1 and 2 and Sri Kripasagar Patil, learned counsel for response number 3 to 5, submit that they have no objection to accord the prayer sought by the petitioner.
That is for consideration of representation, not representation is.
Already, if your contention is that we have already informed that since there is no approval, we cannot make the payment anta,
No, that is after the order was passed, an internal inquiry was conducted. An internal inquiry, we came to know, my lord, the fraud has been cleared by the PDO and the concerned complainant.
Ah.
And an order is passed, my lord, to take action against both them and criminal action to be initiated against them and an endorsement is issued. A fraud has been cleared by both the PDO as well as the concerned complainant. my lord.
where is the endorsement issued now?
that is Annexure R6, my lord. Last one, my lord, issued by the Jilla Panchayat. That is dated 23/10/2024, my lord.
Please give him a copy. ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ ಕೊಟ್ಬಿಟ್ರೆ.
ಅದೇ,
One date may be fixed, my lord. I will go through it and next I will make submission, my lord.
We will give you liberty to challenge this.
Kindly pass over, my lord. I'll go through it and make submission. Kindly pass over, my lord.
On it.
Please.
Barkal. Learned government advocate submits that complaints affidavit has been filed on 11/11/2024 along with all the requisite documents. Full stop. Attention of this court is drawn to the order passed by the learned single judge. Stop. Directions have been issued by the learned single judge to respondents number 2 and 3 to consider the representation submitted by the petitioner on 1/4/2022 and act in accordance with law for the implementation of the order dated 8/18/2023 at Annexure J, as expeditiously as possible. Full stop. Learned government advocate submits that the Chief Executive Officer of the Zilla Panchayat, Kalaburagi, has issued an endorsement dated 21/23/10/2024 to the complainant while stating that no approval was taken for the works and action has been initiated against
concerned PDO.
the concerned Panchayat Development Officer. And an inquiry has been initiated against all the concerned persons. Full stop. Therefore, it is stated in the endorsement that since there was no approval for the works, no payment can be made by the Panchayat. Full stop. Next para. we find that the prayer in the writ petition was to issue a writ of mandamus directing respondents number 2 and 3 to consider representation dated 1/4/2022 and to expedite the process of releasing the amount pursuant to the order dated 8/18/5/2023. And accordingly, directions have been issued by the learned single judge. Full stop. Having regard to the endorsement issued to the complainant, we are satisfied that the directions issued by the learned single judge have been complied with. Full stop. However, if the complainant is not satisfied with the endorsement, he is at liberty to raise a challenge to the same and seek redressal of his grievance in accordance with law. Full stop. Next para. The contempt petition is accordingly closed.
For R1, my lord, I filed the memo of appearance today, my lord. For R1,
Okay.
for R1, my lord, I filed the memo of appearance today, my lord.
Learned government advocate submits that he has also filed memorandum of appearance for respondent number 1.
Please.
Yes.
CL number 14, Yema L. Kulkarni.
This is pertaining to the supermarket matter, my lord. This matter may be taken along with serial number 34, my lord.
34.
Learned, yes, 34, serial number 34, my lord.
This case
That
they
is
have
also
filed writ appeal.
supermarket matter.
Writ appeal they have.
My
filed.
lord,
Yes,
in
yes,
this
yes.
case, my
Yes.
lord, may I make
Ah.
submission with lordship permission, my lord?
Ah,
My lord, in this case, my lordship is aware that review petitions we have filed and we have lost the review petition is filed by the state is a dismiss, my lord.
yes.
Now the
yes.
process has to be in obey the order of this honorable court to be allot the sites, my lord. In this case, my lord, the one of the tribunal, the secretary also it's presented in the court, my lord. So, my lord, we are going to be a process and allocations is going to be make it and we are going to be in allot.
In what time?
2 weeks time, my lord, we have granted, my lord. So because size and all, it required to be.
That may be.
Time it's up. I'm praying for that 2 weeks time to be. And in the meantime, that order copy also review petition based on that we'll get a permission also, my lord, from the state.
Learned advocate general appearing on behalf of the respondent submits
It's not audible, my lord.
sought to review an order passed by a coordinate bench of this court in respect of an order passed on a writ appeal filed by the respondents. Full stop. Therefore, all the writ appeals, the writ appeal filed in this matter would also have to be rejected on the same. Learned AIG submits that
Even it's not.
petitioners, the respondents require some time to identify the sites and allot the same to all the 7 of them. Full stop. In that regard, 2 weeks time is sought by the learned AAG. Full stop. Next para. Placing this petition of the learned AAG on record, release this matter on 28th of November,
Please.
2024
Grateful.
for compliance. Yes,
Serial number 34 also same, my lord.
34. Same.
CL number 34.
Grateful, man.
Other side is.
Bill number 15, GG Chakshetty.
I am appearing for the complainant. For R6, may kindly peruse the order of the learned single judge, page number 11. The writ petition is allowed. Response 3 and 4 are directed to consider the annexure G and pass approved orders within a period of 2 months from today and file compliance report to this board.
To pay damages under section 19(1)
Yes, your R6 may kindly see matters
for having utilized the land.
of 11 guntas.
Hmm.
By virtue of the order passed by the earlier writ petition, a survey has been conducted and they came to know that 11 acres
Direction
of,
was issued to make necessary arrangements for survey and fixing the boundary.
yes, fine.
Thereafter, survey was conducted and it was found that in the land of the petitioner, 11 guntas, a road has been formed by the Public Works Department.
Yes, ma'am.
Annexure G is the representation given by the petitioner to pay necessary compensation. Response number 3 and 4 are directed to consider annexure G and pass orders within a period of 2 months
Not good.
from today.
Yes, my lords, consider and pass the order, we are received also, my lord. And the land is used by the Public Works Department, my lord, we issued the endorsement on 3/9/2024 and he has received it on 5/9/24.
Yenanta?
That land has been used for the they are not concerned about the state highway is formed in that same survey number, state highway 124 of so and she is formed in respect of 11 quotas.
PWD in party ಇದೆಯಲ್ಲಮ್ಮ
ಅಲ್ಲ ನಾನು CEO
ಅಲ್ಲ learned government advocate.
ಅಲ್ಲ ಅದಕ್ಕೆ therefore we have issued an endorsement, he received that tender.
In VR, that is the we are not concerned with that. The Public Works Department also is a party to the and therefore directions have been given. Two and 3, Deputy Commissioner
Yes. 3
and the Zilla Panchayat.
Jilla Panchayat, my lord, issued an
Aitu,
endorsement.
Zilla Panchayat, if Zilla Panchayat has not utilized the land, you are not going to pay.
Yes, my lord.
What about Public Works Department?
Regarding this, my lord, I have not received the instruction, my lord. You also have it next week, my lord, I will file the affidavit of the deputy commissioner.
Against 3 and 4, my lord, it may be this.
Notice issue ಆಗಿತ್ತಾ?
Yes, my lord, the notice is issued and I filed wakalat also.
Learned Counsel Srimati Ratna N. Shivogimat appearing on behalf of response number 2 and 3.
Not, it is mistake, by mistake it 2 and 3 and 4, my lords. Jilla Panchayat, CEO Jilla Panchayat.
ಅಲ್ಲಮ್ಮ ಇಲ್ಲಿ contempt ಅಲ್ಲಿ
Contempt.
CEO is respond number 2. Respond number 3 is Assistant Executive Engineer Panchayat Raj Division.
Amendment ಮಾಡಿ ಕೊಡೋದಿಲ್ಲ.
Amendment ಮಾಡೋದು ಕಾಪಿನೇ ಕೊಡಬೇಡಿ.
Amendment ಮಾಡಿ ಕೊಡೋದಿಲ್ಲ.
Yes, 2 and 3, both of them, they issued an endorsement. I guess 2 and 3, the contempt is not, they are not used that land money.
Has filed ವಕಾಲತ್. ಏನಂತ ಬಂತು?
2, 3 ಎಲ್ಲ
Bombay Panchayat.
2 and 3.
Officer ಮಾಡಿದ್ದಾರೆ.
Zilla Panchayat
ಒಂದು ನಿಮಿಷ ಕೊಡಿ ಸರ್.
submits that the Panchayat has not utilized the land belonging to the petitioner.
Yes.
Full stop. It is found that the Public Works Department has utilized the land and therefore respondents number 2 and 3 are not liable to pay any compensation to
We already issued the
the
endorsement.
complainant. Full stop. In that regard, an endorsement dated
3/9/2024, my lord, and he has,
3/9/2024 has been issued to the complainant.
yes, he has received acknowledgement also produced.
Full stop.
5/9, he has received that
It
endorsement.
is submitted that the complainant has received the endorsement on 5/9/2024.
Please.
Full stop. Next paragraph. The ball therefore shifts to the Public Works Department, which is also a party to the proceedings before the learned single judge. Full stop. Directions were issued to the Deputy Commissioner, Vijayapura, also to consider the representations given by the complainant. Full stop. Next paragraph. Learned government advocate seeks for a short accommodation to secure instructions from the deputy commissioner. Full stop. Next para. Release this matter on 21st of November.
Or you will also be
Please
directly.
first,
Yes,
first
sir.
find out whether all this has been brought to the notice of the deputy commissioner.
I'll get it, my lord. Wrong copies served to us, my lord. Even writ petition copies also. I don't, that is the, we are confused. Kindly see the, my lord, the copy of the order produced along with the contempt.
Ah,
That is one, my lord, that is 2,18,1800 of 2023.
200881,
Yes, but this is wrong copies furnished to us.
wrong copy.
Yes, but that is a confusion, my lord. ಯಾವ್ದು ಯಾವ್ದು ಕೊಡ್ತೀಯ ಕರೆಕ್ಟ್ ಕಾಪಿನೇ ಕೊಡಲ್ಲ ಸರ್, ದಟ್ ಇಸ್ ಅ ಪ್ರಾಬ್ಲಮ್.
I have to serve another copy, one
Next
more
para.
copy.
Learned counsel for the complainant is directed to furnish a complete set of the petition along with all the annexures, including copy of order dated 15th of March 2024, passed in WP number 2000881 of 2019 to the learned government advocate. Yes.
Please.
21st of serial number 16 AM Nagaraj.
It's I am for the respondent 9. Matter, my lord, I will seek 1 week time for paying process, my lord. Since there are so many respondents, my lord, last date of hearing, my lord, your lordship has, my lord, permit me to serve the copy and the counsel who appear before the that single judge. My lord, so served the copy on the Mr. Amrish Roja as well as Mantesh Patil for the private respondent.
Ah.
However, my lord, in the order sheet, in the cause list, my lord, Mantesh Patil has Torsila. 29/10/2023 order sheet may be seen.
You are appearing for whom?
R9. 9, my lord, society,
Society.
please.
This election matter arose out of a cooperative society.
Cooperative society.
Ah. You said a copy on Mr. Mantesh.
Yes, yes. But cause list till Torsila or sir, blood here. Office may be directed. You take copy. It's not still in the cause list, but I will be taken next week.
Learned counsel Sri Amresh S. Roja
For R9.
has appeared for respondent number 9.
9.
Society. Stop. Although copy of the appeal memo has been served on learned counsel Sri Mantesh Patil, who appeared for the writ petitioners.
Yes.
Comma, nevertheless, his name is not shown in the cost rate. Full stop. Learned counsel Sri Mantesh Patil seeks for a short accommodation. Full stop. Release this matter on 19th of November 2024. Full stop. Office is directed to show the name of learned counsel Sri Mantesh Patil
For R10 to
for
50,
response number 10 to
52.
52.
Yes.
Yes.
Oh, bless.
Serial 17. Savan Kumar Mat.
My lords, the registry has raised an objection that all the annexures of KSAT application have been not annexed here with my lords. My lords, kindly peruse page 44, Masami. I have only challenged the order, the notification issued by the chairman of the
Maintainability is overruled for
maintainability overrule agide, Swami. Other annexures were not annexed anta agide.
3.
Ha, Swami. Idralli, my lords, my humble submission is that only notification issued by the chairman KSAT has been challenged, my lords, wherein he has transferred the pending matter since seniority list, seniority matters cannot be heard by the benches at Kalaburagi and Belgaum anta notification madidru. Adanna now challenge madidevi. There, our petition application is for inter-say range forest officer seniority list has been challenged, my lords. Hence, for the disposal, adjudication of this petition, my lords, those annexures are not required anta hakide. Voluminous ide, bari ಅವ್ರದ್ದು seniority ಇದು ಇದೆ ಸ್ವಾಮಿ, list of seniority ಇದೆ, ಅವನ್ನ ಬೇಕಾಗಲ್ಲ ಅಂತ.
Regarding office objection at serial number 3, learned counsel for the petitioner submits that
Page 44, my lords. Notification dated 25th September 2019 by chairman at KSAT.
the
Bangalore.
petitioners have challenged the impugned notification dated 25th of September 2019 issued by the registrar of the Karnataka State Administrative Tribunal at Bengaluru. Full stop. All the other documents are not required for the consideration of the case before this court. Full stop. Next para, the submission of the learned counsel is accepted. Office
Published.
objection at serial number 3 is overruled.
Other office objections are complied, my lords.
Sorry.
ಅದನ್ನ see, my lords, earlier also, my lords, we have engaged with senior counsel. ಈಗ next short accommodation ಕೊಟ್ರೆ senior counsel engagement. Any date convenient to the government, my
Just
lords.
to come up for preliminary hearing.
Preliminary hearing ಬಂದಿತ್ತು.
ಆಗೋಗಿದೆಯಾ?
ಆಗೋಗಿದೆ.
ಹಾ.
B group chairman notice ಅದು ಸರ್ವ್ ಆಗಿರುತ್ತೆ sir. KS, we have even paid PF to the KSAT and government is also party to this. It
Who
has,
is appearing on behalf of the tribunal now?
government is PF
Our
ಕಟ್ಟಿದೀವಿ ಸ್ವಾಮಿ. I have paid PF, my lord, to KSAT.
notice has been sent.
Yes, yes.
ನೋಡ್ರಿ ನೋಟಿಸ್ ಹೋಗಿದ್ಯಾ?
First time ಬರ್ತೇವೆ.
ಬಂದಿಲ್ವಾ? ಈ ಬಂದಿದೆ ಹೋಗಿದೆ.
ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದು ಸ್ವಾಮಿ ಇದಕ್ಕೆ ಬಂದಿತ್ತು ಸ್ವಾಮಿ, ಆರ್ಡರ್ಸಿಗೆ ಬಂದಿತ್ತು, ಅವಾಗ ಸ್ಟೇ ಮಾಡಿ coordinate bench of this honorable court has stayed and issued notices, my lords. Pending office objections open. ಅದಕ್ಕೆ I had paid PF to the respondent number 1.
Learned government advocate accepts notice for response number 2 and 3. Issue notice to respondent number 1. Respondent number 1 ಯಾರು? KAT. ಹೋಗಿದೆ ಹಂಗಾದ್ರೆ. ಆದ್ಮೇಲೆ ಪ್ರೋಸೆಸ್ ಕಟ್ಟಿದ್ರೇನ್ರಿ ನೀವು?
ಕಟ್ಟಿದೀನಿ ಸ್ವಾಮಿ on 3rd September, my lords. 3rd September, my lords.
ಇಲ್ಲ, ನೋಟಿಸೇ ಹೋಗಿಲ್ಲ.
I will pay again, my lords. On 3rd September, I have paid PF, my lords.
Next para. Learned counsel for the petitioner submits that he has paid process fee for service of notice on respondent number 1.
KSAT, my lords.
KSAT.
Yes.
Huh?
ಹೌದು ಸ್ವಾಮಿ.
On
3rd September
3rd of
2024.
September 2024. Pursuant to orders passed on 31/8/2024. Full stop. Next para. If that is not, comma, office to verify and issue notice to respondent number 1. ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ವಾ?
Some of them have remaining ex parte before the tribunal itself, my lords. And some of them have already filed wakalat. Respondent number 1, 8 and 7 have filed wakalat. They have not, their names are not shown, my lords. Some advocates have filed wakalat, my lords. R8 and R1 ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. R1 ಗೆ ನೋಡಿ 9th October 2024 ಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
R1 ಗ
ಈ ತರ ಬರ್ದಿದ್ದಾರೆ ರ್ಯಾಂಕ್ ಆಫ್ ಪಾರ್ಟಿ ಆಫೀಸಸ್ registry has raised.
R1 is tribunal. ನೀವು ಅಲ್ಲಿ ಇದ್ರ ಮುಂದೆ ಯಾರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದ್ರಿ ನೀವು? ಟ್ರೈಬ್ಯುನಲ್ ಮುಂದೆ. This order was challenged before the tribunal itself?
No, smart.
No.
Their only seniority list was challenged, my lords. Earlier round of litigation ನಲ್ಲಿ KSAT had.
You filed the application but it was, office objection was raised.
Office objection, Swami. The other side has appeared and filed that seniority list cannot be heard by that bench anta. By that notification straight away Bengaluru hoitu Swami, now application.
Ah.
That administrative order as well as the notification issued by the KSAT chairman through registrar has been challenged before this honorable court.
Actually, they were not necessary parties. Why did you make them parties here?
ಅವ್ರು ರಿಜಿಸ್ಟ್ರಿದವ್ರು ಬಿಡೋದೇ ಇಲ್ಲ ಸ್ವಾಮಿ. ರಿಜಿಸ್ಟ್ರಿ ಅಂತ ಫಾರ್ಮಲ್. I will.
This cannot be a writ KAT. It is not a writ KAT. It is a writ which should have been shown as writ GM. GM res anta barಬೇಕಾಗಿತ್ತು.
Earlier PIL ಅಂತ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ ರಿಜಿಸ್ಟ್ರಿದವ್ರು, ಅದನ್ನು ಓವರ್ ರೂಲ್
are not questioning an order passed by the tribunal.
Yes.
In the sense a judicial order.
Administrative order.
Not a judicial order, it is an administrative order.
ಹೌದು.
And therefore, this should have gone before the learned single judge. In terms of the circular issued by this court, if an order is passed by any retired high court judge,
Yes.
including KAT, CAT, those matters should come before the division bench. Here you are not questioning any order passed in the sense,
Yes, ma'am.
no judicial order.
No jurisdiction.
It is only a notification issued by the registrar of the tribunal.
Subsequent orders admission.
Therefore, correctly speaking, it should have gone before the learned single judge.
Yes. Since ಅವರು ಹೈಕೋರ್ಟ್ ಜಡ್ಜಸ್ ಇರ್ತಾರಂತ ನಾವಿಲ್ಲೇ ಹಾಗೆ.
This notification
notification
is
is
issued
administrative
by
in
the
nature.
registrar.
Yes. By order of chairman, ma'am.
ಇರ್ಬೋದು.
Learned senior counsel will address the arguments, my lords.
ಅದೇ ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು. Next year E.
Second prayer ಅದೇ ಸ್ವಾಮಿ. Quashing the impugned order dated 29/7/2024, last in application number.
Annexure E.
That is a subsequent to order, my lords, which were heard at Bangalore, my lords.
You have order dated? 26/7.
29 ಅಂತ ಇದೆ.
26/7.
We made the
Page
wrong.
number 64. Page number 60. Ink page number 64 ನೋಡಿ. Nine 8/2024. Actually not 9/8. It should have been 26/7. ಅದು ತಪ್ಪು ಮಾಡಿದ್ದೀರಾ.
ಅದೇ
26/7 ಗೆ there is an order which says the learned counsel for response number 7 and 10 submit that by virtue of the notification produced and marked as annexure R1 along with reply statement and the post of RFO in the state cadre, this tribunal has no jurisdiction to try the application. That is order dated 26/7. Not 9/8.
My lords, that may be passed in the Belgaum bench in those ಕೆಲವೊಂದು connected matters ಹಚ್ಚಿದೀವಿ ಸ್ವಾಮಿ. I will verify and correctly narrate it. But similar matters of seniority list of RFOs inter se were also pending before the Belgaum bench, my lords. Only pertaining to this bench were transferred to Bangalore bench. Principal bench of KSAT.
Tribunal has no jurisdiction to try the applications and learned senior counsel for the applicant submits. ಏನ್ರಿ ಕಂಪ್ಲೀಟ್ ಕಾಪಿನೂ ಇಲ್ವಲ್ರಿ ಇಲ್ಲಿ?
Complete copy is.
That Gulabi pen. For entertainment.
Tribunal to ಇಲ್ಲ ನೋಡಿಲ್ಲ ವಿಷಯ
Chairman.
to ಇಲ್ಲ ವಿಷಯನ ನೋಡಿ
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ.
ಟ್ರಿಬ್ಯುನಲ್ ಏನೋ ಹೇಳ್ಬೇಕು
ಅವ್ರು ಇನ್ನೂ ಬಂದೇ ಇಲ್ಲ.
ಆದ್ಮೇಲೆ ಆರ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
In process of the notification, my lord, tribunal has not taken any decision. In process of the notification, my lord,
So the
Tribunal
matter
has
is
not
still pending
taken-
consideration.
yes, sir, that has to be directed to the tribunal to consider to know whether it is a
Interim order ಕೊಟ್ಟಿದಾರಲ್ರಿ.
interim order is
And this
subject
issue has not been decided. Why did you file this
Interim
petition?
order vacate ಮಾಡಿ ಬೆಂಗಳೂರು ಬೆಂಚ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ ನಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ ಆಫ್ KSAT.
Where is that order?
stay extended till further order ಅಂತೀವಿ.
I will show my.
Last page number 73, my lord. You know of the submission interim order granted
Now
earlier
now ಇಲ್ಲ ಸ್ವಾಮಿ ನಾನು
is
ಹೇಳ್ತೀನಿ.
hereby extended till next.
I will narrate this.
ಅಲ್ಲಲ್ಲ.
Lords, now our application is pending before the principal bench, my lords.
Where is that order, sir?
Yes, my lords.
As per administrative order of honorable chairman. ಅದಾಯ್ತು. ಅದಾಯ್ತು, ಇಲ್ಲಿ ನೋಡಿ. This application is posted for further orders on 9/8/2024. 9/8 ಮಾಡಿದಾರಾ, ಆರ್ಡರ್ ಮಾಡಿದಾರಾ?
ಹೌದು ಸ್ವಾಮಿ.
Where is that, where is the copy?
One. I will furnish it, my lords. Kindly pass it over. Straight away, the bench here has transferred it to principal bench Bangalore, my lords. Same order sheet has been continued, my lords.
ಅವ್ರು ಮಿಕ್ಕಿದವರು ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ. ಸರ್ಡ್ R1 and R8 ಅಂತ ಬರ್ತಾ ಇದೆ ಸ್ವಾಮಿ. R1 ಅಂತೂ ವಕಾಲತ್
R1
ಹಾಕಿದೆ.
is KAT.
Yes, my lords. But still,
ಎಲ್ಲಿ ಬರ್ತಾ ಇದೆ?
ಹೈಕೋರ್ಟ್ ವೆಬ್ಸೈಟ್ ಅಲ್ಲೇ ಬರ್ತಾ ಇದೆ ಸ್ವಾಮಿ. ಕೇಸ್ ಸ್ಟೇಟಸ್ ಅಲ್ಲಿ ನಾವು ನೋಡ್ತೀವಲ್ಲ ಡೀಟೇಲ್ಸ್ ಅಲ್ಲಿ ವಕಾಲತ್
ಯಾರು
ಹಾಕಿದ್ದಾರೆ.
ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ?
ಅವ್ರ ಹೆಸರು ಬರಲ್ಲ ಸ್ವಾಮಿ. ವಕಾಲತ್ has been filed on 3 R8 and R1 on 9th October and 9th 10th October. Both
ನೀವು R1 ಅಂತ ಯಾರು ಮಾಡಿದ್ರೋ ಮೋಸ್ಟ್ಲಿ ಅವ್ರು ಇರ್ಬೇಕು.
maybe ಅವ್ರು.
KAT ಎಲ್ಲ.
ಇಲ್ಲ KAT ಅಲ್ಲ.
Anyway, you have not paid the process fee for service of notice on the other respondents?
No, lords. They are absent in the KSAT itself, madam. They remained ex parte before the KSAT.
ನಮಗೆ ಗೊತ್ತಿಲ್ಲ.
ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
You want to file a memo, you file a memo.
I will file a memo to that effect, madam.
Dispensation.
In dispensation of other, if not necessary, madam. Otherwise, I will pay.
Memo file ಮಾಡಿ.
ಮಾಡ್ತೀನಿ.
ಕೊಡ್ರಿ, ಪೇಪರ್ ಕೊಡ್ರಿ.
ಟೈಪ್ಡ್ ಕಾಪಿ ಮಾಡಿ ತಂದು ಕೊಡ್ತೀನಿ.
ತಂದು ಕೊಡಿ. Learned counsel for the petitioner has filed a memo seeking dispensation of notice to respondents number, all the private respondents.
Private respondents here.
At serial number 4 to
15.
15.
4 to 16.
16 months.
while contending that the relief sought in this writ petition is regarding the notification issued by the registrar of the Karnataka State Appellate Administrative Tribunal, and no relief is sought against the said respondents in this writ petition. So, next para, at the risk of the petitioners, notice to response number 4 to 16 is dispensed with. Huh? ಅಲ್ಲಿ issue emergent notice to respond number 1 returnable by 26th of November. Interim order.
Interim order needs to be extended till next
Notice.
31st August. Interim order granted as far as this matter was considered.
Interim order passed on
31st August.
31/8/2024
31/8.
stands extended in the next date of the
Hearing on serial number 18, government advocate.
These matters, my lord, represented by the, my lord, additional advocate general, my lord. He sought some time, my lord, in this matter. This is, my lord, behind 120 days, my lord, that delay is condoned. And thereafter, my lord, they made the application for recalling that order. So that application itself is not maintainable. Our, the additional advocate general, other day made the submission, my lord. But today, my lord, some is,
But it
lots
was
of
heard
priority,
for
my lord,
some
any
time.
another day, my lord, lots.
Last occasion, this matter was heard for some time.
Ah.
So clarified, an order that was against contrary to the law can be recalled by the honorable court at any point of time.
Hmm.
Yeah, the appeals were itself not maintainable. Hit by section 74, continuation of delay. They are filed beyond the period of 120 days.
Hmm.
So they were not maintainable. Unfortunately, they were all condoned.
that division bench at Dharwad has passed. on.
Dharwad has passed, there's no order.
Subsequently, that is subsequently, my lord. Previous this, my lord,
Ah.
the IA was allowed and condoned the delay of, my lord, that is behind 120 days. Thereafter, my lord, Dismissal court heard this matter at the Kalaburagi bench, my lord, principal bench, my lord. There is a direction to deposit the amount also. In view of that, my lord, deposited the amount also. Thereafter, my lord, they filed the application for recalling that order.
Yes.
Even otherwise, my lord, that delay regarding so far the delay in other appeals are concerned is kept open. That is matter subject to the, my lord, of the result of the Supreme Court.
They are making submissions on that, in that regard only.
But that is, my lord, even my lord, once, my lord, that application is allowed, my lord, condone the delay. But you lordship, my lord, defer this matter, my lord, till the decision outcome from the apex court.
Apex court.
Yes, my lord. Regarding the same issue, my lord,
Ah.
that matter is pending before the apex court. My
But
lord.
may I clarify?
Whether is a
May I
permissible
clarify,
to,
my lord, my lord, last occasion, the submission was that, my lord, we need not wait for the decision of the Honorable Supreme Court, my lord, on the count that the issue before the Supreme Court is something else. My lord, my submission, there is a detailed order in this case also, my lord. They were supposed to answer, my lord, what will happen to cases which are initiated under the new act, award is passed under the new act, appeal is under the new act. There is another scenario where, my lord, the
Correct.
initiation of acquisition was under the
Only
old
those
act.
matters.
Yes, my lord. The SV Global Mill case was a situation where, my lord, section 54's applicability may be, my lord, a question to be determined. It was a case of notification under the old act, award under the new act, appeal under the new act. They said that, my lord, section 54 may be applicable. Therefore, my lord, they sought leave to, my lord, file review. Review was rejected. That is, my lord, now in question. These are cases, my lord, where
All arise only
all,
out of the
yes,
new
my lord.
acts.
Entire proceedings, my lord, initiation is under the new act. So, my lord, the applicability of section 74 and, my lord, appeal after 120 days, my lord, is not maintainable. My lord, this was one proposition I laid, my lord. The other thing was that, my lord, I did not want to take, my lord, an order on, my lord, on technicality. I wanted, my lord, this court to test the case, my lord, on merits as well. My lord, my appeals are in time. Lordships may consider my case, my lord, for enhancement or otherwise, my lord. Then, my lord, pass an order, my lord. If your lordships, my lord, find, my lord, there is a case for reduction, then we may have to wait for, my lord, the judgment or, my lord, the judgment of the division bench, my lord, where it is made subject to. But the division bench judgment, my lord, in Dharwad may not resolve the issue, my lord, because what they have done is, my lord, they have dismissed the appeals subject to, my lord, the result of, my lord, the SLPs. So that way, my lord, it will be only a technical or, my lord, paper disposal. My lord, it will not.
But according to you, that issue
That is not
not
at all
pending before the
concerned to, my
Supreme
lord,
Court.
this set of cases. I'll point out from, my lord, the judgments, my lord, where it was remanded, what was the contentions taken there, and review, my lord, which was based on, my lord, the applicability of 54.
Yes.
The lordships can take, my lord, serial number 18.9 because certain synopsis and other things, my lord, are filed in.
The orders passed by the Supreme Court also is there.
Yes, my lord. The earlier orders, my lord, on global.
Global mill.
Yes, my lord.
With my lord's kind permission.
Ah,
Please, my lords, I appear for the appellant state in these matters. On the last occasion, my lords, my learned friend had fairly submitted that regardless on the issue with regard to delay, that the matter may be heard on merits, and in the eventuality of the state, if the court were to come to a conclusion that the state would succeed in the appeals, then the aspect of delay could be looked into. It is for that reason the matters were posted today. So my learned friend, my lords, had submitted that. And with regard to section 54, that submission was also made earlier when the earlier applications were being heard. We had submitted very clearly before the Honorable Court that the principles that evolved from that judgment and the ones that would apply to the section 74 and section 4 and the proviso are one and the same. My lords, it can be heard on merits, the matters. Because after the court has heard at length and allowed our application and allowed applications of the claimants, private litigants, even they have to be heard. It's not only the state which will be affected. There are many applications, many appeals where applications of land losers have been allowed. And they're also before this Honorable Court. Then they will also have to be heard in all fairness.
no. Land losers or claimants, their prayer is for enhancement of compensation.
And my appeals are in time. There is no issue of.
My learned friend, some of his appeals may be in time, but it is also a fact that there are many claimants who are represented by other lawyers. Their cases were time barred and their applications were also allowed by this Honorable Court. So they may also have to be heard because they will be adversely affected if that orders were to be recalled today. So it is for that reason, my lords, even we agreed that the matters could be heard on merits as on today. And my learned friend had fairly submitted on the last occasion that only in the eventuality.
There were provisions under the old act.
Yes.
Where if compensation is enhanced in respect of one claimant.
Yes.
The other claimants also, irrespective of whether they had filed appeal or not.
Yes.
They could seek the benefit of that judgment.
My lord, under section 28A of the old act, my lord.
Yes. Yes. Exactly. So they will have that benefit. Since there is a provision itself, even if they are not permitted to file an appeal, but there is a provision which would enable them to take advantage of the orders passed in favor of the other claimants. They cannot.
Take advantage of
Not all claimant would be, my lord. Not all claimant would be eligible for, my lord, decree on par. Only people who have missed, my lord, reference and, my lord, they can claim that to, my lord, subject to, my lord, the limitation and other aspects. Section 28A of the old act, my lord, the corresponding section will be 73 in the new act.
Where in an award under this part, the court allows
the applicant any amount of compensation in excess of the amount awarded by the collector under section 11. The persons interested in all the other lands covered by the same notification under section 4, subsection 1, and who are also aggrieved by the award of the collector may, notwithstanding that they had not made an application to the collector under section 18, by written application to the collector within 3 months from the date of the award of the court, require that the amount of compensation payable to them may be redetermined on the basis of the amount of compensation awarded by the court. Provided that in computing period of so and so.
What comes in their way?
Lord, one, my lord, will be,
Notwithstanding word in,
Notwithstanding.
in fact, what is this? What it means is that when an award is passed by the.
Even if they have not sought for reference.
Yes.
Houdu.
If they are not.
It doesn't mean that if they have sought for reference, they are not barodilla.
Those who are sought for that is again subject matter of interpretation.
Yengagutte, sir.
Ill word and is what.
No.
Notwithstanding, that is what my.
No. The meaning, the meaning is very clear. Even if they have not sought for reference,
You can still go.
they are entitled to have the benefit. If they have filed a reference,
That may be.
what will happen? Can there be a conflicting award regarding enhancement? Agadilla. So therefore, you cannot read it in any other manner. That benefit can be availed by every person who is interested. Is there any other judgment to the contrary?
but there are, my lord,
Yenanta?
but I am, my lord, my lord, of the view that your
Anyway,
lordship's
we are not
lordship's-
concerned with
yes,
that
my lord,
now.
your lordship's view is right, because,
Yeah.
my lord, a person who is, my lord, absolutely not vigilant gets, my lord, same award.
Correct.
Person who is vigilant and, my
How
lord,
can he be
slightly,
prevented?
my lord, and not so vigilant
Possible.
because his appeal was, my lord, not within 120
Maradilla.
days, he should not miss.
It takes care of both the situation.
That will be a question, my lord, to be answered, my lord,
Yes.
subsequently.
So the same provision is there in the new act also.
Yes,
So they can get the
Yes, but if
benefit
they
of
are
that
entitled, they will.
provision.
I'll first
So what do you
address-
want? Do you want the court to hear
Yes,
the
yes.
matter on merits?
Yes.
And only if the court comes to the, but we have to say something.
Yes.
Because question has been raised.
Yes.
Issue regarding maintainability of the appeal filed at the hands of the state is SLAO is raised.
Yes.
That it cannot be maintained.
Yes.
In view of the bar limitation prescribed. An appeal cannot be entertained after the appeal period. In terms of the provisions.
That's an
Therefore,
issue we have raised.
once you have raised an issue,
Yes, my lord.
that has to be determined.
Yes, my lord.
Court will get jurisdiction only
Yes,
after determination of this issue.
yes, my lord. Your
Insofar as the appeal filed by the state is concerned.
Is the appeals are in time.
Our sari,
It cannot be
gottaಯ್ತು.
taken up.
But now a submission is sought to be made.
That's what.
That is what we are also saying. It cannot be that we hear the matter on merits
Allah, sir.
without deciding that issue. And only if the court come to the conclusion that yes, there is some merit in their appeal, we then determine the question as to whether it can be entertained. Hangagadilla.
What,
We have to decide that question first.
yes, that could be decided. My lord, I am, my lord, my preliminary submission is their appeal will have to go on delay.
Therefore, we will decide.
My
it now.
second, yes, my lord, that could be decided. But, my lord, I put
We
across
can't
my.
hear the learned EAG on the merits of the matter and thereafter decide this question.
Yes, that.
Hangagadilla.
No.
Sir, you will have to make your submissions on the maintainability of your appeal. Mr. EAG,
Please, my lord, the dates may be fixed. my lord.
ಏನಪ್ಪ ನಾವು ಈಗ 2-3 ಸರಿ ಅದಕ್ಕೇನೆ ಅಡ್ಜನ್ ಮಾಡಿದೀವಿ.
My lords, my humble submission is, firstly, our case is, my lords, that the
ಇದ್ರಲ್ಲಿ ಏನ್
order
ಹೇಳಿದ್ದಾರೆ?
our
What has
application has been
been
allowed.
decided in this
Lord,
case?
they have dismissed, my lord, on the count of delay. The operative portion, my lord, is at page 20.
That judgment, my lords, has been obtained in the other circuit bench without bringing to the notice of that bench the orders passed with the honorable court in this bench, my lords. Because none of the judgments, the orders of this honorable court where allowing our applications are there, they were not placed before for the perusal of the honorable court in.
Allowing the application.
ನಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರದ್ದು ಅಲೋ ಮಾಡಿದ್ದಾರೆ ಕೆಲವು.
ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಇಲ್ಲಿ ನಮ್ಮ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋವ್ ಆಗಿದೆ ಅಂತ.
That is by consent.
Not by consent.
Not by consent.
Not by consent. No, by consent. Yes, ma'am.
By consent it is.
No, it is
That
not a
was a
consent.
stage when we were also, my lord, not aware that
Correct.
this cap of 60 days is there for condonation. When it was noticed that, my lord, it cannot be condoned beyond that period, my lord, we put across, my lord, the applications for, my lord, recalling that order since it's not in consonance with the position of law. That's not a, my lord, reasoned order where it is held that, my lord, even delay can be condemned beyond the appeal period and.
Taking into consideration all these.
No, that is not, that is not.
Supreme Court, Global Mills case,
Yes,
ಎಲ್ಲ consider ಮಾಡಿ ಮಾಡಿರೋದಲ್ಲ.
ಮಾಡಿರೋದಲ್ಲ. It's a simpliciter, my lord,
ಅದೇ.
condonation, 120 days.
So you have now filed an application to
For
recall that order.
recall.
That issue has to be decided.
Please, my lords, we have, on that also arguments were heard, my lords, we are ready to address the, on that issue, my lords, because the power of review, my lord, is limited, as my lords are aware. We will place our arguments, my lords, we will make our submissions. A date may be fixed, my lords, please. Because there is no mistake of fact or any such thing for review jurisdiction to be exercised in this particular case, my lords, at this stage, is our humble submission.
Which is that order, please show at least one order regarding that
First alilla, sir.
condonation of delay.
Yes.
ಇದ್ರಲ್ಲಿ ಇದೆಯಾ?
Lordship.
ಇದೇ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಇಲ್ಲ, ನನ್ನ matter, my matters, my lord, the delay was kept open. If your lordships can take note, 18.3. 18.55.
First matter ದಲ್ಲಿ ಇದೆ.
ಅಲ್ಲ 18.9 merit ಗೆ delay condonation.
18.55 ಹಿಡಿದು. That's where it was allowed.
Just kept it open ಅಷ್ಟೇ.
ಹೋಗಂಡದ, but mine was kept.
ಅವ್ರು ಹೇಳೋದು one matter it's allowed ಅಂತ. ಹೌದು.
18.55. 18.55.
Dated 23/1/2020, my lord. I am not sure whether it is recorded in the first.
23/1/2020.
ಅದೇ. There is no discussion.
There is no discussion.
Mr. Learned AAG. There is no discussion. Like any other application, it is just taken up and say delay is condoned.
It was heard at
There is
length,
no
my lords.
determination.
Unless they file it in their affidavit that there was no hearing on the subject and the court, honorable court was pleased to pass an order
Sir,
without
there
hearing
are-
parties.
The objection is having regard to the specific provision. And
Please,
that
please.
provision has not been discussed.
Please, my lord. Please, I bow to my lord. Whether that provision is directory or mandatory, my lord, has to be looked into. That was already done, my lords, and an order was passed by the honorable court, which the my respondent colleagues are very much aware of. On the issue of delay, it was heard more than 4 or 5 times by this honorable court. The issue of delay alone.
ಬೇರೆ ಕೇಸಲ್ಲಿ ಆಗಿದೆ ಸರ್.
18.30 ದಲ್ಲಿ
40 matters.
18.30 my lord, dated 23/1/2020.
ತೋರ್ಸ್ರಿ.
18.30.
ಇಬ್ಬರಿಗೂ ತೋರ್ಸ್ರಿ.
18.81.
If this is the type of order, then you are right that there was no no discussion having regard to the specific provision. Yes.
18.30 ತೆಗಿರಿ. 18.30. 30.
But our position is, my lord, either condone or not condone, my lord, let that matter reach, my lord, conclusion. Because, my lord, what is happening is, by the time, my lord, this determination, my lord, takes place and we get the amount, the prices are so high, my lord, we cannot replace the property we have lost. And, my lord, if the delays condonation, which is already, my lord, ordered, and our application for recalling is dismissed, my lord, the appeal becomes maintainable. Likewise, my lord, the cross objections also become maintainable. My lord, this, we are ready to take that order also. In the state is at risk, my lord, if our cross objections are allowed, and we are at risk if their appeals are allowed. Let that not be, my lord, kept pending. That's, my lord, our request.
Dated 23/1/20. Same order. no? Same.
So all orders have been passed in the normal course,
Yes, yes.
as if it is a regular application for condonation of delay. There is a provision which enables consideration of such application. No other discussion.
And in particular.
So that is why they have filed that application to recall that order. Anyway, you are entitled to make whatever submissions you want.
Please.
You can make.
What else?
ಬರ್ಕೊಳ್ಳಿ.
ತಗೊಳ್ಳಿ.
Having regard to ಅದ್ಯಾವ್ದು provision ಕೊಟ್ರಿ? ನೀವೇ
Section 74.
Proviso to checks. section 70.
See, but similar provisions are there, is even in respect of the
Arbitration Act.
condonation of delay in the CPC for filing a return statement. Yes. Similar provision. Yes. Two periods are fixed.
Yes.
And what is the interpretation placed by the Supreme Court on the in that provision?
It's a different interpretation, my lord. But my lord, the issue, the subject,
So same thing will have to be
the criteria under my
yes.
lord, filing of WS or filing of appeals are different, my lord. Because filings of appeal are a statutory, my lord, a benefit given to the person who has suffered an order. It's not, my lord, on a general principle. It's a privilege that is given to the person, my lord, who suffers the order. And he must exercise that within, my lord, the stipulate, because these kind of provisions are also there in the Arbitration Act. There, my lord, the delay is much lesser than the condonation provision is much lesser than that. There also, my lord, they have taken a very strict view, section 37 of Arbitration Act. And my lord, they are all relied, my lord, this.
Anyway, we'll consider.
Same is also under commercial tax.
But it's a harsh provision, my lord, for the claimant and also, my lord, state. It's very difficult for the state, my lord. They may have to do that, my lord, because in this very set of matters, the earlier AG, my lord, made a submission that, my lord, though it is not put on record, that they were considering an amendment. That is done, my lord, that would resolve the issues. But anyhow, this is the position of law as on today, my lord, we'll have to go by this.
In fact, my lords, in addition to what my learned friend has stated, my lords, there have been requests from farmers, my lords, many farmers who lost lands, to have that particular provision amended so that it would avail, it would give them an opportunity to knock the door. of this one.
Courts can consider the issue based on the provision.
Please.
Whether
As on today, my
you
lord,
as a government want to make any amendment, it is left to you. You do whatever you want. If it is
Yes.
permissible in law, you do it.
Yes.
But court is required to determine it only in terms of the available provision.
Please.
Cannot go beyond the scope of.
Having regard to the express provision contained in section 74 of the Land Acquisition, Rehabilitation and Resettlement Act, 2013, whereby appeal is permitted on an award passed by an authority under section 69 within 60 days from the date of award, and a further period of 60 days totaling to 120 days. And beyond the said period, an appeal cannot be filed. Issue has been raised at the hands of the appellants, claimants, in respect of the appeals filed by the SLAO and the state beyond the period of 120 days. Full stop. However, learned AAG submits that this court has already considered applications for condonation of delay and has passed orders in few of the appeals herein, condoning the delay. We stop. To that, learned counsels for the claimants would submit that they have filed applications to recall all such orders. Stop. Next para. This court is therefore required to consider the said issue before going into the merits of the matter. Full stop. Next para. Release this matter on, when do you want?
Lords,
19.
no, my lords, I would request my lords to kindly have it in first week of December, my lords.
Huh?
First week
Eh,
of.
ಅಷ್ಟೊಂದೆಲ್ಲ
Allala, there are other matters, we will prepare a list. See, my learned friend is aware of the list of cases that he is appearing in.
That's all right. You are only deciding the question. ಯಾವ್ಯಾವ್ದಕ್ಕೆ ಅಪ್ಲೈ ಮಾಡ್ಬೇಕು ಅದನ್ನ ಆಮೇಲೆ ಅಪ್ಲೈ ಮಾಡ್ಕೊಳ್ಳೋಣ.
Allah Swami, land losers, private land losers, they have also secured an order.
Same
beneficial
thing would
order.
apply.
They,
ಬರ್ಕೊಳ್ಳಿ ಇನ್ನೊಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಸೇರ್ಕೊಳ್ಳಿ.
ಅದನ್ನು matters connect ಮಾಡಿಸ್ಬಿಟ್ರೆ ಅವ್ರನ್ನು hear ಮಾಡ್ಬೋದು.
Next para. At this juncture, learned AG would submit that there are certain appeals filed by the claimants also beyond the prescribed period of 120 days. ಅಲ್ಲೂ ಇದೇ ತರ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದಾರಾ?
Please.
ಇಲ್ಲ.
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಮಾಡಿಲ್ದಿದ್ರು they have a right to be heard, my lords, because it's on the same issue.
ಆಗಿದೆ ಗವರ್ಮೆಂಟ್ ಆಗಿದೆ, ಅವ್ರದ್ದು ಕೂಡ ಆಗಿದೆ.
My learned friend Harshvardhan may be aware, my lords. He was appearing in some of the.
In few of those cases, such applications for condonation of delay have also been allowed. Full stop. Next para. Our date admele office is directed to list out those appeals filed by the claimants.
My lord, my request would be, my lord, we will be going, my lord, nowhere, my lord, because now, my lord, 500-600 matters are pending, which are of different context. These cannot be found out, and my lord, we'll go on with this, my lord. Let this issue be answered, my lord, and it can be, my lord, applicable for cases which are. It will be a very vague order. In the sense, my lord, we don't know what are the, my lord, matters. Avrige gurtirutte. Namdu, we are, my lord, different people.
It's only a limitation, my lords, which my lords will be hearing.
That's a different aspect. Delay condonation in cross objection is.
ಹಂಗಾದ್ರೆ ಬೇಡ ತೆಗ್ದ್ಬಿಡ್ರಿ
Hearing ಮಾಡಿ.
ಒಂದು ಸೀರೀಸ್ ಲಿಸ್ಟ್ ಆಗಿದೆ.
So we will have it on
19th.
21st.
No, my lords.
21st of November we have.
First week of December, so that at least we'll collate. If they cannot, at least we'll collate all the cases. We'll place it before my lords.
ಬೇಡ. We are not considering them now.
Allala, on delay itself. On delay itself.
You please answer the issue raised in your appeals.
Please, then it may be taken up on
Please answer that one. We'll see.
27th or 28th. my
The
lords.
others we will see later.
27th or 28th, I may request my lords. 27th or 28th, my lords, so it will give us some
ಅಷ್ಟೊಂದು
time.
ಟೈಮ್ ಏನಕ್ಕೆ ಬೇಕು?
Allah, this is so that we could. I will.
The issue
require
lies in a
instructions
narrow
also.
compass.
Please, my lords, it could be disposed of on Monday itself. It could be taken up on 28th. Please.
Released these matters on 25th of November.
Please, oblige.
26th. 27th. ಆಯ್ತು 27th.
Please.
No further adjournments will be granted. Yes.
Much obliged.
Number 19, AGA.
But I am appearing for this.
Section 74.
Illilla. My lord, this is, my lord.
19.
Serial number 19, additional government advocate.
Your lordships, the learned AG is going to argue in this matter, your lordships. Advocate General, because with regard to stay, on the last date of hearing, I think the government advocate had passed on the order filed by the division bench, Dharwad bench, with regard to depositing of 25% of the enhanced compensation in cases where possession is taken and 10% of the enhanced compensation in cases where possession is not taken. Because this matter was argued by learned AG before the Dharwad bench, and I have requested him to argue this matter before this court also, your lordships. The same is applicable to these matters.
Same
also.
issue.
Same issue.
No, my lord, slightly different issue, my lord. In the sense, my lord, all other cases, my lord, where there was delay or my lord otherwise, condonable delay or my lord non-condonable delay, the lordships were pleased to my lord award a consistent award of my lord stay subject to deposit of 50%, and my lord that was permitted to be released. There is one order in my lord Dharwad bench pertaining to a matter of Mudol, where my lord they modified that and my lord reduced that from 50% to 25%. Now they are insisting, now they are insisting that all cases 25% to be made.
Yes.
ಆ ಕೇಸಲ್ಲಿ 5,700 ರೂಪಾಯಿ ಪರ್ ಸ್ಕ್ವೇರ್ ಮೀಟರ್
yes.
ಅವಾರ್ಡ್ ಆಗಿರೋದು, ನಮ್ ಕೇಸಲ್ಲಿ 7.5 ಲಕ್ಷ ಪರ್ ಎಕರ್. That will be hardly about 17 rupees.
What we were saying, that cannot be taken as a benchmark.
That cannot.
That's the reason, Your Lordships, I've requested Advocate General, I think he's held up in court hall number 1, kindly be passed over.
230.
Kindly be passed over. He's held up in court hall number 1, Your Lordships, just a short talk.
Advocate General.
Advocate
Which he
General,
appeared.
because he has only argued this matter before the Dharwad bench.
You want
I
to
seek
pass
for
over?
us, pass over, pass over. Okay.
Lordship, I have 230, my lord. Another matter is there, my lord. You will have 230.
ಅಲ್ರಿ ಅವ್ರೇನ ಇವಾಗ ಫ್ರೀ ಆಗಿದ್ರೆ ಬರಂಗಿದ್ರೆ ಬಂದ್ಬಿಡ್ಲಿ.
So he's in court, yeah, if he comes back, yes, once it's completed, it's,
Huh?
yes,
I'm ready.
the moment he comes, I'll inform you.
19 and 20 na?
19 to 21, 24, 26 and 27.
27.
Lord, 20, there is no stay order, my lord. Jeez. I have to file the IFR stay, my lord. 20, this may be taken next week, my lord. Serial number 20. There is no stay order, my lord. There is no IFR stay, my lord. Serial number 20. That may be taken next week, my lord. So I'll file the application for stay, my lord.
Serial number 20, at the request of learned government advocate, release this matter
Next week.
on 19th of November.
Please.
So 19,
21,
21, 24,
24, 26 and 27.
26, 27.
27.
Pass over. Yes.
Please.
Serial number 22, Shivashankar H. Manu.
As per the interim order, my lord, government advocate has to
Yes, my lord.
record instructions regarding.
Today, my lord, I requested them to come,
Instead
my
of
lord, today in the
SC, my
after
lord,
session, my lord.
GM post was fulfilled, my lord, for Anganwadi post, transferred to some other place. And again, they vacated the place and called for SC post, my lord.
Yes, my lord, I am getting the instruction, my lord. They are coming, my lord.
Last date
Lordship, I have
also, my
tomorrow, my
lord,
lord, I will make the
the
submission.
last date also, they have
Why,
short time. my lord.
they
This is-
started, my lord, they're not reached.
They're getting it today.
Tomorrow, your lordship, I will,
Release this matter tomorrow.
please,
Yes,
My lord, maybe day after tomorrow.
day after tomorrow,
please.
Thursday. Release this matter on 14th of November.
Please.
Please.
Serial number 23, Manvendra Reddy.
Here for the complaint, my lords, the order of the learned single judge is at page number 11, my lords, wherein my representation was to be directed to be considered, my lords, by the authorities. Respond number 3, my lords. I see. But annexure B, my lords, the order was passed on 15th March 2023, my lords. Thereby, my lords, by annexure B, I have given a representation submitting the certified copy of the order. Thereafter, my lords, by annexure C, my lords, they had sought for the representation by annexure F and F1 of the writ petitions to be submitted before the authorities, my lords. On page number 17, my lords, I had annexure D. I have submitted those representations. I seek dispensation of notice to the respondent number 1 and 2, my lords, because the direction was only in respect of respondent number 3, my lords. Due to, I'll submit a memo to that effect, my lords.
SLAO.
Yes, my lords.
And what were you asking in your representation?
My representation was, my lords, earlier, my lords, the KIDB officials, my lord, had acquired the extent of 4 acres, 20 guntas of the land of the complainant, my lords. Thereby, my
Annexure
lords.
D, na?
Yes, my lords.
Annexure D.
Yes.
That is your representation.
No, my lords. Annexure, the representation is not part of the petition, my lords.
Ah.
The representation is before this. May I submit, my lords? There's only one copy, my lords. I have.
Don't.
The excess of 20 guntas, my lords, which was of the land of the complainant, my lords, which was utilized, my lords, but the compensation is not being paid. This is my representation, my lords. 4 acre 20 guntas have been acquired, my lords, and for which compensation has been received by the complainant. Only to the extent of 20 guntas, which was excess, which was utilized by the authorities, my lords, but the compensation is not paid. At para 2(3) of the paragraph of the petition, my lords, I have detailedly mentioned regarding the aspect of which has been mentioned in the representation.
Here consent award.
Like consent award to the extent of 4 acres, 20 guntas.
Extent of land acquired without notifying, without acquiring, 20 guntas excess land is utilized anta. Please tell us,
Please, my lords.
what is it that the SLA can do in this matter? Having regard to your prayer,
Please, my lords.
20 guntas excess utilize ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಅಂದ್ಬಿಟ್ಟು.
Yes, my lords.
Now you are seeking directions only to the SLAO.
Yes,
What can the SLAO do?
because SLA would be the appropriate person, my lords, to at least pass an order.
How? How will he get the power to pass an award? That is why we say
Please, my lords.
we should never issue this kind of mandamus without looking into your representation. We'll have to consider whether such a direction can be issued to the officer.
Please, my lords.
ಇವಾಗ ನೋಡಿ ಏನಾಗಿದೆ. ನೀವು you got an order at the hands of the learned single judge.
Yes, my lords.
At direction to the SLAO. What can the SLAO do? Does he have the power to pass an award now? Who is the competent authority?
It's competent authority, Murthy, my
It
lords.
is the government only.
Yes, my lords.
SLAO has no power. He can only determine award in respect of the land that is notified and acquired. Does he have the power to do anything beyond that one?
No, my lords.
ನೀವು ಈ ತರದ ಒಂದು ಡೈರೆಕ್ಷನ್ ತಗೊಂಡಿದ್ದೀರಾ ಈಗ? What is the use? ಅದು ತಗೊಂಡಿದ್ರು ಕೂಡ no, he cannot do it.
Because
Correct, unauthorized ಆದ್ರೆ the direction is that they have to determine compensation and give compensation.
no, my lord.
What can the SLAO do? ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
Yes.
Huh.
It is duty of the SLA to consider adjournment also.
Because
It
at least
be- beyond what is required, if the land has been utilized,
Suppose.
how can he pass?
There any regarding measurement.
That is only the regarding measurement. ನೀವು ಆಕ್ಚುಲಿ ಏನು ಇದು ಮೆಜರ್ಮೆಂಟ್ ಪ್ರಕಾರ ನೀವು ಮಾಡಿದ್ರಿ, ನೋಟಿಫೈ ಮಾಡಿದ್ರಿ, there is some minor discrepancies that can be corrected ಅಷ್ಟೇ.
At the most.
Having regard to your contention
Please.
that 20 guntas of land have been utilized in excess of what was notified.
Yes. Lords, my
What
submission,
can the SLAO do?
at least the SLO could notify as to whether the property has been
It is
utilized or
not
not.
for him to notify, sir. It is the government only.
Lords, because because the SLO can direct the authorities to whether to survey the land and to at least notify whether the 20 guntas have been utilized or not.
He does not have the power to direct the government, sir, to notify. It is the government alone that can notify.
For at least for
Therefore, you should have asked for directions to the government,
please,
not to the SLAO.
regarding the determination as to whether the excess land has been utilized, my lords.
Bari ಅಷ್ಟು ಮಾತ್ರ ಆದ್ರೆ,
Yes, my lord.
is that the representation that you have given?
Lords, I have asked for determination as well as
Therefore,
both.
Who is
both,
the
my lords.
competent authority?
Government.
Government only. So you should be careful, sir, in giving the representation and coming before this court,
Please.
seeking for a direction. Entire exercise will be waste now. You will be simply whiling away your time here. That is why I have always been telling the learned councils,
Please, my lords.
I am not going to issue mandamuses like this. Just because you say I have given a representation, consider. I am not going to do that. Unless I am satisfied
Please.
that there is a duty cast on that officer to do that. It is a wasteful exercise now.
Lords, at the most, my lords, let the SLO to determine as to whether the extent of utilized or not.
ಮಾಡಿ ಏನ್
Because
ಮಾಡ್ತಾರೆ?
lords, thereafter, the
So
order
you
may be,
have to give a representation once again,
please, my lords.
only to the competent authority.
Yes, my lord. If
That is the government.
now, once it has been determined to the extent of 20 guntas has been utilized, my lord, thereafter, my lords, I can,
ಸರಿ, ಇವಾಗ ನೀವು representation ಏನ್ ಕೇಳಿದೀರಾ?
I have sought,
And direction is that you have to consider your representation.
yes, my lords.
Consider ಮಾಡಿ ಏನ್ ಮಾಡ್ಬೇಕು?
Because the other aspect, my
And you
lords,
are now saying contempt.
my lords, other aspect, my lords.
A contempt petition has been filed now, isn't it?
Yes, my lords. The other aspect, my lords, when I have moved an application for survey, my lords, the department now says that, my lords, the entire extent is utilized by the KIDB, my lords, the survey cannot be done. And how to gather the information regarding 20 guntas, which was been not notified for the acquisition, my lords, is there is no way for that. That is why, my lords, the representation was given to the
The court
SLO.
has no power to direct the state government.
That can be done, my lords.
Then you would have directed the state government
Please,
that this is the allegation.
please.
Please find out whether you utilized 20 guntas of his land without notification. And if that is so, after arriving at a conclusion, yes, your lands have been utilized,
Please.
then state government is the appropriate authority. It will take steps to notify. Alva,
Please, my lords.
what do you want now?
With that liberty, my lords, may be disposed of.
Berkeley. On going through the orders passed by the learned single judge, we find that the complainants herein had filed the writ petition seeking a writ of mandamus directing respondent number 3, namely the special land acquisition officer, KADB, to consider the representations given by the petitioners on 22/8/2022. Full stop. Accordingly, the learned single judge directed by order dated 15th of March 2023 that the third respondent shall consider the representation in accordance with law within 8 weeks from the date of receipt of a certified copy of the order. Next para. We find that in the representations given by the complainants herein, they allege that the respondents have utilized lands in excess of what was notified. And therefore, they are seeking determination of compensation and payment of same to the complainants. Full stop. We have pointed out to the learned counsel that even if it is found that excess lands have been utilized beyond what was notified, then it is only the state government which has got the power to notify the excess lands for acquisition, and thereafter the SLAO will get the authority to determine compensation. Full stop. However, the representations have been given to the SLAO, who has no power or authority to notify the excess lands which are alleged to have been utilized beyond what was notified. Full stop. Next para. At this juncture, learned counsel for the complainants seeks leave of this court to withdraw the complaint and give fresh representations to the state government and the SLAO for redressal of their grievance. Full stop. Next para. Accordingly, the contempt petition stands dismissed as withdrawn. Full stop. Liberty is also reserved to the complainants to give a representation to the state government and the competent authority for notifying the excess lands belonging to the petitioners, which are alleged to have been utilized, along with the other lands belonging to the petitioners. Full stop. Ordered accordingly, please.
Obliged.
Serial number 25, J. Augustine.
It opposite.
My lord, I appear in serial number 25, please. Am I audible?
Yes.
Please. My lord, this is a case relating to grant in aid post, my lords, in a law college, my lords, SCAB Law College, which is in Raichur, my lords. Very briefly, if I may mention the important dates, my lords, very briefly. What has happened is the writ petitioner was excluded by the government and college for the grant in aid post. This was in 2015 order. It was filed in writ petition in 2016. After 8 years, my lords, in this year, the learned single judge has said that the writ petitioner is entitled to hold the grant in aid post, whereas me, the appellant, my lords, who was respondent number 6 in that writ petition, has been held to be disqualified from holding the grant in aid post. So the issue pertains in that narrow compass, my lords, of grant in aid post. Just a few dates, if I may mention, my lords. My lord, I, the appellant, completed my LLM, my lords, in 1998. And in 1999, having completed LLM, which was a prerequisite for a full-time faculty post as a lawyer, as a law professor, law lecturer, I joined the subject college, my lords, as a full-time lecturer in 1999. My lords, in 1999 itself, the government of Karnataka had formed a committee for identifying grant in aid colleges. Now, this college, my lords, SCAB Law College in Raichur, was also one of the 24 colleges. And I was also one of the persons identified for the grant in aid post in 1999. Unfortunately, my lords, in 2000, for reasons best known to the government, that grant in aid order omnibus for all colleges were withdrawn. It was finally, it didn't go through, my lords. Despite the order, that order was withdrawn. My my lords, the respondent number 6 for the writ petitioner, she completes her degree, though she is older than me, she completes her degree later and joins in 2002, that is 3 years after me, as a part-time lecturer in the college because she does not hold LLM. 2002, she joins as a part-time lecturer without LLM.
The learned single judge has accepted the contention
Please.
that as on the date when the post was admitted to grant, that is 28/11/2012,
Please.
you are not working in this college.
My lords,
You are working in another college in Davangere.
My lords, what happened is
Bagalkot. That is the finding.
Bagalkot, two different places, Bagalkot and Davangere also two places I had worked.
Yes.
Either the issue, my lords, would your lordships kindly come to the government's report at page, my lords, page 180 may be taken, my lords, 180. Is I'm sorry, my lords. Verification report is annexure F, which is at I wrongly noted the number. Kindly bear with me a minute. My lords, may kindly come to page 58, which is part of the records. 58. My lords, the grant in aid order which was passed originally was an in principle approval of the college. Thereafter, it was subject to conditions. Condition 1 was that verification report has to be prepared by the committee of the government to see the suitability of the candidates for awarding grant in aid to the posts. Now, this is that Parishilana Varadi. I'll only point to page number 62. Kindly come to 62 in that. Your lordships would find at serial 4, Srimati Pushpalata G. Kanunu Upanyasakar. That is my opponent, my lords, or rather the writ petitioner. Her service starts from 2006 and she is noted there, her service as 2006. Kindly come to the bottom of the page, plots. This is serial number 6, Vasundhara P. My service is taken, my seniority is taken from 1999. Even though I had gone and served in other colleges, my continuity of service has been recognized by the government. Because my husband, my lords, there has been never any discontinuity in my service.
No, it says 1999 Purvan ha.
Please.
Rinda 31/8/2004. It ended there.
Maruhajara. Yes.
Yes.
But my seniority is reckoned from 99 only, my lords, because there is no discontinuity in service.
No, where is the question of seniority, sir? We are on the question of admission to grant in aid.
My lords, as on
the date when the post was admitted to grant in aid,
please,
you are not working in that institution.
My lords, what happens is the grant in aid is to the institution first, subject to conditions that when the verification is prepared, I am already there, my lords. They
have very clearly taken note of the fact that from 1999 to 31/8/2004, you have worked in that college.
Yes, then again I come back, my lords.
Thereafter, you came back again on 1/12/2012.
Please. Please, I come back and from, please.
Yes.
Avatinda from 2012 till today, I am in that same post, plots. There has been no discontinuity of service.
2012
How? ಏನಾಗುತ್ತೆ ಸ್ವಾಮಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ my husband is a government servant. So when he's transferred, I take permission and I join another college. But when I come back to this college, Raichur College, that college recognizes my seniority and continuity of service.
Where is the question of recognizing your seniority, sir? It's a private institution, isn't it?
Please, my lord.
It's a private institution.
No, even if it is a private institution, the continuity of service has not ended, my lords. In fact, what has happened?
How can it be?
My lords, that is the order passed, my lords. My lords, that is the reason why my date is taken as 1999. Otherwise, my lord.
We can understand if the very same institution has got branches elsewhere.
Please.
In some other district.
Yes.
And with permission, you go and work in that other branch of the same institution.
Yes, my lord.
At least in those circumstances, we can say, yes, you have been recognized as continuing service.
Yes, my lord.
In that institution. Otherwise, where is the question of your continuing in service and your seniority should be counted?
True. The same issue, my lords, arises even in a case where that private college recognizes the service put in other colleges also and for the continuity of service. There is no
service. It is
Andre,
not for the purpose of continuity of service.
For
you
seniority.
can take it for the purpose of considering for how many years experience you have got.
Seniority, my lords. My lords, ಇನ್ನೊಂದು issue ಇದೆ. ಒಂದೇ ಒಂದು issue ಇದೆ. ಅಲ್ಲ, even, my lords, two things happen. The date of award of in principle approval of
what was the grievance raised in the writ petition?
My lords,
by the sixth,
in fact, there is
the sixth respondent.
My lords, one issue may I just mention, my lords. In fact, this issue can be resolved on a simple point, my lords. Totally may I just point out what happens. The lordship may kindly come to the impugned order, which is
no. What was the grievance of the writ petitioner?
The writ petitioner's grievance was she was excluded totally. Our post ittu for granting aid. She was excluded from the 6 numbers, saying that this has been reserved only for ST. It cannot be given to you. That is what ST ge reserve agide nimage kodakagalla anta it was said. Against that, she comes to the learned single judge, files the writ petition in 2016. After she files the writ petition, she quits her job, and from 2016 she has not been in service at all, not a teacher at all. What happens is, in that one of the persons who, one Mr. Gopinath, would your lordships kindly come to that impugned order itself. He is himself no longer, he quit because he was disqualified. The lordship may kindly come to Sarkarada Adesha is at page 74 months. It starts at 72. This is the impugned order before the writ petition court. Your lordship would see the relevant page is the relevant page is at 75 months, 74 and 75. Would your lordship see in that list prepared by the government, the principal of the college, Padma, is serial 1. I am number 2. My sevege serida dinanka is reckoned from 1/9/1999. Kindly come to 75 months. At serial 5 is one Mr. Gopinath. Would your lordships find it, madam?
The institution remained absent, absent, is it?
Yes, my lords, what happened is if the institution had clarified that there is availability of another vacancy, this issue would not have arisen. We do not want Pushpalata, the writ petitioner, to go away
Allah,
either.
adonde Allah, you are saying
Please,
after filing the writ petition, she is not worked in the college.
not at all. From March 2016 till today, for 8 years, she does not work.
All those aspects have not been taken into consideration.
Yes, my lords, because the institution has gone unrepresented. Therefore, what I do is I make representation and file additional documents here, my lords. Kindly come to page. ಇದೊಂದು ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ for your lordship's earlier query, page 75.
Perfect.
Please.
Learned government advocate takes notice for respond number 1.
1, 3, 4.
Huh?
1, 3 and
1,
4.
3
4.
and 4.
Second respondent ಏನ್ ಬೇಕಾಗಿಲ್ಲ.
Issue notice to respond number 2, 5 and 6. The appellant is also permitted to serve copy of the appeal memo on learned counsel Shri Chaitanya Kumar Chandriki, who appeared for respond number 6, writ petitioner. Please. Full stop. And a copy on the learned government advocate. Full stop. Next para.
Respond number 2, my lord, penal advocate are there, my lord.
Huh?
Before the learning singer's judgment, we taken the notice, wrongly we
There,
taken.
or
Penal advocates are there, man.
notice
You
has
may be
been given.
permitted to take out penal
ಯಾರಿದ್ದಾರೆ?
advocates.
Law University. ಅಲ್ಲಿ respond number 2 ಗೆ learned counsel Shri Amaresh's Roja is requested to take notice for respond number 2, Karnataka State Law University.
Please.
A copy to be served. Huh? Next para. Learned counsel for the appellant submits that unfortunately there was no representation to representation for respond number 5 institution, where the appellant herein and respond number 6 were working. Full stop. Certain important aspects of the matter, namely that after filing the writ petition, the writ petitioner discontinued her services with the 5th respondent institutions.
Yes, ma'am.
And therefore, the learned single judge could not have issued such directions to quash the
Grant-in-aid post.
grant-in-aid post or admission of the appellant herein
Yes, to
to
grant.
the salary grant.
Please.
By further directing that the writ petitioner should be admitted to the salary grant.
Yes.
Full stop. When admittedly, the writ petitioner was not working in the institution from the year 2016,
Yes,
question of issuing such direction to admit the writ petitioner to the grant-in-aid post along with the salary grant would not have been hold on, full stop. On the other hand, the appellant herein has been working in the institution
One nine nineteen 99.
continuously
Yes, ma'am.
from 1/1/2012.
Well, please.
1/1/2012 till date. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order in writ petition number 2000474 of 2016 till the next date of it.
So grateful.
Okay.
Serial number 28, Muhammad Abdul Qayyum.
Your Lordship, this is an appeal by insurance company, questions company appeal. I am filing memo to dispense notice to R4, R5. Stay may kindly, delay of 17 days.
Delay of 17 days in filing the appeal is condoned. Stop. IA number 1 of 2024 is accordingly disposed of. Full stop. Next para. Issue notice to respond number
1. 2 and 3 are minors.
1, 2, and 3. 1 to 3. Full stop. Learned counsel for the appellant has filed a memo seeking dispensation of notice to response number
4 and 5.
4 and 5 on the ground that respond number 4 is the driver and respond number 5 is the owner of the vehicle, and the appellant insurance company is not disputing its liability insofar as the currency of the insurance at the time of accident. Full stop. Next para. There shall be an ad interim order of stay of the impugned judgment and award in MBC 289 of 2023 on the file of the second additional senior civil judge and JMFC, Raichur and MACT Raichur till the next date of hearing, subject to the appellant depositing 50% of the award amount before the tribunal within a period of 6 weeks from today.
Serial number 29, Amit Markam.
Claimant's appeal for enhancement, my lord. There is delay of 221 days.
Royal Sundaram.
Shri Sudarshan, sir.
ಇವರು ಸಂಜಯ್ ಎಂ ಜೋಶಿ ಬರ್ತಾ ಇಲ್ವಾ? ಬರ್ತಾರೆ. Senate Counsel Sanjay M. Joshi is requested to take notice for
Respond number
2.
Notice with regard to R1 may be kindly dispensed, my lord. He is the owner.
Counsel for the appellant has filed a memo seeking dispensation of notice to respond number 1 on the ground that respond number 1 is the
Owner of the vehicle, please.
and the liability has been passed on respond number 2 insurance company.
Please.
Stop. At the risk of the appellant, notice to respond number 1 is dispensed. Yes.
Seal number 30,
Learned counsel is requested to serve copy of the appeal memo along with annexures on learned counsel for respond number 2.
seal number 30, Puneet Markar.
Same, my lord.
Same. Royal Insurance, na? Please. Same matter,
No, my lord. It is different matter, my lord, but party, the insurance company is same, my lord.
ಹಂಗಾದ್ರೆ ಅಲ್ಲಿ ಇವ್ರಿಗೆ ಹಾಕಿ ಎಂ ಸುದರ್ಶನ್ ಹಾಕಿ
Please.
Seal number, engineering matter, seal number 31, Avinash Uplankar.
Both matter may kindly refer to the local, my lord.
20 ಮತ್ತೆ
And 29,
29, 30. both
please, my lord.
matter stands referred to ಲೋಕದಲ್ಲಿ.
Please.
Oh, 221 days, 200 days.
221 days and 200 days. is
ಆದ್ರೆ,
there, my lord.
delay of 221 days in filing the appeal stands condoned, subject to condition that the appellants shall not be entitled for payment of interest during the delayed period.
Please.
IN number 1 of 2024 is accordingly disposed of. ಎರಡರಲ್ಲೂ same, ಅದು 200.
Seal number 31, Avinash Uplankar.
My lord, these petitioners are now working as the deputy superintendent of police, wherein the promotion which they requested before the Karnataka Administrative Tribunal, which was not considered. Serial number 31.
31, contempt.
Contempt.
Ah,
My lordship, the order of this honorable court starts from page number 12.
to consider the recommendations of the subcommittee stated so and so in respect of giving notional seniority
Yes, ma'am.
as expeditiously as possible, not later than 6 months.
I have given the representation as per Annexure B to the both the parties, Additional Chief Secretary as well as the Director General of Police on 3/4/2024.
Issue notice to response number 1 and 2, returnable by 26th of November. Learned government advocate takes notice for respond number 3. Learned counsel for the complainant is directed to serve copies of the petition along with annexures on learned government advocate.
Number 32, Uleppa Error.
Not, I am for the petitioner. The petitioner has been suspended thrice. Now the third order is under challenge before my lords. Not annexure A1, page number 35.
Are you asking for any interim prayer?
Yes, my lord.
ಏನು?
Interim prayer, not A1, I have been suspended. A2, KT has stayed.
Stay the operation of the order of the tribunal.
Yes. Yes, ma'am.
ಆದ್ರೆ
Latest, my lord, present order which is challenged.
ಅದೇ, that is the order of the tribunal.
Yes, yes, my lord.
ಅದು ಸ್ಟೇ ಆದ್ರೆ ಏನಾಗುತ್ತೆ ಬೆನಿಫಿಟ್?
ಬೆನಿಫಿಟ್ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
ಹಾ.
ನನಗೆ 3 ಸಲ ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದಾರೆ, 3 ಸಲ ರದ್ದಾಗಿವೆ.
ಹಾ.
Very same charge, very same orders that are now based on that I am suspended. If my lord permits, I will bring out, point out.
ಆರ್ಡರ್ ಆಫ್ ದಿ ಟ್ರೈಬ್ಯುನಲ್ ಸ್ಟೇ ಆದ್ರೆ ಏನ್ ಪ್ರಯೋಜನ ಅಂತ ಕೇಳ್ತಾ ಇರೋದು.
ಸ್ಟೇ ಆಗಿದೆ, ಆಲ್ರೆಡಿ ಸ್ಟೇ ನಲ್ಲಿ ಇದ್ದಿದ್ದೀನಿ ನಾನು ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ ಮೇಲೆ, ಮತ್ತೆ ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಇಸ್ ವಾಟ್ ಮೈ ಲಾರ್ಡ್. ಐ ರಿಕ್ವೆಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ ಟು ಪೆರ್ಯೂಸ್.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್.
Yes, my lord. Annexure A13 ಮೇಲೆ kindly. Annexure A13, page 116.
Page number 128.
Yes, my lord. 120 is now under challenge before my lords.
28.
Yes. There is already status quo by the Honorable Principal Bench, Bangalore. Despite of that, I am again suspended. That is what my lords have pointed out last time. Why I have gone to Principal Bench, Principal KT Bench as well as High Court. I have been shifted to Mangalore. Mangalore jurisdiction comes to Bangalore KT. Thereafter, I went to Bangalore Bench, High Court. That is what my lord's question I could not answer last time.
My lien is shifted to Mangalore after suspension. I reported at Mangalore. From there, my lord, I approached principal bench KT.
On last occasion, my lord, your lordship, after hearing some time, my lord, this is, my lord, he given the representation for revoke the suspension. Last occasion, your lordship has heard this matter. He given the representation for revoke the suspension. So that is rejected. That's why he filed the, my lord, application before the principal bench. This principal bench, my lord, passed the order status quo. That's all, my lord. He cannot take advantage of that one status quo, not for us to suspend again. There is no, my lord, order. That is, your lordship is last
Charges
occasion also
are very
clarified
same.
this one also.
Charges are very same. Charges are very same. Twice the Honorable High Court has set aside the orders of suspension. Twice. My lord, I request my lord to peruse annexure A3. Kindly. Kindly annexure A3 be perused. Operative portion, my lord will find at page number 61. Annexure A1 order dated 30th January 2024 has been set aside. And present suspension order, my lord will see annexure A14, where they have quoted very same orders. Kindly, my lord, page number 119. In that, Ulleka 2 ಮತ್ತು 3, both orders have been suspended and set aside.
Ratna Shivogi Mutt for respondent number 4.
Yes.
Lords have directed the government advocate to find out whether the charges given to some Uma Devi or something, whether what is the status. My lords have, I don't know what is the
It is given, my lord.
present status.
That is given, my lord. In writing, my lord, I am seeking instruction from them.
He's also tainted.
In fact, that submission has been taken note of even by the
Tribunal
tribunal.
also, yes, that is complied.
Ah.
That is complied.
Annexure A14 page 119, ಉಲ್ಲೇಖ 2 ಮತ್ತು 3 ಎರಡು ರದ್ದಾಗಿವೆ by the Honorable High Court in writ petitions. Still, again, they quote very same orders and suspend me. Third time.
This order dated 14/10/2024 was stayed, huh?
Yes, madam.
Huh?
My lord will see annexure A15.
A14.
A14 lord ಉಲ್ಲೇಖ 2 ಮತ್ತು 3ರಲ್ಲಿ ಮತ್ತೆ ನನಗೆ ಸಸ್ಪೆಂಡ್ ಮಾಡಿ ಎರಡು ಹೋಗಿವೆ, ರದ್ದಾಗಿವೆ ಎರಡು.
By which order?
Yes.
By which?
By which? Annexure A3. Kindly.
A3.
Annexure A3. Annexure A3 page number 61. ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ED 38 DGP 2020 ಸರ್ಕಾರ.
Respondents are directed to reinstate the applicant.
Yes.
Into service.
Yes. I've been reinstated and I'm working. Once again, annexure A4 suspended. A4, my lord will find page number 62. Same charges. Very same charges.
Not same charges. Kindly pass over, my lord. My file is misplaced, my lord. I'll get it, my lord, 2:30. Lordship, I have 2:30, my lord.
Pass over.
Tomorrow.
Huh?
Tomorrow.
At the request of learned government advocate, release this matter tomorrow.
Great, great. Yes, I have a function at home. That is why I'm sorry.
Yes.
Seal number 33, Siddharuda B. Pujari.
Respondent, my lord. This matter may be taken up on Friday.
My lord, have it on 19th, my lord. 19th, my lord.
Friday agadilla.
19th maybe.
At the request of learned counsel for the petitioner, release this matter on 19th of November.
Seal number 35.
Idurdu ಇದು ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ ಒಂದು ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ವಲ್ರಿ, ಪಾಪ ಅವ್ರು ಬೆಳಿಗ್ಗೆಯಿಂದ ಬಂದು ಕೂತ್ಕೊಂಡಿರೋರು.
Seal number 10, Ganesh
ಇಲ್ಲಿ
Kalaburagi.
ಹೊರಗಡೆ ಅದೇ ಪಾಸ್ ಓವರ್ ಮಾಡಿಸ್ಕೊಂಡು.
With your lordships, kind leave, my lords.
Yes, yes.
I'm
You are ready.
I'm not ready, my lord. In fact, my lord, there are, I am given to understand similar matters of same project, near 1,400 cases are pending before your lordships with regard to this project.
No, this is regarding
This is
the-
regarding, my lords,
you
similar
want the
matters,
same-
interim order has been granted.
You want the same benefit that was given to you in the orders passed at Dharwad bench. Ade
Please,
tane?
my lord, that is the order dated 23rd September 2024.
ಹೌದೌದು.
The
ಅವರು
similar-
what they are saying is that order was passed because look at the market value or the award passed in those cases. It is very high compared to what is the in the present cases.
So therefore, my
In the
lord, in
present
this-
cases, the market value is very, very less, and therefore you cannot
Apply
give the same benefit of depositing only 25%. That is the contention.
So we'll be able to place the data, what was the award passed and what is the enhanced amount, my lord, to show that. So, that's one point. There are, I will place all those similar orders, maybe passed in all the matters, my lords. I'll furnish the data to your lordship by next week, my lords.
Anyway, what is sought to be contended is that this kind of an order, even if it is passed by a coordinate bench, that cannot be taken as a benchmark now. That in all cases, you will be permitted to only deposit only 25%.
What has happened here is, my lord, in fact, my lord, my first submission is not that if the landowners are entitled to the money, we want to deprive the landowners what is due to them, my lord. What is being examined, my lord, so whatever is due, we will pay. Question is about what is not due or enhanced amount, what is the basis of the order passed by the reference court, my lord. To that extent, I want to point out, my lord, if your lordships are satisfied that if it is arbitrary or disproportionate to what they are entitled, then your lordship may.
Now, normally what we were directing is deposit 50%.
Correct, my lord.
And they would seek for leave of the court to withdraw that award amount.
Correct, my lord.
Now, since you are making a submission, please restrict it to 25%.
Please, my lord.
In terms of the orders passed by the coordinate bench at Dharwad.
Please, my lord.
This is the contention that they are seeking to raise.
Our case is 20.
First of all, ನಮ್ದು award amount ಕಡಿಮೆ ಇದೆ.
The difference.
ಅದ್ರಲ್ಲೂ ನೀವು 25% ಅಂತ ಮಾಡಿದ್ರೆ.
ಅಲ್ಲ ಕಡಿಮೆ ಅಂತಂದ್ರೆ
25%
ಎರಡು ಕೋಟಿ ಚಿಲ್ರೆ, ನಂದು 7 ಲಕ್ಷ ಪ್ರತಿ ಎಕರೆ.
ಅದೇ ಅಲ್ಲಿ that per acre it would come to nearly 2 crores ಅಂತ ಅಲ್ಲಿ.
More than 2 crores.
More than 2 crores.
I'll examine that.
About 7 lakh, 8 lakh.
It is hardly about
7.5 lakhs.
7 or 8 lakhs.
I'll seek instruction. Your lordship, then have it kindly grant 2 days, my lord.
Adana, please verify that one.
Please, if it's possible on 19th at least, my lord, I'll just get on 19th, my lord. If that is the case, my lord, I'll seek instructions and we'll make.
Aste. At the request of the learned advocate general, release this matter on 19th of November.
Please, my lord.
All right.
Seal number 19, 21, 24, 26 and 27.
Yes. ಅವ್ರು ಬಂದ್ರಾ?
Seal number 10, Ganesh Subhash Chandra Kalaburagi.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಬೇರೆ ಕರಿ. ಬಂದ್ರಳು. ಯಾವ್ದದು? 24.
Seal number 10.
2:30 it could be taken. At 2:30 it could be taken.
2:30.
Yes, sir.
Next ಕರಿ.
Seal number 35.
You can ask them to go, why they should stand here. I don't think the presence of the parties would be necessary now. Their presence was necessary only for conciliation. If that is not the point, then there is, why should they wait here? Let them go.
Admission matters, CL number 35, Krupasagar Patil.
My lordship, I am appearing for respondent number 3, insurance company, my lord. I am appearing for respondent number 3, insurance company, my lord.
Mr. Krupasagar Patil.
Krupasagar Patil for appellant.
You know, it can be disposed of, huh?
Please, my lord.
Huh?
Please.
Pass over.
CL number 36, Sachin Mahajan.
Wife's appeal challenging, my lord, the decree of divorce granted by the family court.
Wife's appeal.
Wife's appeal. Matter requires to be admitted, my lord, since.
Ready.
One date may be given, ma'am.
Admission, formally it can be admitted. There is already an interim order granted.
Admission.
Admission. In fact, it was moved by the other side with an understanding, my lord, that the matter would be formally admitted and, my lord, it can be sent for conciliation. It appears, my lord, they are willing to, my lord, negotiate the terms and, my lord, end the matter. So my request would be, my lord, formally it may be admitted by extending interim order, my lord. Parties may be directed to approach, my lord, the mediator or the conciliator, as we had the understanding, my lord, before moving the matter. Decree of divorce is sought, my lord, on 2 grounds, both of, my lord, desertion and cruelty. The family court has held, my lord, that there is no desertion.
Huh? Is dissolved.
It is dissolved.
There is an order of stay.
There is an order of stay.
Admit. Call for trial court records. Next para. The parties herein are also directed to appear before the mediation center on
28th or 28th, my lord?
28th of November.
Please.
Full stop. Release this matter on 5th of December.
Please. Interim order is only till the next date, my lord. It can be made until further orders. It was at their request, my lord. Couple of times it was adjourned. And, my lord,
till then.
Until further orders.
Granted, earlier stands extended until further orders.
Highly obliged.
Serial number 35, matter may be referred to Lok Adalat, my lord.
Lok Adalat.
Injury case only enhancement.
Serial number 35, matter stands referred to Lok Adalat.
Please. That is for additional documents, my lord. Please.
CL number 37, B group matters. Ravi B. Patil.
For respondent.
Ravi B. Patil, ಯಾವ ಮಾಟಕ್ಕೆ ಬರಲಿಲ್ಲ ಅವತ್ತು ಬೆಳಿಗ್ಗೆಯಿಂದ ಅಲ್ಲ ಪಾಸ್ ಓವರ್
37 kindly pass over.
ಏನಮ್ಮ ಎಲ್ಲಾ ಮ್ಯಾಟರ್ ಪಾಸ್ ಓವರ್ ಮಾಡ್ಸ್ಕೊಂತಿದ್ದೀರಾ? ವೇರ್ ಇಸ್ ಹಿ?
He is engaged in another court.
ಏನ್ರಿ?
Refixation of the, my lord, pay scale. Under wrong representation, my lord, that was reduced. The wrong representation made by the, my lord, petitioner hearing.
You are ready with the matter.
That is, my lord.
You are ready with the matter.
Lots of.
ಅಲ್ಲ ಬಿ ಗ್ರೂಪ್ ಅಂತಂದ್ರೆ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ
ಅದೇ
ಟೇಕನ್
hearing only, my lord,
ಡಿಸ್ಪೋಸ್
because 230 another matter is there, my lord, parted matter. Therefore, it not reached at all. Next any week, my lord.
at the request of learned government advocate release this matter on 21st of November.
Seal number 38, Maruti S.
Appeal for the applicant, petitioner, my lords. My lords, challenge, my lords, CH-2 order, my lords, at annexure A, my lords. My lords, the impound order, my lords, annexure A6, my lords, page number 78, my lords. Page number 78, my lords. Kindly see, my lords, adರಲ್ಲಿ para 2, my lords. The promotion of the applicant has been withdrawn, my lords. Can I read, my lords? Para 2 of the page number 78, annexure A6, my lords. But ಬಳ್ಳಾರಿ ಕೇಂದ್ರ ಗ್ರಾಹಕದಲ್ಲಿ ವೀಕ್ಷಕರಾಗಿ ಕರ್ತವ್ಯನಿಸಿದ್ದ ಅವಧಿಯಲ್ಲಿ
ಯಾವ ಪೇಜ್ ನಂಬರ್?
Page number 78, my lords. Para 2, my lords, ಅದರಲ್ಲಿ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್, my lords. ಬಳ್ಳಾರಿ ಕೇಂದ್ರ ಗ್ರಾಹಕದಲ್ಲಿ ವೀಕ್ಷಕರಾಗಿ ಕರ್ತವ್ಯನಿಸಿದ್ದ ಅವಧಿಯಲ್ಲಿ ಶಿಕ್ಷಾ ಬಂದಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಯೂಸುಫ್ ಬಚ್ಚಾ ಖಾನ್ ಈತನು ಕಾರಾಗೃಹದಿಂದ ಮೊಬೈಲ್ ಮೂಲಕ ಮುಂಬೈನ ವ್ಯಕ್ತಿಯೊಬ್ಬರಿಗೆ ಬೆದರಿಕೆ ಒಡ್ಡಿದ ಪ್ರಕರಣದಲ್ಲಿ ಸದರಿಯವರು ಕರ್ತವ್ಯ ಎಸಗಿರುವ ಕುರಿತು ಶಿಸ್ತು ಕ್ರಮ ಉದ್ದೇಶಿಸಲಾಗಿರುತ್ತದೆ. Plus, they are not initiated any action. Only they intend to take action. My promotion has been withdrawn. But they are not issued any charge memo as on the date of incident. As on the date of given promotion, my junior have been promoted subsequent post. Subsequently, they intend to initiate action against me. They are cancelled my promotion, but in the similar circumstances, the one application filed by the Honorable Tribunal, that has been dismissed, and they approached the Honorable High Court of Karnataka, Bangalore bench, that has been allowed, and the order of the case has been set aside, in application number 19407/2023,
No, that official memorandum was issued on 26/9/2022.
Yes, my lords. Yes, my lords. The charge memo issued, my lords, subsequently, my lords. As per
what was the prayer in your application before the tribunal?
My lord, to set aside, my lords, the another A6, my lords.
A6.
Out, Swami. Another A6, my lords.
Because they recalled your promotion.
Yes, my lords, which is already granted. Not in similar.
Why the tribunal has not accepted your contention?
Lords, they are contented. Once the lords they wanted to initiate, it is deemed to be initiated until that's on ground of that, they not allowed my application, lords. That is clearly contrary to lords, Janakiraman case and Anil Sarkar case, lords.
Please read paragraph number 11 of the impugned order.
Please, my lords. In view of the above discussions, let us examine the case of the applicant. No doubt the applicant lowest in the hierarchy of the prison department, but he is the most important employee to enforce the rules, circular and provisions of the prison manual, because he is working at the cutting edge level. As per the material available, he was in charge of a cell in Central Prison Ballari, wherein a known dangerous criminal was undergoing imprisonment and entrusted with the various responsibility of the following the instructions contained in prison manual, circulars and rules, to keep a watch on the activities of this tribunal and also ensure this safety. This alleged dereliction of duty on his part is serious in nature, as a notorious gangsters lodged in the jail could access mobile phones and indulge the antisocial and anti-national activities. It is pertinent to note that the preliminary inquiry officer has mentioned that his report about serious lapse on the part of the 41 prison officers working in the Central Prison Ballari, and the applicant is one of them. Therefore, the allegations against them against him to the extent of alleged dereliction of duty cannot be with prejudice. Secondly, the interest of state public interest is involved as the prison department is very sensitive and important department in the maintenance of the public order. Interest of state and upholding the public policy. Therefore, we are of the considered opinion that even if there is a procedural lapse of the part of the respondents in not bringing the involvement of the applicant in the alleged dereliction of duty to the notice of the departmental promotion committee, if the large public interest and security of the state is considered, this lapse plays into insignificance. This is as per the ratio laid down by Honorable Appeals Court so and so. And so and so, the point to be noted is that Deputy Inspector General of Prisons submitted his report 4/3/2022 to respondent number 2, and the respondent 1 mandate recommendation to this government to initiate disciplinary proceeding against 41 officers and staff, including applicant, on 17/8/2022. The promotion to be applicant to the cadre of headquarter was accorded on 30/8/2022.
Let us see what is this Union of India versus Keval Kumar. What have they discussed?
That's Keval Kumar, my lads. Thirdly, I not get the lads this judgment, my lads. But my lads, anyhow, my lads, they wanted to initiate disciplinary inquiry against them, my lads.
Paragraph number 9 ali ಇದೆ ನೋಡ್ರಿ. Without discussing, how can they say? Paragraph number 9 ali ಇದೆ ನೋಡಿ. Union of India versus Keval Kumar.
Please,
reported in so and so.
Please,
Where the lordships have ruled.
Yes.
That date of commencement of disciplinary proceedings is from the date when the department took a decision to initiate action against the delinquent.
This is overruled, my lords, as per Janakiraman case, my lords. Janakiraman case must clearly state the action of taken must as on the date of issue of charge memo, not before that, my lords. The Janakiraman case and Anil Sarkar case is very clear, my lords. This is the latest judgment.
Yengri overruled. Janaki Raman is earlier in point 1991.
Subsequently, Anil Sarkar case is
subsequently Keval Kumar has come. How can you say it is overruled?
Anil Sarkar, kindly see, my lords, I produced one judgment.
Same proposition was a subsequent decision. Union of India versus Anil Kumar Sarkar, 2013.
Yes, my lords. Adralli, there is very clear, my lords. The incident, my lords, subsequent data. As on the date,
where is the judgment?
I will produce the my lords.
ಅಲ್ಲೆಲ್ಲೋ ಕೂತ್ಕೊಂಡು ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಇದೇ ಆಗೋದು.
Sorry, my lords, I will produce the along with memo, my lords, on 8 this month, my lords. Along with memo, I will place, my lords. And similar circumstances, one of the Ramanna, who is also involved in this case, he is getting promotion, my lords. And so many of the employees are getting promotion, my lords.
ನೋಡ್ರಿ, ನೀವು ನೋಡ್ಕೊಂಡ್ ಬನ್ರಿ. Although it is cited, and if that is not taken into consideration, then we'll have to set aside this order.
We'll go to this.
Nodi, that Janaki Raman's case has been further reiterated in Union of India versus Anil Kumar Sarkar, 2013.
Yes.
Though it is noticed here, but they have not said why that is not applicable.
I will look at it.
Learned counsel for the petitioner as well as the learned government advocate are required to go through the judgment of the Honorable Supreme Court in the case of Union of India versus KV Janaki Raman, semicolon, Union of India versus Anil Kumar Sarkar, and Union of India versus Keval Kumar, which are cited in paragraphs number 8 and 9 of the impugned order. Full stop. Release this matter on 20th of November.
Please, madam.
Final hearing matters, CL number 39, GS Biradar. GS Biradar, final hearing matters.
Matter is called out. There is no representation for either of the parties. Release this matter on 25th of November.
CL number 40. Deepak V. Barad,
Matter is called out. There is no representation for the appellant. Release this matter on 25th of November.
serial number 41, BD Angarki,
I beg to appear for respondent number 4. As per the direction by this honorable court, today I have filed the details as sought in the registry.
Respond number 4.
How Karnataka,
41.
sorry, 40.
Partitions.
40.
Kindly pass over, madam. Kindly pass over.
ಏನ್ರಿ ರೆಡಿ ಇದೀರಾ ನೀವು?
Suit for partition has been
Ah.
dismissed. So after I had informed that.
Mamdapur,
Update, sir.
I have adjourned the matter. We have adjourned the matter to 25th.
Obviously.
All, yes.
41, BD Angarki,
Paper appellant.
Kindly pass over, madam.
Huh?
Senior is held up in court on 6.
ರೆಡಿನಾ? ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
It's filed, man.
ರೆಡಿ?
If 1 week is granted, my lords, that another this judgment will be required.
At the request of learned counsel for the appellant, release this matter on 20th of November.
serial number 42, Prabhu B,
Lords, I beg to appear for respondent number 4. As directed, Lords, I have Lords filed the details with regarding to formation of layout, number of plots laid, and number of plots allotted in favor of different in the registry today. I have also served a copy on the council appearing for the process.
Learned counsel Shri S.S. Mamdapur, appearing for respondent number 4, submits that he has filed in the office today
Today, I'll.
certain information
I have received, sir.
as sought for by this court. Full stop. Copy of the same is served on the learned counsel for the appellant
Appellant and cross objector also.
and the cross objector.
Adರಲ್ಲಿ, Lords, one small submission. Lord. Layout map ತುಂಬಾ ದೊಡ್ಡದಿದೆ. It is a huge page. I could not get Xerox, so I have furnished one copy, Lords. By next date of hearing, I will obtain 2 more sets so that it would be convenient for the court.
Release this matter on 20th ಆಗ್ಬೋದಾ?
ಮಾಡ್ಬೋದು, sir.
20th. Yes.
Please.
serial number 43, DP Ambekar,
In this case, I have to file a list of this thing, dates ಅಂತ ಹಾಕಿರ್ತೀನಿ. I'll file.
ಘಾಟೆ ಹಾ?
ಇವರು ಇದ್ದಾರೆ. Mantesh Patel also appear.
ಕೂತಿರಲ್ರಿ?
Yes,
ಹಾ.
ನಾನು ಇದ್ದೀನಿ. Both sides are directed to file a this thing. Dates ಹಾಕಿರ್ತೀನಿ.
ಏನು?
20th it might take. List of synopsis ಹಾಕ್ತೀನಿ. Authorities and summary of contention.
At the request of learned counsel for the appellant, release this matter on 20th.
Please.
I request 26th notes. My client is also coming, he is 80 years old. I'm not able to not get him. Maybe taken on 26th, my lord, so that I will get instructions also. 26. ಇಲ್ಲ ನಮ್ಮವ್ರಿಗೆ 2-3 ಸಲ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದೀನಿ, ಅವ್ರು 80 ವರ್ಷ. ಸ್ವಲ್ಪ ಅವ್ರಿಗೆ ಬರಕ್ಕೆ ಅನಾನುಕೂಲ ಇದೆ. ಈ ವಾರ ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಹೇಳಿದೆ. ಐ ಕಾಂಟ್ ಸೀಕ್.
ಇನ್ನೊಂದು ವಾರ ಟೈಮ್ ಇದೆಯಲ್ಲ.
ಇಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳಿದ್ರು ಒಂದ್ 10 to 15 days ಸ್ವಲ್ಪ ಬೇಗ ಅವ್ರು ರಿಕವರಿ ಏನೋ ಆಗ್ತಿದಾರಂತ, ಅದಕ್ಕೆ 25th.
Release this matter on 26th of November.
serial number 44, Vinayak Apte,
ಏನ್ರಿ RFAಗಳೆಲ್ಲ ಯಾರು ರೆಡಿನೇ ಇಲ್ವಲ್ರಿ?
Option plea was taken, my lord, and.
We have not decided one RFA, one criminal appeal, ಏನು ಇಲ್ಲ. At the request of learned counsel for the appellant, release this matter on 21st of November.
serial number 45, MM Patil,
This is the plaintiff appeal, my lords. The plaintiff.
Mr. CA Sugur for response number
Sugur for respond number
8 and 15. Avare contesting respondents.
No, my lords, they are placed ex parte before the trial court.
ಹೌದಾ? 2016.
Yes, ma'am.
All of them have been placed ex parte. Why are you waiting then?
The matter was part heard and thereafter it was released, my lords.
Ah,
The matter is before the honorable court for final hearing.
so we can go ahead now.
Yes, ma'am.
Really?
This is the plaintiff appeal, my lords. The plaintiff filed a suit seeking the relief of partition and separate possession along with the relief of declaration of compromise decree passed in OS 337 of 2001 as not binding on the share of the plaintiffs herein.
Ah,
The trial court partly decreed the suit of the plaintiffs by granting share in 2 suit items, whereas one of the suit items was rejected. With that regard, the present appeal has been preferred, limiting the claim and the appeal in respect of the item which was suit item property which was denied by
Yes.
the trial court. It is the case of the plaintiffs, my lords, that all the suit item properties belong to their father. And after his death, since they being tenants in common, they are entitled for specific share as per the Mohammedan law. The defendant number 1,
daughters.
yes, my lord,
Ah,
daughters. Since they belong to Mohammedans, they have a specific and they are entitled for a specific share as per their Shariat law. One of share to the
daughters.
And one share to the son.
Huh?
One share to the son, half share to the daughters. Double share is for the son. And 1/8 is residuary for the wife. Defendant number 1 is mother of the plaintiffs. Defendant number 2 is sister of the plaintiffs. Defendant number 3 to 6 are the wife and children of one deceased brother, Imam Saab. Defendant number 7 is the brother of the plaintiffs. Defendant number 8 to 15, they are unknown to the family of the plaintiffs. In spite of that, their names are appear in the ROR. As such, they have been made as necessary party to the present suit. Now,
They didn't appear?
defendant number 1 appeared.
Allah, the others.
Others,
who, according to you.
they have been placed ex parte, my lord. They have not contested. Though the
mostly ಅವರು purchasers ಅಂತ ಕಾಣುತ್ತೆ.
Maybe purchasers.
What is the finding?
Finding is their suit property have been decreed in my favor.
Has been
Property
decreed,
standing, the property standing in the name of the third persons have been decreed.
ಹೌದಾ?
The only claim in respect of one of the suit item, which has been alleged that my father had gifted the property in favor of my mother to the extent of 10 acres out of 20 acres. That property has been dismissed. That relief in respect of that property has not been given to the plaintiffs. Being agreed by the same,
ಅಷ್ಟೇ.
to that
Only
extent,
one
the appeal-
item of property.
yes, madam. To that extent, the appeal has been preferred.
Yes.
Now, the defendant number 1, in collusion with defendant number 2, filed a suit wherein they both enter into a compromise. And accordingly, decree.
Defendant number 1 is your mother.
Defendant number 2 is my sister.
Ah,
Without making the other necessary parties in the said suit, they among themselves collude and file a suit for declaration by my sister defendant number 2 and the
respect of this property,
in respect of suit item number 2,
which we are concerned of.
which the honorable court is concerned of.
And they had,
In the year
your
2001.
mother had filed a suit.
My sister filed a suit seeking the relief of declaration, alleging that my mother has gifted the property 10 acres out of 20 acres. Earlier, the said 10 acres was gifted by my father to my mother.
Correct.
Thereby, she acquired the title in respect of that 10 acre. And now the said 10 acre has been gifted to me. Now, since she has already gifted to me and position has been delivered, she is denying my title. Since therefore, I am constrained to file the suit seeking the relief of declaration in respect of 10 acres. The trial, they said, thereafter the compromise petition is filed and the same is allowed and compromise decree is passed by the trial court in OS 337 of 2001. Thereafter, the defendant number 3 to 6 herein preferred another suit, OS 222 of 2002, challenging the said decree, compromise decree. Unfortunately, the said suit came to be dismissed, wherein I was not made a party. The plaintiffs herein are not the parties. Now, in both the suits, in the compromise decree as well as the decree OS 222 of 2002, the defendant number 1 nor the defendant number 2 have established the essential ingredients of gift before the trial court. In that regard, since the say is of oral gift, there is no presumption as to gift. It has to be proved, and the burden is upon the persons who allege that the gift has taken place. Now, my lords, the defendant number one submits that she,
Now,
mother.
let's come to that later.
Oh.
What is the law in respect of a property that is acquired by a Muslim woman by way of a gift from the husband?
It can be oral or it can be registered.
Adalla.
Sir.
You are not questioning the correctness of the gift made by your father.
I am denying the gift, my lords.
Huh?
I am denying gift itself has not taken place because the defendant number one herself have filed the written statement in my suit, claiming that she is illiterate woman and she has not gifted any, she has not acquired any property from her husband, nor she has gifted it to anybody. Therefore, the compromise decree drawn in OS 337 of 2001 itself is in dispute by the contesting party in the said suit. Since she was a daughter, she might have called her to the trial court and thereby she might have misguided the defendant number one and might have obtained the compromise decree. Because the defendant number one have appeared in the present suit and she have filed the written statement.
Yenanta?
I have not gifted to anybody and there is no gift in respect of me. Kindly, I may be permitted to.
Despite there being a compromise petition.
Yes, my lord, compromise decree.
There is a presumption which will go against her.
But the plaintiffs are not
a compromise petition ali entragi.
Oh.
If this lady, your mother, in that suit, if she is a party to the compromise petition and decree,
yes,
how can she now turn around and say, no, I am not aware.
But that is the pleadings of the defendant number one before the trial court, my lord.
Yes.
Because she has mentioned that the daughters are also entitled, the present plaintiffs are also entitled for share in all the properties, and I have not gifted the property to anybody. This is the admission given by the defendant number one in her written statement. Now, the matter for consideration before the honorable court is whether the alleged gift, as per the say of the defendant number 1 and 2 in OS 337 of 2001, the property.
So long as that compromise decree is not set aside in a manner known to law.
Yes, ma'am.
Defendant number 1 will not be permitted to say, no, I am not aware of that decree. That would be the position.
But the written statement, she has taken the. I am not.
If it is contrary to any judgment or order passed by a competent court, civil court, so long as that judgment or decree is set aside in a manner known to law, it would be a futile exercise simply to say, no, I was not aware, I don't know anything.
That compromise decree,
that presumption in law will go to the benefit of your sister.
No doubt, it is a fact, my lord, that the compromise decree has been passed, but I am not a party to the said compromise decree. Thereby, I have challenged in the present suit. That compromise decree is binding between defendant number 1 and 2. Since I am not a party to the said suit, that decree is not binding on my rights in respect of the suit properties. Further, the defendant number 1 and 2 till today have not proved the said alleged gift in accordance with law. If at all the said gift is a registered gift deed, then there is a presumption in law. But the allegation is that it was an oral gift in the year 1980, Ugad. But the exhibit P1 to P5, kindly the honorable court may peruse exhibit P1 and P2.
No documentary evidence were filed.
No documentary evidence. The case is
regarding Khata to show that the gift has been acted upon.
Yes, my lord.
Any documents?
No documents before the trial court by the defendants to establish the fact that immediately after the execution of the oral gift, the property has been mutated in the name of the donee.
No such
document have been produced before the in the OS 337, nor in the OS 222, nor in the present suit.
Even after the compromise decree.
Even after
the compromise decree, mutation entries are not changed.
They are changed, my lord. After the compromise decree, mutations have been changed.
Yes.
The father of the plaintiffs died in the year 1985. Thereafter, the revenue entries have changed. As per the allegation of gift is concerned, it is in the year 1980. If at all, 1980, my lords. Ugadi, 1980. If at all, the allegation, pleadings of the in compromise decree is to be presumed to be correct and genuine, then what prevented the defendant number 1 to get her name entered in the revenue records.
So the decree drawn,
It was drawn on 2001, my lords. 28/8/2002. 28 August 2002. And decree drawn on 6th.
please point out to these facts in the impugned judgment. These dates, relevant dates.
I have filed the translated copy of the judgment, my lord. At para number 32 and 33 of the judgment, my lords. Impugned judgment. Para number 49 of my appeal memo.
Para
number 32.
32 of the impugned judgment.
Impugned judgment.
Yes.
ಸದರಿ 1ರಿಂದ 5ನೇ ಪ್ರತಿವಾದಿಯರು ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು ಸಲ್ಲಿಸಿ ಆ ಪ್ರಕಾರವಾಗಿ ವಾದಿಯರ ದಾವೆಯನ್ನು ಡಿಕ್ರಿಗೊಳಿಸಲು ಕೋರಿದ್ದರೂ ಸಹ ಆ ಮಾತ್ರಕ್ಕೆ ಸದರಿ ವಾದಿಯರು ಮತ್ತು 1ರಿಂದ 7ನೇ ಪ್ರತಿವಾದಿಯರ ದಾವಾಸ್ತಿಗೆ ಸಮಾನ ಹಕ್ಕುದಾರರಿರುತ್ತಾರೆಂಬುದನ್ನು ಅಂಗೀಕರಿಸಲು ಸಾಧ್ಯವಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ OS ನಂಬರ್ 337/1 ದಾವೆಯಲ್ಲಿ 1 ಮತ್ತು 2ನೇ ಪ್ರತಿವಾದಿಯರು ಶಾಮೀಲಾಗಿ ರಾಜಿ ಮಾಡಿಕೊಂಡು ಡಿಕ್ರಿ ಮಾಡಿಸಿಕೊಂಡಿದ್ದಾರೆಂದು ತಿಳಿಸಿದ್ದು. ಆದರೆ
ಅಲ್ಲಲ್ಲ, dates, we wanted to note the dates ಅಷ್ಟೇ.
That
ನಿಮ್ಮ ಪ್ರೇಯರ್ ಅಲ್ಲೇ ಇರ್ಬೇಕಲ್ಲ?
ನಮ್ಮ ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಇದರಲ್ಲಿ
ಅಪೀಲ್ ಮೆಮೋ. ಮೈ ಪ್ರೇಯರ್.
ಏನದು ಡೇಟ್? ವಾಟ್ ಇಸ್ ದಿ ಡೇಟ್ ಆಫ್ ದ ಜಡ್ಜ್ಮೆಂಟ್?
Judgment compromise decree dated in my plain prayer, it is there, my lords. Decree drawn on 6/9/2020. 2002, my lords.
6/9/2002.
Decree is drawn.
The 14th is the year 2014.
Yes, my lords.
ಅದು ಯಾವುದು? OS ಅದು?
OS 337 of 2001.
337 of 2001. DD
6/9/2002.
6/9/2002.
Decree date 6, judgment date.
Judgment date 28/8/2002.
28th 2002.
Decree date 6.
When were the mutation?
After the earlier till during the lifetime of father of the plaintiffs, suit property item number 2 stood in the name of the father of the plaintiffs till 1985, my lords.
Father gifted
to his wife
in the year 2000. Sorry,
alleged gift in the year 1980. Ugad 1980.
1980.
Yes, ma'am.
Father died in 1985.
1985. Thereafter, the name of the mother of the plaintiffs were entered in the
gift is said to have been made by your mother in favor of your sister when?
In the year 2000, my lords. 2000. Exhibit P17, my lord. Exhibit P17.
Date ಹೇಳಿ.
It is plaint. Plaint in OS 337 of.
Date ಹೇಳ್ರಿ. Gift. When the
Ugad 1999. Ugad 1999. Ugadi 1999. Ugadi.
1999.
Yes, my lord. It is also again oral gift.
We will continue at 2:30.
Obliged.
My lord, one appeal submission.
Submission, my lord.
The serial number 17, my lord. Some of the parties are appearing and their names are not shown. Since I have filed memo to the extent that those who remain absent, only those persons we dispense with.
My
Others
lord.
have filed wakalat, my lord.
Already
ಅವಾಗ್ಲೇ ಹೇಳಿದೆ ಸ್ವಾಮಿ.
not all of them.
All of them ಅಲ್ಲ, ಕೆಲವರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಇದೇ ಕೇಸಲ್ಲಿ. ಅವ್ರ ಹೆಸರು registry put up ಮಾಡಿಲ್ಲ.
The matter jurisdiction issues, my lord, I am. Yes, my lord. The kind.
But you will not have any say in this matter here.
Yes, my lord.
They are raising a challenge to the notification issued by the
chairman,
registrar.
R1.
Tribunal.
Yes, my lord. R1 also in the appear, my lord.
There,
Yes, my lord.
the dispute is only between the petitioner herein and the registrar of the KSAT.
Yes, my lord.
In that matter, you will have no voice.
I am agreeing.
So formally you are made a party.
Yes, my lord.
In this issue, you will have nothing to say.
He is the
Who
one.
are you to say?
I am agreeing, my lord. In the respond number 1 case city, ಅವ್ರದ್ದು ಹೆಸರು ಬಂದಿಲ್ಲಲ್ಲ.
Please understand,
Yes,
sir.
my lord.
You are a contesting party in the original application filed by them.
Yes, my lord.
That will be considered on merits.
Yes.
Now they are aggrieved of the notification issued by the tribunal.
ಇಲ್ಲ ಸ್ವಾಮಿ,
Restricting.
he is the one who raised that objection, my lord. Notification.
Raise ಮಾಡಿರಬಹುದು.
ಈಗಿರೋದು KSAT
You are challenging that notification.
Yes, ಹೌದು.
You are saying the tribunal could not have issued such a notification.
Yes.
Therefore, the dispute here before this court is between you and the
KSAT.
registrar of the tribunal.
Yes,
In this matter, you will have no voice.
Yes, my lord.
Although you have appeared, you cannot make any submission.
On this issue, my lord, promotion is stopped, my lord.
That is why you are there formally.
Yes, my lord.
But this issue has to be decided between the petitioner and the registrar of the tribunal. Therefore, when he requested that all the other parties can be notice can be dispensed with, we have ordered so. Anyway, you have filed your wakalat for some of them.
Yes, my lord.
We will notice that appearance has been entered in respect of respondents number so and so ಅವ್ರ collect ಮಾಡ್ಕೊಳ್ಳಿ.
Yes.
In respect of the others dispense.
I am only in the R8, my lord.
Those who remain absent in the KAT itself, I only.
R8.
All right, sir. Whether they have filed wakalat or not, even if they have filed wakalat, they will not be heard in this matter.
R8 extend.
ಮುಂದೆ
Yes, my lord. Only R8, my lord.
ನೀವೇನ ಹಾಕಿದ್ರೇನಮ್ಮ? ಹಾಕಿದ್ರೆ ಅವದನ್ನು ನೋಟ್ ಮಾಡ್ಕೊಂಬಿಡಿ. For rest of them dispensation.
And
Serial number
the KSAT ಪರವಾಗಿ R1 is appeared. ಅವ್ರ ಹೆಸರು ಬಂದಿಲ್ಲ.
ಆಯ್ತ್ರಿ.
Yes, ma'am.
You will show your name.
Yes, ma'am.
There is no difficulty.
Serial number 37, interim order kindly.
ಆಯ್ತು. Interim order to be extended. Yes.
ನಿಮ್ಮ ಹೆಸರು
41.
ಅವ್ರು ಪ್ರೆಸೆಂಟ್ ಅದರಲ್ಲಿ ನಾ ಏನ್ ಬರ್ದಿನಿ ಗೊತ್ತ್ರಿ, ಹೆಸರು ಬರ್ದಿಲ್ಲ, ರ್ಯಾಂಕಿಂಗ್ ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೆ ಸುಮ್ಮನೆ ಬರ್ದಿನಿ.
ಇಲ್ಲ ಕೊಡ್ಬೇಕು.
ಯಾರು ಅಪಿಯರ್ ಆಗಿರ್ತಾರೆ ಅವ್ರನ್ನ ಬಿಡ್ರಿ. ಫೈಲ್ ದೇರ್ ಅಪಿಯರೆನ್ಸ್. ಅವ್ರ ಅಪಿಯರೆನ್ಸ್ ಬಿಟ್ಟ ನಂತರ ಉಳಿದವರಿಗೆ ನೀವು ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿ ಈ ತರ ಅವ್ರ ಎಕ್ಸ್ಪರ್ಟ್
ಅದು main.
ಕಾರಣ ಕೊಟ್ಟು
ಆಯ್ತು ಮೇಡಮ್.
ಕೊಡಿ, ಅವ್ರನ್ನ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿ.
ಅವ್ನು ಫೀಸೇ ಕೊಡಾನಿಲ್ಲ, ನಮಗೂ ಅದೇ ಪ್ರಾಬ್ಲಮ್. ಅನ್ವರ್
Continue.
ಈಗ ನಾನು ಮತ್ತೊಮ್ಮೆ ಕೋರ್ಟ್ ಏನಿದೆ ಫಾಲೋ ಮಾಡ್ತೀನಿ.
ಇದು ಹೋಗುತ್ತೆ ಟ್ರಾನ್ಸ್ಫರ್.
Court officer, can you please unmute the court's mic, please?
Both matter could be not heard together and not it could be disposed. Any day not.
Last appearing for the appellant in this matter, my lords. Last time they said they will file an affidavit because I could not hear what my learned friend submission because the court's mic was muted.
ಈ ಮ್ಯಾಟರ್ ಅನ್ನು ಹೌದು ಇದರಲ್ಲೇ ಹೇಳಿದೆ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ನಾನು ಐ ವಿಲ್ ನಾಟ್ ಬಿ ಪ್ರೆಸಿಂಗ್ ಅಂತ ಹೇಳಿದೆ
Yes, madam. My senior man.
All right. If you are ready, we will go on with this matter then.
Yes. We are ready in both the please.
If you are ready, will you make submission?
No.
Please.
My lordship may have it tomorrow or something because my learned friend said that he will file an affidavit today. That's the reason why I could not be. I was ready. If he is ready for the matter, lordship may give me a very short date, either tomorrow or day after tomorrow, whichever is convenient to the honorable court. I will make my submissions.
Although learned counsel Sri Ravi B. Patil had earlier submitted that his client will file an affidavit having regard to the subsequent events that the minor daughter was permitted to join the mother.
Mission ಏನಿಲ್ಲ but she has joined. Since both of them were called in the chamber, she expressed her intention to join mother, and for which I have not objected. Written permission in Inlas. There is no order specific.
Chamber discussion
has expressed her intention to continue to live with the mother. Nevertheless, the learned counsel would now submit that There will be a copy on the other side.
Outside.
Learned counsel for the appellant seeks for a short accommodation to file 2 applications on behalf of the appellant. Full stop. The applications may be filed in the office. Full stop. A comma while serving a copy of the same on the learned counsel for the respondent. Full stop. Release this matter on 19th of November.
22nd, if it could be.
22nd.
Great.
22nd. Working day. But 25th account.
2060 or
25th.
2060.
All 26.
Mehboob Sahab versus Sayyid Ismail and others. Kindly page number 11 may perused. In page number 11, for a gift to be complete, there should be a declaration of the gift by the donor, acceptance of the gift expressed or implied by or on behalf of the donee.
ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಾ?
Page number 11 of the set.
11.
Yes, first para.
Top ಅಲ್ಲಿ.
Yes, my lord. Beginning of the first line. For a gift to be complete, there should be a declaration of the gift by the donor.
Is extraction of another judgment.
Yes, my lord. In Mehboob Sahab at
After
page number,
considering all that, what is the law laid down?
Lord laid down is, my lord, at page number 18. Para number 21. In this backdrop, we proceed to scan the gift deed. On perusal of the gift deed, it is manifest that Abdul Haq had declared therein that he had always been the owner in possession, and the entire house was in his exclusive ownership and possession and free from all encumbrances. Thus, the said recitals belies the case of the plaintiff that there was an oral gift 7 years prior to filing of the suit. In the case on hand, my lords, till the death of the father of the plaintiff, the subject matter of the suit property stood in the name of the father of the plaintiff. Therefore, the say of the defendant number 1 that there was an execution of oral gift in her favor by her husband.
What are the requirements?
Requirements at page number 11, my lords. There should be a declaration of the gift by the donor.
Yes.
And there should be an acceptance of the gift.
Expressed or implied. By or on behalf of the donee. And delivery of possession. Property. So what you are contending is, there is no delivery of possession.
Yes, my lord. Neither delivery of possession nor expression of giving, willingness of giving gift. Because
how can you say that?
Because if at all the gift has actually taken place, then the possession would have been delivered to the wife.
Right, sir. That is why we are saying. You are saying there is no delivery of possession and therefore it cannot be called a valid gift.
Yes, my lord.
See, on the first aspect of the matter, that there has to be a declaration of the gift by the donor. How do you find out?
That has to be proved by the alleged donee, because she is claiming that there was a gift. He has to prove the gift.
The requirement as per law is that there should be a declaration. But oral gift also is permissible.
Permissible.
So therefore, even if you contend that yes, it was gifted, all you are required to prove that there was acceptance of the gift.
Yes.
There was acceptance of the gift, either expressed or implied, by or on behalf of the donee, and delivery of possession of the property. Your contention is that although he may claim that there was a declaration, he gifted it, I have accepted it,
yes,
all that may be oral. You may contend orally,
yes,
but you are not proved that the possession was delivered. Because all of us continued to live jointly in that house.
Yes.
That is your contention.
Yes, my lord. Similarly, the revenue record stood in the name of the donor himself. Therefore, the contention of the defendant number 192 that oral gift had taken place.
Please read it further. The subject matter of the gift by the donor to the donee. The donee should take delivery of the possession of that property either actually or constructively.
Yes.
That is why they have underlined that one.
Yes.
These are the only way by which you can find out. Because other things a party may contend, yes, it has happened, it has not happened, or happened, not happened. Ultimately, it is because of these factual positions that one will be able to ascertain whether it is a valid gift. Yes. On proof of these essential conditions, the gift becomes complete and valid.
So, because the defendant number 1 herself failed to establish a valid
Now
gift.
you please read paragraph number 21 again.
21, yes. In this backdrop, we proceed to scan the gift deed. On a perusal of the gift deed, it is manifest that Abdul Haq had declared therein that he had always been the owner in possession.
There was a gift deed there.
Earlier, the allegation, the pleadings, yes,
Sir,
in the case on hand,
there was a gift deed.
There are two facts, my lord, in the case on hand. Prior to execution of the gift deed, 7 years prior to the execution of the gift deed, she was orally gifted. That said, Abdul Haq had orally gifted the suit property in favor of the appellant herein. Thereafter, to avoid future litigation, to avoid multiplicity of litigation in near future, the same was reduced to writing. Now, the document which was reduced to writing has been scrutinized by the Honorable Apex Court.
Yes.
On perusal of the gift deed, it is manifest that Abdul Haq had declared therein that he had always been the owner in possession, and the entire house was in his exclusive ownership and possession and free from all encumbrances. Thus, the said recital belies the case of the plaintiff that there was an oral gift 7 years prior to the filing of the suit. That is, sometime in the year 1968. The learned trial judge as well as the appellate court has brushed aside the said aspect by stating that it has not affected the stand of the plaintiff, inasmuch as some witnesses have deposed about the gift having been made in the 1968. Here, in my case, my lords, not even a single witness have deposed that alleged gift has taken place between my father and my mother. In the case on and there is a witness. In spite of that, the Honorable Apex Court has scrutinized that when a gift has taken place, the delivery of possession is the necessary condition and necessary ingredient to complete the gift, transaction of gift. As the deed would show, the executant had stated that he had executed a will earlier in favor of Rashida. That apart, such a fact, had it been true, would have definitely formed a part of the written instrument. Omission of such a fact, in our view, defies common sense. The conclusion that the gift deed dated 9/10/1970 evidences such a gift is absolutely unacceptable. Be that as it may be, the issue is whether the document and the concomitant factors establish factum of gift made by the donor. As stated earlier, if the essential features are met with no registration is necessary. On a perusal of the gift, deed of gift and the evidence brought on record, it is demonstrable that Abdul Haq remained in the premises in question. He did not part with the physical possession. The case of the plaintiff is that she resided with Abdul Haq, and therefore the principle of donor getting fully divested or handing over of physical possession is not attracted.
Same here.
Same applies in my case. Though such a finding has been recorded, we find it wholly contrary to the evidence on record. The plaintiff was staying with her husband, the family registrar and voter list exhibit. Though the gift deed mentions that she was entitled to get her name mutated in respect of the premises, yet it was not done. The same is also not done in our case, Manoj. On the analysis of the evidence in the backdrop of the deed, it is extremely difficult to hold that she was residing with Abdul Haq in the premises in question. So, page number 22, my lord. 21, last line. Page number 21, last line, last paragraph. There is no proof that the land was mutated in her name.
Paragraph 24.
24 minutes, last line. There is no proof that the land was mutated in her name in favor by the revenue entries authorities. Such was also not in the possession of the title deeds. Thus, the evidence on record on a studied scrutiny clearly revealed that Rashida Khatun was not in a constructive position. Therefore, one of the elements of valid gift has not been satisfied. So, the defendant number 2 claims to hold the title of the portion of the suit item number 2 by virtue of alleged gift executed by defendant number 1 in her favor. Whereas the defendant number 1 herself have failed to establish the fact of valid gift in her favor. Apart from that, the suit property is measuring 20 acre, 20 guntas, my lords. The subject of gift is to the extent of 10 acre, 14 gunta. Whereas the claim in respect of suit item number 2 has been dismissed in entirety. Even otherwise, if the gift is to be believed, then I am entitled for relief in remaining 10 acres of suit property, suit item number 2. Even that is been dismissed by the trial court, holding that gift is valid as per the compromise decree.
That is in respect of 10 acres.
Yes, my lord, but the trial court has dismissed the suit in the suit item number 2.
Although 10 acres in terms of the gifted.
Gifted, it is 10 acre, 14 guntas, madam. Remaining 10 acre is also dismissed.
Without any reason.
It has not, without any reasons, madam.
Without any reason.
Without any reason. It has.
And property is in whose possession now?
It is in
remaining extent.
Remaining in defend number 8 to 15 minutes.
Together.
Separately, they are holding
8 to
15 third persons.
Who are they?
They are unknown to the family of the defendants, the plaintiffs.
And how is it that the others are not raising any claim?
They have not filed any suit or any. They have not raised any objection.
Is it a fact that they have sold the property to them or
No,
something like that? Then why would the others give up their
That
rights?
is the reason. That is the reason the plaintiffs approached those defendants prior to filing of the suit, and they are made necessary party before the trial court.
Nimma own sisters and brothers.
Allah, that is not in the knowledge of the plaintiffs, my lord. It is not in the knowledge of the
What do
plaintiff.
you mean it is not in the knowledge of the plaintiff?
Because
Why are they not asking for sharing that property?
we have asked the share, plaintiffs sought for share, my lords, in the suit properties.
You have only one share.
No,
Isn't it?
two daughters have filed the present suit
Howdo?
against mother, sister.
Correct. So our question to you is, If you are saying respondents number or dependents number 6 to
8 to 15.
8 to 15 are in no way connected with the family,
Yes, ma'am.
but they are in possession of the property. If that is the contention, why are the other family members, your brothers and sisters, not claiming any share in that property?
They might have made unlawful transactions, my lords, which is unrecognized by law.
You should come out clean, sir.
That there is no document shown to me to plead that they have made certain transactions. If it was a registered transaction or it is available to me, I would have necessarily pleaded.
You are representing whom?
For respondent number 8 and 14.
8 to
8 and 14.
What is your contention?
My lords, I have been placed in expert in the law trial court. And even I have not been preferred any appeal as pertaining to that. On the last date of the court.
When
has-
did you enter appearance in this matter?
Please, ma'am.
When did you enter appearance in this matter? ಅವ್ರದ್ದು ವಕಾಲತ್ತಗಿರಿ. Hmm. 2019 you entered appearance.
Yes, sir.
And you have not done anything.
Yes, please. Party has not yet been approached to me.
Huh?
Party has not yet been approached. to me.
What can we do?
Kindly come to page para number 8 of my plaint, my lord. I have clearly mentioned para number 8 of my plaint that the plaintiffs had been to the defendant number 8 to 15 and requested them, as they are not related to the family of the plaintiff and also are not the successor to the plaintiff's family. So on what basis their names are entered in the ROR in respect of the suit properties. But till today, they are not ready to tell about their names appearing in ROR in respect of suit properties. The plaintiffs have made an effort asking them whether they have purchased or whether they have mortgaged the suit properties.
And nothing has been said in the judgment.
Nothing has been said, my lord. They have not appeared before the trial court and filed the written statement itself. Defendant number 7 to 9 and 13 to 15 have been placed ex parte, my lord. Though opportunity has been given to them, they have not appeared.
ಇಲ್ಲಿ ಖರೀದಿ ಅಂತ ಇದೆಯಲ್ಲ, quotation.
ಅಲ್ಲ ಇದೆ ಸರ್, ಬಟ್
ಖರೀದಿ.
exhibit my lord.
ಒಂದು ನಿಮಿಷ. ಖರೀದಿ. quotation ನಂಬರ್ 183. ದಿನಾಂಕ 6/7/93.
Exhibit my lord.
Exhibit P5. ಏನ್ ಸರ್ವೆ ನಂಬರ್ ಇದು?
ಇದು 258 my lord.
ಬಾರ್ ಎ.
ಬಾರ್ ಎ.
ಇದೆ. ಕಾಲಮ್ ನಂಬರ್ 11 ಇದರ ಹಾಕೊಳ್ಳೋ ಗುಣಗಳು.
ದಿ
ಖರೀದಿ. quotation ನಂಬರ್ 183. ದಿನಾಂಕ 6/7/93. Whether you have pleaded anything in this regard?
No, my lord. And this these Imam Saab, Tande Baba Saab is my brother. They are family members, my lord. Imam.
Sale deed dated 7/93. There is no pleading.
No, there is no pleading. What I have sought for clarification from the third person.
Every record iದ್ಮೇಲೆ you have to say something about this entry.
The first name is the brother of the
Peer Saab. Peer Saab ಅಂದ್ರೆ ಯಾರು?
Peer Saab, not related to my family member.
ಅದೇ.
He is not related.
He has purchased.
In the year 93.
Allah, but there is no sale deed, my lord.
ಅಲ್ಲ ನಂಬರ್ ಇದೆ ಅಲ್ಲಿ.
It is mutation number, my lord. Sale deed number.
Quotation number. Sale deed SR number.
Already 2019 ಅಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿದೀರಾ? You don't want to prefer an appeal?
No, my lords, with a fair submission, I have been made my best efforts to consult with the client, Your Honor, but even for today, he was not in front of me.
So in respect of that remaining 10 acres,
Yes, ma'am.
there is nothing at all, no reasoning, no finding,
No
nothing.
reasoning, no finding, my lord. And
Their property, 6 acres, 10 guntas have been sold in favor in their.
They should come and produce document, my lords. I have.
ಮುಟೇಶನ್ ನಂಬರ್ 183 ಹಾಜರು ಮಾಡಿದಿರಿ.
ಯಾವ ಸರ್?
ಮುಟೇಶನ್ ನಂಬರ್ 183 ಅಂತ ಇಲ್ಲಿ ನಮೂದಾಗಿದೆ.
ಅಲ್ಲ, mutations we have not produced.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ ಮಾಡಿ.
ಅದು ತೆಗೆದು ಸಿಗುತ್ತಿದೆ. ಆ
ಅಲ್ಲ,
mutation
my
number-
appeal is restricted only in respect of suit item number 2, my lords. That is in respect of suit item number 3. I am aggrieved by only.
258.
ಇಲ್ಲ, I am aggrieved by survey number
ಅಲ್ಲ ಸರ್ವೆ ನಂಬರ್
236 ಅಷ್ಟೇ. To that extent, I have preferred appeal.
So,
Those survey numbers are not. I have not sought any relief in my appeal, my lord. Only suit item number 2.
Not worry.
236. Survey number 236, measuring 20 acre, 15 gunta.
Your Honor, my lords, if as
Exhibit
pertaining to
P4,
that ambiguity, I can have a document.
Yes, my lord. In that,
As pertaining to 236, I have got a document to remove the ambiguity of
236.
236. Certified copy.
How are you concerned with 236?
In fact, Your Honor, the Bahu Sahab and my father, the respondent number 8 father.
Allah, today, he is saying this appeal is restricted only
236.
236.
Yes, sir.
You are not purchased 236.
No, Your Honor. But I have got a half share in that.
Yaru?
Inami land, sir.
that is
It's an
father of
Inami land.
plaintiff.
ಇನಾಮದಾರ ಇದು ಎಕ್ಸಿಬಿಟ್ P4 236 ಸರ್ವೆ ನಂಬರ್.
Baba Sahab,
Totally 20.
Imam
20
Sahab.
acres, 11 gunta.
11 ಇನಾಮದಾರ.
Idena? This is the property in dispute now.
Yes, my lord. The father of the plaintiff name is appearing in column number 9 and 12. Baba Sahab is father of plaintiff, my lord. Baba Sahab is.
He was the inamdar.
He was the inamdar of that.
Inamdar.
Yes.
So total 20 acres, 11 guntas.
11 guntas.
Inamdar ಆಗಿದ್ರೆ, after the Inam's Abolition Act was brought into force, you are required to file a declaration. The Inamdar is required to file a declaration. Isn't it? Otherwise, the property will go to the government.
Since I presume that such declaration was filed, therefore the land is still vesting with the family of the plaintiff.
They have not produced that relevant correct year extract of 2014. ಇದು ಹಳೇದು. 2014 ದ ದಾವಾಕಿದೆ.
Yes, madam.
Whether you have produced the RTC extract pertaining to this land.
14 ಇಂದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ ಸರ್.
ಇದೆಲ್ಲಿ ತೋರಿಸಿ. ಇದರ 14 ಅಂತ ಇಲ್ಲ.
238.
2014 ದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
Yes, madam.
2014 ಈ ಸರ್ವೆ ನಂಬರ್ 236.
203. Exhibit P6, madam.
ಲಾಳೆ ಸಾಬ್ ಹುಸೇನ್ ಸಾಬ್.
He is unknown to family of the plaintiff.
Respondent number 8.
One portion, another exhibit P7. 10 acre 14 gunta, standing in the name of defendant number 2.
ಅಲ್ಲ ಇದು ನಮೂನೆ ನಂಬರ್ 6 ಆಯ್ತು.
ಇದು holding.
RTC extract ಇಲ್ಲ. ಇದು ಫಾರಂ ನಂಬರ್ 6.
That is holding, madam.
Respondent number 8.
Also is purchased then.
Illa sir, purchase alla. It's an Inami land which has been granted in both of the names. Lale Sahab and appellant's father's name. It had been granted by.
ಅಂದ್ರೆ
Purchase ಮಾಡಿದಿಲ್ಲ sir, it had been.
ಅದೇ correct, land tribunal.
Please, sir.
So applications were filed
Yes, sir.
before the land tribunal. Baba Sahab,
Babu Sahab and my father Hussain Sahab were the real brothers.
the applicant was Baba Sahab.
Yes, sir.
Father of plaintiff.
Father of applicant.
Huh?
Father of plaintiff.
Father of the plaintiff.
Yes.
One day.
Imam Sahab had
Two sons, sir. By name Baba Sahab and Hassan Sahab.
Baba Sahab and Hassan Sahab.
Yes, sir.
Hussain Sahab is dead now.
ಹೌದು.
20 ಎಕರೆ ಅಂತಲ್ಲ
ಅಲ್ಲ ಬಟ್ ROR ಅಲ್ಲಿ 20 ಎಕರೆ ಸರ್.
ಅಲ್ರಿ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್
The ROR shows that
10 ಎಕರೆ 11 ಗುಂಟೆ ಮಾತ್ರ ನಿಮ್ ಫಾದರ್ ಆಗಿರೋದು, ಇನ್ನು 10 ಎಕರೆ ಲಾಲಾ ಸಾಬ್ ಕರೆಕ್ಟ್ ಇಬ್ಬರಿಗಾಗಿದೆ ಇದು.
ಸರ್ ಈಗ in that event the alleged gift
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 8 ಮೇಲೆ 10 ಎಕರೆ ಇವ್ರ ಹೆಸರಿಗಾಗಿರೋದು ಬರೀ 10 ಎಕರೆ.
the following are declared to be occupants of the land mentioned against their names. Baba Sahab, 10 acres, 11 guntas. Lale Sahab, that is your claim,
Yes, sir. Respondent number 8.
10 acres.
10 ಎಕರೆ ಗಿಫ್ಟ್ ಮಾಡಿದ್ರು, 10 ಎಕರೆ ಇವ್ರಿಗೆ ಇದೆ ಅಲ್ಲಿ ಸರಿ ಇದೆ.
kindly come to exhibit P16, my lords.
You are suppressed all these things. Sir.
Yes, sir.
Those facts are not in the knowledge of the plaintiff, my lord. I have filed. Like, on the inquiry, even notices are issued, my lords. They had been given sufficient opportunities. They should come and appear before the trial court and file necessary objections. Not that, it's not that I have not made them a party. They have been made party.
ನೀವು 2019 ಅಲ್ಲಿ ವಕಾಲತ್ ಹಾಕ್ಬಿಟ್ಟು you are simply keeping quiet. You know there is an ex parte judgment.
My lords, that's what I have been making in fair submission before the honorable court.
ಬಿಡಿ ಹಂಗಾದ್ರೆ, if your party is not
Kindly come to
interested,
exhibit
what can we-
P16, my lords. Exhibit P16 is a compromise petition. Copy of plaint filed by the defendant number 192.
Anyway, if you are seeking that you also have a share,
Yes,
court is required to consider all these aspects.
yes, my lord.
That is why the other parties are keeping quiet. They know
No.
this is what has happened. That is why they are not asking for any share. You are
Their
suppressing
name-
all these facts, although you know.
No, my lord. Their names are entered in the revenue records.
ಯಾರ್-
Defendant
ಯಾರ್
number
ಹೆಸರು?
1, 2 to 7. My family members' names are admittedly in the revenue records.
In respect of
In respect of portion of lands, not in the entire,
only 10 acres, 11 guntas.
not in that survey number 10 acre 11 gunta. In another survey number, their names are entered.
Sir, we are not concerned with others now.
No.
You said this appeal is confined only to
Survey number 236.
236.
Yes.
So we are asking these questions only in respect of that property.
If the said document is to be believed, my lord, then exhibit P16 goes to show that gift has taken place to the extent of 10 acre 14 gunta. Whereas the said document before the honorable court is
11
for
gunta.
10 acre 11 gunta. Then this gift, alleged gift is invalid.
Yeah.
Because if
To what extent?
to 10 acre 11 gunta,
Only three guntas. Adu, not you. They have to raise objection.
it's not,
Not you. How it cannot become invalid because 3 guntas in excess of what was
when I am
granted by the
when I am-
tribunal has been gifted.
my submission is, my lords, when I am incompetent to alienate the said property because I am not the owner to the extent of 10 acre 14 gunta. If that document is to be believed,
Yeah.
then
In respect of 3 guntas, who can raise objection?
but this, first of all, this
Who can
gift
raise
itself-
objection?
first of all, this gift itself is invalid. This is my claim. I have approached
That, that is a different aspect. We were asking all these questions because we were surprised when you said
Yes.
nothing has been said regarding the remaining extent of the land.
in the judgment.
Why ಅಂತ ಕೇಳಿದ್ರೆ ಇವಾಗ ಇದೆಲ್ಲ ಬರ್ತಾ ಇದೆ ಹೊರಗಡೆ.
These documents are for the first time produced before the honorable court. That too after a period of 15 to 16 years. I don't know what prevented the defendants from filing those documents before the trial court. This document, even the said copy of said document is not served upon me.
This order is passed in 84, 27th of March 1984.
Before that,
sir.
27th of March 1984.
Oh. So
Order has been passed by the
But-
tribunal.
ನೀವ್ ಹೇಳೋದು 80ರಲ್ಲೇ ಗಿಫ್ಟ್ ಕೊಟ್ಟಾರ.
that is as per the compromise decree.
So
ಅಲ್ಲ ಅದನ್ನೇ.
ಅವಾಗ 10 acres 14 ಗುಂಟಾಸ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
Yes, ma'am.
That has taken place prior to this order.
So when he was not owner, then
Sir,
ಅಲ್ಲ, ಇವಾಗ ಇನಾಮ್ದಾರ್.
his father was the inamdar.
plaintiff's
Entire
father.
extent of land 20 acres 11 guntas.
I don't know what document is before the honorable court, my lords.
This
That
is an
copy
order
itself
passed
is
by
not,
the
sir.
land tribunal.
Because I have not gone through the said document, I am unable to.
Without verifying all these facts, you have simply filed a suit.
I have clearly mentioned in
That
my.
is why the others have kept quiet without saying anything in respect of the remaining extent of land. Anyway. So, since your client is also involved in this survey number also.
Please.
We do not know what you want to do, you do. Let us see. We will consider the claim of the appellant. 2019 ಅಲ್ಲಿ ವಕಾಲತ್ ಹಾಕ್ಬಿಟ್ಟು ಸುಮ್ಮನೆ ಕೂತ್ಕೊಂಡ್ರೆ ನಾವೇನ್ ಮಾಡೋದು? And you have all this information with you.
ಇದು 14 ತಂಡ.
And you are keeping quiet. Lord will not help someone who is sleeping over his rights, sir.
I do consider.
Courts cannot come to your rescue. You do whatever you want. We will consider the appeal. Really?
Yes, sir. Since the alleged gift between the father of the plaintiff and mother of the plaintiff has not been established in accordance with law, and it has not been proved, it is only on the basis of the compromise decree entered between the defendant number 1 and 2. The defendant number 2 is claiming the right of title over the suit property, item number 2. Since the defendant number 1 and 2 have not adduced evidence recognized under law to prove that oral gift has been affected accordingly, my submission is the observation of the trial court that the compromise decree in OS 337 of 2001 is automatically holds good.
ಓದಿದ್ರೇನ್ರಿ ಜಡ್ಜ್ಮೆಂಟ್ ಪೂರ್ತಿ ಓದಿದ್ರೇನ್ರಿ? What have they said in respect of the remaining 10 acres of land?
My lords, I have not seen.
Which is actually your property.
Yes.
Nothing is said?
ಕಾತೂನ್ ಬಿ ಅದರಲ್ಲ.
Khatun be present, defendant number 2. Sister of,
Appear ಆಗಿಲ್ಲ.
they have a list.
ಇವರು ಮೆಹಬೂಬ್.
Sir.
ಮೆಹಬೂಬಿ.
Mehboobi, she appeared and filed written statement. My lords. It is consent written statement. She has admitted the claim of the plaintiff.
Contempt. They have suppressed the facts and obtained the both are proven. Fraudulently obtained this.
That is what has been challenged.
The decree itself is challenged.
She has filed written statement.
In spite of the compromise decree, she has filed this written statement. Denying that,
She has
Allah,
entered.
if I am permitted, I will read the written statement, my lord.
Entered it.
No, in the written statement, now she is saying, no, I don't know, I have not entered into any compromise.
Allah, she says that, my lords, I have never executed gift.
Howದು?
Para number 5 of the written statement of defendant number.
So it still remains as an agricultural property.
Yes, my lord, still agriculture property.
That compromise decree was in OS 337 of 2001.
2001.
What is this 222 of 2003?
That suit is filed by defendant number 3 to 6, challenging the compromise decree.
Oh, they have also
They have also challenged the compromise decree, my lord. That suit came to be dismissed. Neither of the
non-prosecution.
No, my lord. On merit, it has been dismissed. They have contested and the matter was heard completely and it was dismissed, holding that compromise decree is valid.
On what grounds?
On the ground that the defendant number 7 have deposed in the said case that my father has gifted the property in favor of my mother, the brother of the plaintiffs in the present case, have also deposed in favor of the mother. The defendant number 1 to 7 got partitioned the suit properties among themselves without bringing the fact to the knowledge of the plaintiffs. Only after it came to the knowledge of the plaintiffs that they are denying the rights of the plaintiffs, they approached the village and they have filed the present suit. Page number 43 of US 222.
Oh, the mother now says, my husband did not gift it to me. So
Yes, ma'am.
therefore, where is the question of me gifting it to my daughter?
Yes, ma'am.
That is our stand now.
He is ready to give all the share to all the children.
I have, it is submitted that in the lifetime of my husband, he has never gifted me the said property in any manner. Hence, there was no occasion to gift the same to defendant number 2 by me in any manner. He has taken that stand now.
Yes.
But there is a compromise decree.
Compromise decree, but I am not a party to those proceedings.
Now we are also looking at it from the stand now taken by the mother.
Yes. At that point of time,
he has taken a stand. In the compromise petition,
in the 2001 manner.
Correct.
ಅದರಲ್ಲಿ ಗಿಫ್ಟ್ ಅಂತ ಇದೆ.
Correct. ಎರಡು ಕೇಸಲ್ಲೂ ಕೂಡ earlier both the suits she has said yes, my husband has gifted it to me and I have gifted it to my daughter. Illi now she is taking a stand that illa ನನ್ನ husband ನನಗೆ ಕೊಟ್ಟಿಲ್ಲ. That will be in tune with what you are trying to say.
Yes, madam. All the children are entitled in the written statement she has detailed.
ಇದರಲ್ಲೂ ನಾವು 10 ಎಕರೆ ಅಂತಲೇ ಹೇಳೋದು 20 ಎಕರೆ ಅಂತ ಹೇಳೋದು.
ಅಲ್ಲ ಸರ್, that
ಅಲ್ಲ ನೀವು ಏನು
as per the
ಮೆಟೀರಿಯಲ್ಸ್ ಇದೆ ಇಲ್ಲಿ. He has stated in a written statement, defendant number 1, Mehabubi, mother, Khatunbi.
Those documents,
ನೀವು ಹಾಕಿರೋ
exhibit my lord.
10 ಎಕರೆ ಇದು ಅಂತಲೇ ಇರೋದು. ಗಿಫ್ಟ್ ಕೊಟ್ಟರೆ 10 ಎಕರೆ ಅಂತಲೇ ಇರೋದು.
ಅದೇ ಸರ್, 10 ಎಕರೆ ಅಂತ that gift is challenged.
ನೀವು ರಿಮೈನಿಂಗ್
10 acre
ಏನು ಇಲ್ಲ ಮೆಟೀರಿಯಲ್ಸ್.
That property till 1987-88 stood in the name of Baba Sahib.
Oh, see, judgment paragraph number 6, Kannada version tegiri. English ಅಲ್ಲಿ, you see now it appears that all of you are now colluded to take away the rights from this person. You see paragraph number 6 of 6. Defendant number 3 has filed return statement 3 to 6.
ಎಲ್ಲars of brother of plaintiff, my lord.
ಸೇರಿದ ಆಸ್ತಿಗಳಾಗಿ ಒಪ್ಪಿಕೊಂಡಿದ್ದರೂ ಸಹ ಸದರಿ ವಾದಿಯರು ಸರ್ವೆ ನಂಬರ್ 236ರಲ್ಲಿ ಮಾತ್ರ ಇಚ್ಚೆಯನ್ನು ಪಡೆಯಲು ಅರ್ಹರಿದ್ದು ಉಳಿದ ಆಸ್ತಿಯಲ್ಲಿ ಇಚ್ಚೆಯನ್ನು ಪಡೆಯಲು ಅರ್ಹರಿರುವುದಿಲ್ಲವೆಂದು ಸದರಿ ಮೃತ ಬಾಬಾ ಸಾಹೇಬ್ ಅವರ ಜೀವಿತ ಸಮಯದಲ್ಲಿ ಆವಾಸ್ತಿಯನ್ನು ಯಾವುದೇ ರೀತಿಯಲ್ಲೂ ಸಹ ವಿಲೇವಾರಿ ಮಾಡಿರುವುದಿಲ್ಲವೆಂದು ಹಾಗೂ ದಾನವಾಗಿ ನೀಡುತ್ತಿಲ್ಲವೆಂದು ಆದ್ದರಿಂದ ವಾದಿಯರು ಸರ್ವೆ ನಂಬರ್ 230ರಲ್ಲಿ ಮಾತ್ರ ಇಚ್ಚೆಯನ್ನು ಹೊಂದಲು ಅರ್ಹರಿರುತ್ತಾರೆ ವಿನಃ ಸರ್ವೆ ನಂಬರ್ 222 ಮತ್ತು 258ಗೆ ಯಾವುದೇ ಇಚ್ಚೆಯನ್ನು ಪಡೆಯಲು ಅರ್ಹರಿರುವುದಿಲ್ಲವೆಂದು ಸರ್ವೆ ನಂಬರ್ 250.
Now they are also trying to support the plaintiff.
They are supporting their property, my lord. They are not
See, you have also not filed any appeal in respect of the other properties. You have filed this appeal only in respect of survey number 236.
Those properties have been decreed in my favor, my lord. Those properties have been decreed.
Howda?
Yes, my lord.
All the items.
There are 3 suit items. Item number 1, 2, and 3. Item number 1 and 3 have been decreed in my favor. Therefore, I have not preferred any appeal in those properties. Item number 2 has been denied by the trial court. Therefore, in respect of that, I have preferred the appeal.
ಸರ್ವೆ ನಂಬರ್ 236 ಬಗ್ಗೆ ಮಾತ್ರ ಇದೆ.
ಹೌದು ಅಷ್ಟೇ. The extent of 10 acres. That is why the contention, even in the earlier suits, and the issue is only regarding 10 acres, 14 muntas. Why it does not raise any claim regarding the remaining 10 acres is because of this. All of them know that 10 acres occupancy rights have been conferred in favor of defendant number 88. That is why none of them are raising any claim in respect of that. But only the plaintiff is trying to raise a claim now. And this person has not participated. And now he is brought to the notice of this court. So opportunity is required to be given. Clearly, we will accept his contention that in terms of the judgment of the Supreme Court, as per the material available on record, the trial court could not have come to a conclusion that the gift has been acted upon. Because admittedly, they continue to be in occupation of the house, this property jointly. But it's an agricultural land.
Yes, madam.
How do we say anything regarding possession?
At least mutation entries or revenue entries would have been taken place if the alleged gift had taken place. It's till death of the father of the plaintiff, it stood in the name of the father of the plaintiff itself. After his death, the mother got it mutated in her name. If the alleged gift was supposed to be true, then she should have affected her name in the revenue records much prior to death of the father of the plaintiff.
I will say and bring material on record and to reconsider this aspect of the matter. We can demand the matter.
Please.
Avaga ಒಂದು opportunity ಸಿಗುತ್ತೆ.
Please.
Please. You can place all this material And since the argument is confined only to this property,
Please,
you can show this copy of this order.
please.
Say 10 acres occupancy rights have been conferred and no one has challenged that order.
Order.
That has attained finality.
Yeah, finally.
That cannot be questioned before a civil court.
Please,
That you take that stand.
please.
Regarding the remaining 10 acres and 11 guntas. 10 acres and 11 guntas, we hold that the trial court could not have come to this conclusion having regard to the judgment of the Supreme Court. ಮಾಡಿ reconsider ಮಾಡಿ ಅಂತ ಹೇಳಿ.
Only in respect of suit item number 2, my lords. Otherwise, all the people who have
Only in respect
again,
of
it
item
will lead to
number
multiplicity of litigations.
Only survey number
236, yes. Item number 2, my lord.
Item
Item
number.
number.
236, 20 acre,
15.
15.
And court has said nothing.
they are not expressed anything.
And even in the judgment, court has said nothing about the remaining
Therefore,
10 acres of land. So in order to give opportunity to all the others, including
Please.
defendant number 8, matter stands remanded.
Kindly one submission, my lord.
Yes.
Only in respect of servant of 236.
Say there. Only in respect of item number 2.
Yes.
Because you are aggrieved only in respect of
Item number 2.
item number 2.
Yes.
Your
Gift,
rights
alleged
were denied.
Yes.
Huh?
In view of that document, whether you are going to prosecute this case or not.
Life,
ಅಲ್ಲ,
that
ಹತ್ತಕ್ಕೆ
document,
ಓದ್ ನಿಮ್ದು ಪ್ರಕಾರ.
then
ಇಪ್ಪತ್ತೈದು
in
ಕೇಳಿದೆ.
respect of servant number, to the
ಅಲ್ಲ,
remaining extent may be decreed, my lord.
Remaining
Remaining extent may be
ಇಲ್ಲ.
decreed,
ಅದ್ರ ಬಗ್ಗೆನೆ.
ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡೋ ಅಗತ್ಯ ಇದೆ ಇಲ್ಲ ಅಂತ ಅವ್ರೆಲ್ಲ ಇದ್ದೀರಿ.
may be decreed by the honorable court.
They can, you,
If the said document is genuine, my lords, I have not seen, the honorable court may decree my suit to that extent, remaining extent may be decreed. 10 acre,
ಈಗ 10 ಎಕರೆ ನಿಮಗೆ ಗೊತ್ತಾಯ್ತಲ್ಲ ಈಗ.
yes, madam. He has been
20 ಎಕರೆ claim ಮಾಡಿದ್ರೆ. ಇನ್ನು 10 ಎಕರೆಗೆ ನಿಮ್ಮಲ್ಲಿ ಏನು ಡಿಫರೆನ್ಸ್ ಇದ್ದಿದ್ರೆ, you can withdraw this appeal.
That gift itself is illegal according to plaintiff's, my lord.
ಆಯ್ತು, gift ಆಯ್ತು.
ಅಲ್ಲ ಅದೇನಾಗಿದೆ ಇವಾಗ that remaining extent has been
In favor of-
gifted in favor of defendant
One of the
number
sister.
2. ಅವ್ರಿಗೆ
Kakungi.
ಹೋಗಿದೆ ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿ.
ಅಲ್ಲ, ಅವ್ರು
ಅದರಲ್ಲಿ
Adರಲ್ಲಿ we have been denied here.
difference ಇದೆಯಲ್ಲ.
ಇದೆ ಇದೆ
Difference ಇದೆ.
ಅವರಲ್ಲಿ ಡಿಫರೆನ್ಸ್ ಇದೆ.
We have challenged the alleged gift, that to that extent matter may be remanded.
Please,
ಹ್ಮ್
please.
Pass order.
Memo ಆಯ್ತು.
ಕೊಡ್ರಿ ಒಂದು ಮೆಮೊ ಹಾಕ್ಬಿಟ್ಟು ಕೊಡ್ರಿ.
Please, move.
Xerox ಒಂದು
Please. Please.
memo along with document ಅಂತ.
ಕೊಡಿ ಒಂದು ಮೆಮೊ ಬರ್ದು ಕೊಡಿ.
Please.
ಕೊಡ್ರಿ ಒಂದು ಪೇಪರ್ ಕೊಡ್ರಿ. Heard reserved.
Okay.
Yes.
ಈ ವಕೀಲನಲ್ಲಿ ಪ್ರೇಯರ್ ಬರೀ ಮಾಡಿಫೈ ಅಂತ ಕೇಳಿದೆ. ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ ಅಲ್ಲಿಂದ ಇಲ್ಲಿ ಇದರಲ್ಲಿ ಮಾಡಿದ್ರೆ ಸರ್.
Modifying the order.
By allowing the appeal.
ಅದು ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಬಗ್ಗೆ ಇಲ್ಲ ಬಾಡಿ ಆಫ್ ದಿ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಪೀಲ್ ಹೇಳಿದೆ.
ಇಲ್ಲ, in my memorandum of regular first appeal at para number 3, my lords, that the parties herein are referred adರಲ್ಲಿ last 4 lines. The appellants in respect wherein the suit of the appellants was partly decreed by allotting 1/8 share each to the appellants in respect of 2 scheduled properties and did not allot the share in other suit property, against which And to that extent, the appellants are submitting this regular appeal. Already.
$230 madam.
Case number 55.
Memo with one document is filed. Council has tried. Memo with one certified copy of the order.
Yes, yes. I'm submitting it.
Order sheet. Order sheet.
230 first. One. Number ಕೇಳಿದ್ರೆ ಎಲ್ಲ ಬಿಟ್ಟು ಅದೊಂದು 55 that is. With your lordships kindly, my lords.
Yes, yes.
Once my learned friend Navinath completes, my lord, I'll just take for 10 minutes to take the stand of the state government, my lords, in this matter.
Yes.
I think it'll take another half an hour. After that, I'll just make
Yes,
my
yes.
submission.
Yes, yes.
I would request for my lord, Lord, let them complete, my lord. I would request, my lord, day after tomorrow, I will make my reply, my lord, to the submission.
ಏನ್ರಿ ರಿಪ್ಲೈ ಕೊಡೋದಕ್ಕೆ ಮತ್ತೆ ಇನ್ನೊಂದು
ಯಾಕಂತಂದ್ರೆ there are, my lord, ಆಯ್ತು ಮುಗಿದ್ಮೇಲೆ
let us see. Yes.
Lord, your lordship recollects, Lord, I had broadly argued that the concept of a beneficiary is not applicable to a case like this. Because Lord, I explained, Lord, my argument was that this is a case of an assignment. Because the original public purpose continues to be there, and that is just assigned to us. And the test that is to be applied is
There
a
are
test.
at least two judgments of the Supreme Court
That's right.
which you relate upon.
One Supreme Court judgment, the other was a Bombay High Court, the division bench, which actually explained the whole concept of assignment elaborately.
Yes.
So, my lord, that being the position in law, my lord, because Supreme Court judgment, as your lordship rightly says, was also a case where at the time of acquisition, that entity was not in existence. It was created subsequently, and thereafter, my lord, that was also the case where the court said the mere fact that the successor in interest came into being subsequent to the acquisition is of no relevance. So that boils down to the only test that is to be seen is who pays the compensation. And that is the underlying principle under section 3BB, AA, that is person interested. So, my lord, it is not disputed that the payment of compensation is made by us. My learned friend relied upon some of the documents that I've supplied to, my lord, furnish to show that the
You are
special.
again requesting the government to
Exactly.
make the payment.
So, my lord, I'll take your lordship through that. What the SLAO says is that, see, there are these adjudications. The amount is required to be deposited. You please deposit the amount, that is to us. And then there is a response to us where we say that, yes, we are looking into the matter. And there is another letter, my lord, those are in the second compilation filed by us, my lord, where we say, where the SLAO himself says, you take legal advice and see what is to be done. So the fact of the matter is that the SLAO sits in my office is absolutely of no consequence, because your lordship looks at the larger legal position that the state exercises the power of eminent domain. There is no concept of Nigam having a special land acquisition officer. Because, my lord, I don't have the power of eminent domain. That is a power to be exercised by the state and the state alone. So for the purpose of administrative convenience or whatever efficiency, my lord, we have a government's representative sitting in our office. And, my lord, he does not have the authority to dictate terms to me, because my board is chaired by the chief minister of the state and also comprised of the irrigation minister, among others. So we take our own decisions. The SLO is, of course, under a duty to ensure that the compensation is dispersed to the landowners. That's the scheme under section 31, etc. So he will obviously be telling us that please deposit this amount. That doesn't mean that I don't go in appeal or I don't take it further. That's not the mandate. So, my lord, I wanted to now take your lordship, my lord, I was at that two judgments, Pirappa and Gupta's judgment, which dealt with what is the concept of a beneficiary. My lord, that is in my compilation, the first compilation, my lord. Now, my lord, Pirappa's judgment, my lord, I have to place because my No, I have filed. But look, I have filed a very comprehensive compilation. He has also filed a,
You have filed writ petition.
Correct.
no, writ petition was filed by me.
Passed an order in their favor. Huh? So let us see the.
My lord, I'll tell your
memorandum.
lordship, I'll just, my lord, there was a.
Where is the
order-
memorandum of writ petition?
Yes. Lord, that is at page 26.
That executive engineer belongs to KNNL.
Correct, that's mine. Lord, what actually happened was the appellate court.
Anyway, they have not raised such an objection. If they raise, then we'll ask for information. They are not raising that objection. Yes.
So, my lord, I'll just take your lordship through Pirappa. That is, my lord, in my compilation, my lord, at page 201.
Yes.
I'll just take you to the relevant, there are 4-5 paragraphs that I have to show. My lord, please see how the matter arose at page 209, para 6. My lord, sir, para 6, page 209. The appellant, represented by his legal representative, was the absolute owner of land bearing so and so. It is claimed that on 12/2/81, the predecessor Rajshri Cement Works, a unit of Ultratech, made a proposal to the state of Karnataka as respond to set up a cement manufacturing plant and applied for acquisition of an allotment of 1187 acres or 5 guntas of land towards setting up a factory, residential colony, etc. at Malkhed, Gulbarga. This fact is not supported by the original land acquisition record of the government and therefore before this court by the state government's council. Now we'll then come to para 9. On 7/6/1990, the state government took possession of the acquired land from the landowner and transferred the same to KIADB, which in turn allotted the same in favor of the company as per the provisions of the KID Act and the relevant provisions of the Karnataka Industrial Areas Development Board regulations. The appellant received the compensation under protest and made an application on 20/6/1982 to the Special Deputy Commissioner to make reference of the award to the reference code for enhancement of compensation under 18(1). The reference application filed by the appellant before the Deputy Commissioner under 18(3) of the Act was so-and-so was numbered as so-and-so. The Special Deputy Commissioner by supplementary awards dated 30/12/1992 and
Acquisition was made for the benefit of a company.
for the, under the KIDB Act, yes. Your lordship know under the scheme of the KIDB Act, the KIDB approaches the government issues a notification under 28(1), the land vests in the government. And then under 28(8), the land is then given to the KIDB by the state. And KIDB then, as part of that industrial development plan, will allot it to the end users who are the actual beneficiaries. And that too on commercial terms.
Correct.
So that's very important. So, my lord, your lordship saw all this, then please come to para 14.
Yes.
While the matter was yet to be heard by this court, the respondent state through KIDB filed review petition before the High Court. So and so, my lord, I'll just last line. Messrs. Ultratech Limited, through its unit, Rajshri Cements, filed writ petition number so and so before the High Court on so and so, questioning the correctness of the award of the compensation passed in favor of the landowners on the ground that they are necessary party to the reference proceeding before the reference court.
So that can be distinguishable.
My lord.
It's a distinguishable factor.
Correct, absolutely, absolutely. So that's the distinction.
Yes, yes.
And that is what the court has referred.
Yes.
No, I'll just, now that your lordship have understood, I'll just take your lordship straight to the relevant issues. Issues are at para 30 at page 217. And then, my lord, the reasoning. My lord, para 30, your lordship sees 217. Issue number 30.1 and 30.2 are the issues that we are concerned with.
Yes.
Whether the allottee either is a beneficiary or interested person entitled to hearing before the determination of market value. And then number 2 is whether the writ petition filed by the so-and-so is maintainable in law. Now, my lord, the reasoning, my lord, starts from para 63 onwards at page 227. No, rather, my lord, sorry, my lord, I'm sorry, my lord, para 49, lordship missing first. That's where it starts. Para 49. Page 222. My lord, your lordship finds that at para 49, there is a reference made to that lease deed executed between the KIDB and the Rashri and Rashri Cement. Now, this clause is extracted. The premium indicate, I'm reading the italicized extract.
yes.
The premium indicated in clause 1 of this agreement represents the tentative cost of land. In the event the lessor incurring the payment of amounts to the landowners over and above the awards made by the acquiring authority by virtue of awards passed by the competent court of law, or in view of the provisions of the Land Acquisition Act in respect to the demise premises or any part thereof, the same shall be met by the lessee within 1 month from the date of receipt of communication signed by the executive or other authorized officer by the lessor. Further, in the event of the lessor incurring the payment amounts to the landowners from the mulkis and structures existing on the demise premises, the same shall be met by the lessor within 1 month from the date of receipt of the communication signed by the executive member or any other officer authorized by the lessor. As soon as it may be convenient, the lessor will fix the price of the.
Come to the next paragraph.
Yes, my lord. Lordship want me para
On an examination.
on a careful
examination.
Yes, on a careful examination of the aforesaid clauses of the lease agreement executed between the parties in respect of the land of the appellant, it becomes manifestly clear that the said agreement is executed by KIDB in favor of the company after allotment of land was made in favor of the company as provided under Regulation 10A and C of the KIDB regulations respectively, by following the procedure for inviting applications and submission of applications by the interested parties along with the required deposits toward the cost of the land. Further, clauses 5A and B of the lease agreement referred to supra would clearly state that the premium indicated in clause 1 of the lease agreements represents the tentative cost of the land, and even in the event of the lessor incurring payments of amounts to the landowners over and above the awards made by the acquiring authority by virtue of the award passed by the competent court of law or in view of the provisions of the LA Act in respect to the demise premise or part thereof, the same shall be met by the lessee within 1 month from the date of receipt of communication signed by the executive member of so and so, so and so. Then para 51, from a careful reading of the aforesaid clauses of the lease agreement along with the provisions of section 32(2) of the KIDB Act and regulations 4710 BCD of the KIDB regulations, it is clear that the company is only the lessee by way of allotment of the land, and the same has been allotted by KIDB in its favor and has executed the lease deed in its favor in respect of the allotted land. In view of the aforesaid documents, namely the notification issued under 28(1) and 28(4) of the KIDB Act by the state government, it can be safely concluded by us that the acquisition of land involved in these proceedings is for the purpose of industrial development by KIDB in Saddam Taluk. Therefore, the beneficiary of the required land is only KIDB, but not the company as claimed by it. A reading of section 28(5) of the KIDB Act makes it clear that the land which is acquired by the state government statutorily vests absolutely in it. After following the procedure provided under section 28(6) and 7 of the KIDB Act, the state government takes possession of the acquired land from the owners, persons who are in possession of the land, and transfers the same in favor of KIDB for its development and disposal of the same in accordance with regulations so and so referred to supra. Then Lord 53. In the instant case, a perusal of the provisions of the lease agreement executed between the parties referred to supra
Yes,
and
we have
regulations.
understood this.
So, Lord,
That
this
is
is
the
tentative
distinguishing
cause.
factor.
So, your lordship sees, in this case, I step into the shoes of the state government, because here the KIDB is only somebody who has been given this land by the state. Now here, by virtue of assignment, it is lock, stock and barrel, the project, the land, assets, liabilities, everything is vested in me by the state government by creating the government company. And I pay the compensation. I generate my own resources. I may take, Lord, your lordship asked me that pertinent question. But there are grants, money is being given to you by the government. And I explained to that, Lord, all those monies are converted into equity. So the equity of the company keeps growing because whenever the government gives me that grant, it gets converted into equity. So, my lord, so this is clearly distinguishable. And my lord, the conclusions are at para 63 to 65. I'll not trouble your lordship because we have covered. Now, the second judgment, my lord, is Gupta. That is, my lord, that is again something similar. 235. It's a short judgment. I'll just refer to two or three paragraphs. Lord, it starts at 235. Your lordship may come to 238. Para 2. Now let's just have a look at para 2. The question for consideration is whether a post-acquisition allottee of land is necessary or proper party or has any locus to be heard in the matter of determination of compensation under the scheme of the Land Acquisition Act. If not, whether the impugned order permitting additional evidence and directing remand is sustainable. Well, I'll just read this back.
This is what is sought to be relied by
them. They rely on these two judgments principally to say that being a beneficiary, I am not entitled to be heard. This is the two judgment that he's citing.
Yes.
And my lord had also, Justice Basavaraja's order. I have to say something on that also, because my learned friend was not being fair to the court. In that case, my lord, your lordship was not told that the relied upon order in turn relied upon one particular LAC number, which the Supreme Court had set aside, said that you can't rely on that. And this was after the Supreme Court's remand order of 2022. My learned friend, being the counsel appearing, should have told this court that the reasoning adopted in all these series of cases, this cascading links of judgment, the reasoning has been set aside by the Supreme Court in the remand order. He should have fairly told that to your lordship. So, my lord, para 3, my lord, I just wanted to show the only distinction here was from Pirappa, as your lordship saw, was a case of an allotment by lease. Here it was by a conveyance. The allottee, my lord, that's the only distinction, but the reasoning remains the same. So I don't want to trouble your lordships on that also. So, my lord, this will take care of both these judgments.
Point out to that fact.
Yes, my lord, just para 3. Para 3,
yes.
if I'll just read this. The facts giving rise to the question may briefly be noted. Huge chunks of lands were acquired by the state of Haryana in different phases for the public purpose of setting up model industrial township by the Haryana State Industrial Development Corporation in Gurgaon. In Haryana, substantial part of the land was allotted to HSIDC to Maruti Suzuki. One of the clauses in the conveyance deed executed in favor of the allottee provided that if compensation is enhanced, the allottee shall be liable to pay additional price on that basis. So this was by a conveyance. So, my lord, that's the distinction. Now, my lord, what your lordship also finds here is that the enhanced amounts are not paid by way of compensation. It is paid to the allottee as an additional price that he has to bear. Because why? The allottee doesn't pay the compensation. Compensation is paid by the state. So as far as the allottee is concerned, his liability is an additional price that he has to bear. So that makes a significant distinction. So, my lord, now, my lord, I'll just take you to the relevant clauses of the memorandum.
Lordships kindly, my lords. If I may add one, just to not to.
You got muted.
Yenaithu?
You got muted.
Correct.
With your lordships kindly, my lord. ಇದರಲ್ಲಿ KDB in these judgments, the allotment price compensation is one of the criteria for fixing of the price. Other criteria is development of the layout, 20% charges, various other charges are collected to the allottee, my lords. The compensation is one of the components which is given, whereas the KDB or the state pays compensation to the landowners directly. So the allottee stands on a totally different footing, my lord, because, for example, BDA allottee, tomorrow he cannot say that, or the KDB allottee, he has nothing to do with the compensation aspect, my lords.
So
That is a distinct.
Even in respect of allotment of residential sites at
Correct.
the hands of development authorities,
Correct,
even
my lord.
there, the initial amount is fixed.
Correct.
And it is clearly stated that depending on the final acquisition cost, the price will be refixed.
Acquisition
Therefore,
cost and development cost also, my lord. For example, they
If
delay.
the price is refixed, then you will have to pay the additional cost. So
Additional
such
cost.
conditions are there even in the development authority. That
Correct,
would
my
not
lord.
give a right to the person seeking allotment of a site
Please.
to challenge the
Compensation.
enhancement of compensation.
If you want, you take it, otherwise you leave it. The principle is, if you don't like the price or allotment.
They are not contracts for a fixed consideration. These are in exercise of the power of eminent domain, whether it is acquisition for the purpose of housing development. These are all part of a larger scheme of development. So the state exercises that authority because ultimately, my lord, these have consequences. Now, my lord, having said that, my lord, I'll just take your lordship quickly to the memorandum and articles. my lord, that is part of the very same compilation. If your lordship looks at my objects, my lord, my lord, starts at page 9. At page 10. Just to show your lordship that this is essentially a special purpose mechanism for raising funding, etc. Now, please have a look at page 10. The objects incidental and ancillary to the main objects are to, my lord, the main objects being irrigation project that your lordship sees at page 9. Plan, investigate, estimate, build, operate, maintain, etc., etc. Lord, all those, this is what we get from the government, what we are supposed to do. And then, Lord, the incidental objects, please see 1. Acquire and hold such movable and immovable property as it may deem necessary and to lease, sell, or otherwise transfer any such property. Then, Lord, 2 is build dams, etc. I'm not, come to clause 6. Meet the operation and maintenance cost of the corporation as far as practical from the water rate demands raised on the government of Karnataka for supply of water by the corporation to individuals and groups of farmers and others, including industries and statutory authorities like command area development authorities, town, city, municipal council, etc. Then 7 is opening current accounts, fixed rate deposits, overdraft and other accounts with any banks. Then 8, my lord, borrow or raise or secure the payment of money in such manner as the company shall think fit, and in particular by the issue of debentures or debenture stock, perpetual or otherwise, charged upon all or any of the company's assets, its uncalled capital and purchase, redeem or pay of any such securities. Then, my lord, clause 10, enter into partnership, that I am not, Lord, troubling your lordship. Come, Lord, please see clause 12. Enter into arrangement with any governments, my lord, this is interesting, or authorities, municipal, local or otherwise, or any person or companies in India or abroad that may seem conducive to the objects of the company or any of them, and to obtain from such any such government authority contracts, license and concessions. Then 13, alter, manage, develop, exchange, lease, mortgage, underlet, sell, give in gift or otherwise dispose or improve or deal with the land, property, assets and rights and resources and undertaking of the company or any part thereof for such consideration as the company may think fit, and in particular for shares, stocks, debentures or securities or any such other company having objects together or part similar to those with this company. Then, my lord, 15 is to incorporate other companies. Then, my lord, 18 at page 12. Sell, dispose of or transfer the business, property and undertaking of the company or any part thereof for any consideration which the company may deem fit to accept, and in particular of shares, stock, debentures, debenture stock, bonds or securities or other or any other company or companies for the purpose of its or other, or they're acquiring all or any of the property, rights and liabilities of the company or for any other purpose which may seem calculated to benefit the company. Then, my lord, a 19 again, sell, improve, manage, develop, exchange, lease, mortgage, dispose of, in turn to account or otherwise deal with any with all or any part of the property and the rights of the company. Then, my lord, 22 is lease, again leasing. Then, my lord, clause 29. Enter into arrangement with the government of Karnataka and or any state or central government undertaking or municipal or local authority or otherwise which may seem conducive to the company's objects or any of them, and to obtain from any such government, corporation or authority or any concessions, grants or decree rights or privileges whatsoever which the company may think fit or which may seem to the company capable of being turned into account, and to comply with the works, development, carry out, exercise and turn any accounts of such arrangements, concessions, grants, decrees, privileges, etc. Then, my lord, this is, my lord, this is this, and then 30, my lord, yes. Receive monies from the state government and the central government or other authorities for carrying out the functions of the company. However, the company shall not carry on any banking or insurance business. So I can receive monies from the state government or from the central government, because, my lord, if the central government has a national scheme for development, my lord, I am entitled to receive it. Now, then, my lord, comes, please have a look at the association, articles of association at page 16. Here, my lord, at page 18, clause 10, that is relates to issuance of shares. Clause 6. Yeah, my lord, I'm just sorry. My lord, page 17, clause 6. The company is a government company. So we are a government company, that declaration is here. And then, my lord, clause 10, my lord, which I wanted to shows that I have the right to issue shares. Then my lord, 11 talks about the power of the directors to allot shares. Then, my lord, one or two clauses here, my lord, please come to page 41. This is part of the Articles of Association. This is a power to litigate. My lord, please see 103 clause F at page 41. To institute, conduct, defend, compound, or abandon any legal proceedings by or against the company or its officers or otherwise concerning the affairs of the company, and also to compound and allow time for payment and satisfaction, etc. So we have this provision here. And then, my lord, being a government company, at page 47, the Comptroller and Auditor General's, my lord, oversight, that is the audit, my lord, clause at page 47. Clause 116, my lord, your lordship sees, the company shall at each annual general meeting appoint an auditor or auditors to hold the office from the conclusion of that meeting till the conclusion of the next annual general body meeting, or until the conclusion of the sixth meeting as may be provided. Then 170, notwithstanding anything contained above, so long as the company is a government company, it should be government company. The auditor or auditors of the company shall be appointed or reappointed by the central government on the advice of the Comptroller and Auditor General of India. And then, my lord, 118 again, the Comptroller and Auditor General's power shall have power as long as the company is a government company. And then 119, auditors shall submit a copy of their audit report to the Comptroller and Auditor General, who shall have the right to comment upon, supplement the audit report in such manner as may think fit. Any such comments upon or supplement to the audit report will be placed before the annual general module meeting of the company at the same time and in the same manner as the audit report. And then 120, as long as the company is a government company, the company shall forward to the government the audit report as also the comments upon or supplement to the audit report, if any, received by the Comptroller Auditor General of India. So, my lord, this gives your lordships an indication as to the kind of oversight we have. And your lordship would find that under the CAG audits are done in respect of autonomous bodies, where there is financial autonomy. That seems to be the underlying principle.
No, I think this next appendix B.
Yes.
Would be more relevant.
Appendix B.
Consideration, yes.
Which
page number 58.
380. Yes.
What was the manner of entrustment of this project?
Yes.
This is what is contained here.
Correct, correct.
Entrustment of Amaraja project.
Yes, that's right. So, my lord, there is a preamble and then the government order.
Yes.
So, your lordship notices this is of 18th of April 2005. Nigam was incorporated in 2003. Sorry, 98. And then, my lord, there is a prelude. My lord, the prelude shows that it's an ongoing project. So, the preamble is important because it shows that it's an ongoing project that is being transferred or assigned to us. So, your lordship is absolutely right. The preamble shows that it is not a I'm not a beneficiary. I am the entrustee, assignee. So the entire genesis of the entire project is also recorded in the preamble. And Lord, just see the operative part. It is hereby ordered that the irrigation, Amarja medium irrigation project under construction near so-and-so shall be transferred to the Niravari Nigam, so that the said project comes under the jurisdiction of the Nigam with immediate effect and until the further order with an instruction to the Nigam that all the works of the said project shall be completed during the year 2005-2006. All assets and liabilities relating to this project has been transferred to the Karnataka Niravari Nigam Limited from the day and the date on which this order has been issued. And Lord, the financial concurrence of the government has been obtained. And then, my lord, likewise, my lord, there are the other notifications, my lord, at page 63. Lord, your lordship will find that there are sub-parameters and certain other projects. Yes, for similar orders for other projects have also been issued, where there are a series of orders. So they follow the same pattern. They are all entrustment of ongoing projects which the irrigation department was managing, which has now been entrusted to us. So there is no consideration involved. My lord, if there was a consideration involved, maybe I could be held to be a beneficiary, and if I'm generating your lordship knows that in the memorandum articles, you cast it as wide as you can. There could be a profit generation motive. Ultimately, yes, if I'm a government company, I'm expected to also generate profits. So if there is an element of profiteering also involved, that doesn't denote the fact that I take responsibility for all assets, for all expenses and liabilities, etc. That's my responsibility. It takes time. My lord, the fact of the matter is, yes, we are still at a very slow pace, but eventually, when we mature as institutions, my lord, I'm sure, my lord, the government will also, with the support that the government has given us, we become more professional. We generate that income. The public exchequer, the government can focus its revenues on social welfare measures in a much more effective manner. So, my lord, I just wanted to show one more judgment, my lord. It's a very cryptic kind of a Supreme Court order, but it's a civil appeal. So, my lord, it has some. But interestingly, though the Supreme Court order is very cryptic, the High Court order which it set aside was a very elaborate order, which held against me. So, my lord, what had happened in this case was, my lord, there was a corporation like Irrigation Corporation established under an act. This is also, my lord, a matter from Maharashtra. So what happened was, my lord, the corporation, the statutory corporation, which was in existence at the time of the Section 4 notification, but it was not made party to before the reference court. There was, my lord, matters were going on in an appeal, and my lord, the learned single judge, my lord, rejected the application for leave made by the Irrigation Corporation, saying that, look, I am the beneficiary. I have not been made a party before the reference court. Therefore, please allow me to pursue this appeal. And here is my leave to permission for seeking leave. The single judge dismissed the application for leave by an elaborate judgment, which I have handed over, my lord, basically saying that you are not a local authority. The argument was made that, but there was an argument made by the corporation that we are also a person interested. And that is, my lord, recorded in the High Court order, but that was not dealt with. So the Supreme Court, by this rather short and sweet order, my lord, virtually encapsulates the issue in law. So your lordship may just have a look at that. Says Vidarbha Irrigation Development Corporation being the beneficiary as deposit. My lord, this is para 2, my lord. Yes, Supreme Court order I'm reading. Vidarbha Irrigation Department being a beneficiary has deposited the amount of compensation. Obviously, it could participate in the proceedings pertaining to the compensation. Thus, the High Court has erred in law in refusing the corporation's leave to file an appeal against the award passed by the reference court. Though the corporation could not seek reference under section, Lord, it's a mistype, which is 18 of the Land Acquisition Act, as against the award passed by the Land Acquisition Commissioner, but could definitely prefer an appeal against the announcement made by the reference court in the light of the decisions rendered by this court in Himalayan Tiles, Francis Victor Coutinho, Neyveli Lignite, UP Awas Nigam, Abdul Razak, etc., etc. As such, we set aside the order of the High Court and remit the matters to the High Court with the request to adjudicate the matters on merits in accordance with law. Interim orders by the High Court shall continue. So, my lord, the leave was granted, and the Supreme Court said that you give them the right to prosecute the appeal on merits. My lord, I just gave the High Court order because it's a very elaborately it discusses, but doesn't look at the issue of a person interested. Now, my lord, my learned friend had cited a Supreme Court judgment, which is part of his compilation. I need to, my lord, take your lordship through that. This is, my lord, the page 31 of my learned friend's compilation. This is, my lord, Srachi Bardhawan Developers Private Limited versus State of West Bengal. It's at page 31. Lord, I wanted to just distinguish this. Lord, here what happened was the Bardhawan Development Authority, like the BDA, acquired the land. And later on, by an unregistered document, the land was given for development to a private builder, the appellant before the Supreme Court. Now, what happened was, my lord, there were proceedings for under reference, and then there was my lord, in the reference, the compensation was enhanced considerably. So at that point of time, the development authority preferred appeals. The appeals were pending before the High Court. The builder filed a writ petition. The writ petition was heard by the learned single judge who allowed the writ petition while the appeals under 54 were pending before the same High Court. Now, against that, my lord, the landowners went in writ appeal. In the writ appeal, the appeal was allowed and the single judge's order was set aside. Now, it is in that context, my lord, challenging that order, the builder comes to the Supreme Court. Now, my lord, please see in this backdrop, what did the Supreme Court say? My lord, your lordship may see page 37, paragraph 8. Lord, may I read?
Yes.
So far as Civil Appeal 5856 of 21 is concerned, Sarachi Bardhawan filed a writ petition under 226 for the reliefs referred to herein above, and more particularly challenging the judgment and award passed by the reference court enhancing the amount of compensation. Appellant herein, Sarachi Bardhawan, was not a party to the reference proceedings. The locus of the appellant, Sarachi Bardhawan, has been seriously disputed on behalf of the landowners claimants, and it is seriously disputed whether the appellant Sarachi Bardhawan can be said to be a person interested within the definition of Section 3B of the Land Acquisition Act. It is also required to be noted that as such, out of 24 reference cases before the High Court in writ petition number so-and-so, the appellant restricted the prayer with respect to only 4 respondents. As observed herein above, at the instance of BDA, 4 appeals challenging the judgment and award passed by the reference court are pending before the High Court. Therefore, in the facts and circumstances of the case, and more particularly when the locus of the appellant Sarachi Bardhawan to challenge the judgment and award passed by the reference court is seriously disputed, and whether the appellant Sarachi Bardhawan can be said to be a person interested within the definition of Section 3B of the Land Acquisition Act, and thereby the appellant can challenge the judgment and award passed by the reference court enhancing compensation, are all disputed questions of fact and are all contentious issues. We are of the opinion that the learned single judge of the High Court ought not to have entertained the writ petition under Article 226 of the Constitution and ought to have set aside the judgment and award passed by the reference court enhancing the amount of compensation under the provisions of the Land Acquisition Act. The remedy available to the appellant could have been to prefer appeal before the High Court with the application for leave to appeal. Then, my lord, please come to para 11. In view of the above, and the reason stated above, the impugned judgment and order passed by the High Court in so-and-so is not required to be interfered by the court. The division bench of the High Court has also reserved liberty in favor of the appellant to pursue whatever other remedies may be available to them in accordance with law, which may be including to prefer an appeal before the High Court, challenging the judgment and award passed by the reference court, provided the leave to appeal is granted by the High Court, that is the appellate court. And then, my lord, at para 15 is a final conclusion. The court keeps that liberty open to the developer to file an appeal. So, my lord, that's the context, because you can't, through a writ petition, you couldn't have got an order which was pending consideration before the High Court in appeal by the development authority. So you could, that's what the court says. So this is distinguishable from my case, my lord, because your lordship saw, I had cited UP Awas Nigam to say that yes, the remedy of filing a writ petition is also available. It coexists with the right to file an appeal with a permission to seek leave of the court. Both options are available. So, my lord, that is how this judgment can be distinguished. And, my lord, Navili Lignite also, my lord, friend. Then, my lord, the documents in the second compilation, just 2, 3, and then, my lord, I am done. My lord, the second compilation that I have filed comprised of those documents pursuant to the directions of this court.
The second compilation. Huh? One.
Lord, it was filed on 4th of November. This is how it looks.
11th of November.
4th November. 4th November. Yeah. My lords have that? Yes.
Yes.
This is a compilation of 76 document pages. Well, please see page 8. Well, this is a letter written by the Special Land Acquisition. Your Lordship sees right on top, dated 26/5. I'm sure, my lord, this is a translation. It may not be accurate, but your Lordship, we can place the original one also for your Lordships. With reference to the subject explained above, as per the letter from the government dated at the above reference, in court cases number so and so, it is mentioned that the letter referred to about to deposit an amount of 31 lakhs so and so only in the court towards the land acquisition compensation cost. So your Lordship first notices that we are being directed by the government to deposit that amount. In all the cases explained above, the court ordered statement of accounts and all entries have already been submitted to the government. You are hereby requested to verify in this regard and release the amount of so and so for depositing in court as per the letter from the government. So, my lord, your Lordship knows under 31 of the Land Acquisition Act, it is the SLAO who has to disperse the compensation. So he is of course asking me as part of his statutory obligation to have the amount deposited. So, my lord, we have a response over the page at page 9. This is 30th July. We write to the Special Land Acquisition Officer. With reference to the above subject, an amount of rupees 33.64 lakhs towards payment of bills relating to the land acquisition cases have been released to your current account dated 21/7/2005. Accordingly, you are instructed to take action to deposit in court with suitable appeal to completely close the EPS registered in the said cases, and action to be taken to instruct the advocate of the concerned corporation to file suitable application before the court to completely close the said LAC cases and submit the report in this regard. The said amount shall be used only for the land acquisition cases specified in the description list, and care shall be taken to ensure that under no circumstance the said amount is to be used for any other person. The letter towards utilization of the same shall be submitted along with the counter signature of the concerned superintendent engineer to the head office, Dharwad. Prior to remitting the amount, it is instructed that all calculations shall be re-verified and so and so. So this is one, and then Lord, please see over the page in the next document. Again, written by the Special Land Acquisition Officer. Subject is release of grant as per the order of the Honorable Court. With reference to the above subject, land in so-and-so village is subject to land acquisition for the purpose of Amarja project. The Honorable Civil Court Kalaburagi has issued an order fixing an amount of rupees 42,000 and 67,000 per acre of Kushki land in LAC cases. Against the said order, landowners have filed an appeal to the High Honorable First District Court, and the Honorable Court in its order in the appeal has ordered payment of such and such amount as per acre in addition to the order of the lower court. As per the order of the Honorable Court, statement of accounts have been prepared. The details of the compensation amount to be paid to the landlords and details are below. In the above case, opinion has not been received from the government advocates and legal cell. As per the order of the Honorable Court, the statement of accounts have been prepared and submitted for the proposal for release of grants. Hence, it is requested to seek opinion of the legal cell of the Nigam and to take action to release the grants. So, my lord, these are all routine letters which the SLAO, as is duty bound, is required to ask us to make the deposit. The fact that whether he sits in my office or elsewhere is not of any consequence, because, my lord,
anyway, you have pointed out to the observations or finding of the Supreme Court in this regard. Even if you are able to point out that they were in the know of things.
Correct.
And there were communications. That itself will not.
That itself, absolutely. Because Abdul Razak, my lord, that judgment of the Supreme Court, that was one of the arguments made. Your persons appeared as witnesses. So the court said that is immaterial. They, in fact, that judgment relies upon the Agra Development Authority case. There again, the minutes of the meeting records that the beneficiaries were attendees. So the court said that is no consequence whatsoever. Because, my lord, we are talking about an SLAO who's a designated authority in excess of power of eminent domain. I don't have that power. If that declaration is made that by virtue of the SLAO sitting in my office, I have the power of eminent domain, it can't be. That's absolutely untenable. So these are all, so my lord, the fact of the matter, this matter should not have taken this long. Ultimately, everybody is interested in defending or seeking enhanced compensation. The fact of the matter is, I should have been made a party, I pay the compensation. And as I told your lordship the last occasion, the problem is we get to know about these matters only when we get execution notices and warrants. That is when we get to know about these matters. So, my lord, in my respectful submission, my lord, the order of the learned single judge, though it is not as elaborate as the way that I have argued it, my lord, your lordship may do it because there are thousands of matters, writ petitions pending, where, my lord, we are forced to file writ petition. So your lordship will lay down the law. So it will allow, my lord, everybody, including the land loser, he can focus only on getting work done, my lord. So much of time is being wasted in these kind of technicalities. Should not happen.
You also pointed out to some, I don't know whether it was some interim orders passed by the Honorable Apex Court to Supreme.
Yes, though the final orders. Yes, yes.
There is the submission that is taken note of.
Yes.
That they are coming to our office for execution of these awards.
Yes.
You pointed out, where was that? The Supreme Court has taken note of
The
that.
Supreme Court has only taken note of the fact that we were not made parties.
Yes, yes.
So that's at page 90 of my compilation, the original compilation.
There are two, page 90 minutes.
First compilation, my lord, the thicker compilation. Page 90, my lord, your lordship.
90.
90. 90. My lord, your lordship sees page 90, second paragraph.
Yes.
Further, in most of the appeals, the appellant Niravari was not made a party in the appeals before the High Court.
Last but one paragraph also, my lords. In our opinion, it is appropriate the parties are relegated before the High Court for reconsideration of the entire matter afresh in accordance with law.
My lord, in spite of this order, my learned friend takes up the technical plea that you can't just be impleaded. You have to file a formal application, and we did file. And he's contesting those matters. This order is passed on a permission to file SLP by us. Permission is granted. These are appeals. We are deemed to have been my lord, impleaded as parties, and the matters have been remanded back. And yet, my lord, they continue to raise these objections. Very unfair. Yes. And my lord, I showed your lordship that in the remanded proceedings, my lord, at page 119, my lord, your lordship had showed that when it suits their convenience, they give up that objection.
As a concession.
As a concession. And they are short of concession in law. It's a concession of fact on something like as substantive as this. So, my lord, that's can't. So, my lord, that is my respectful submission. My lord, anything else, my lord?
Yes,
my
Mr.
lord,
AG, you want to make some submission?
Please, my lord, I'll just, my lord, in so far, the implication is, my lord, there's KNL, similar, there are four Niravari Nigams, my lord, KNNL, KBJNL, various Kaveri Niravari Nigam, BJ Vishwasharya, again, Jala Nigam, my lord. My lord, only in KNNL, insofar as these cases, there are 700 cases, my lord. KBJNL, there are around 2,000 cases pending only before your lordships, my lords, where the special land acquisition officer is made a party and impugned judgments are passed by the court below, my lords. As I submitted earlier, my lords, it is not the case where we are denying the landowner the compensation. Award has been passed only by making the special land acquisition based on one similar award, my lords. All common awards have been orders are being passed where compensation is disproportionately increased. In fact, my lord, only in KPGNL, the financial liability will come out to 1 lakh crores, my lords. We won't be able to do any project because the state was not able to handle this kind of litigation. We constituted different nigams. Now, again, if they want to make the special land acquisition officer pass an award, my lord, it is the whole purpose of passing these government orders, creating different nigams to handle, transfer the assets and the liabilities. It is a case of not a beneficiary transfer where they step into the shoes of the state government and they conduct the litigation, pay the compensation, my lords. Therefore, a beneficiary is different, allottee is different, but a transferee is totally different, my lords. So therefore, my lords, and this court, my lords, has already held that the state government has no right to appeal, file an appeal. It is only the KNNL or they have to challenge the impugned order, my lord, pursuant to which all these government orders have been passed. I think that is all. The judgment also is part of the
2014 order.
compilation.
The 2000 which I placed last time, but that's part of the compilation.
That is part of the compilation, my lord, that your lordships will get it at page number 76. No, not 76. That is at page number 198, my lord.
198.
At 200, my lord.
Yes.
At 198, your lordship may kindly see the cost title, Special Land Acquisition Officer Belgaum versus so and so. The appeal is by the state government assailing the judgment on the award so and so. It is to note the appellant that even though the contempt awarded by the reference court is on the highest, the beneficiary in whose favor the land was acquired, concluding the claimant has not taken any steps so and so, so and so, so and so. Then, my lords, page 200, paragraph 4. Under the above circumstances, it becomes necessary for this court to observe that in case where the state government acquires land for private owners for the benefit of third party, generally is not an aggrieved by the acquisition of such land, in spite of the government have indulged in filing appeal in such and similar cases by spending public money unnecessary, and it has become a big litigant before the court of law. In such cases, the state government, after filing the appeal, challenge the award made by a reference court, has issued a government order that no appeal need be filed. Therefore, it is necessary to direct the registry of this court and send a copy of this judgment to the Law Department, Department of Law, Parliamentary Affairs, Reserve Service Secretary, Major Irrigation and Minor Irrigation, with the so as to that henceforth state government should avoid filing appeals in such similar cases, awarded a cost of 25,000, pursuant to which a government order came to be issued, my lords, which your lordships will get it at page number 76, my lords.
Yes.
MFA number so and so, UT note, a copy of the judgment dated so and so is enclosed herewith. It is brought to the kind notice as observed in the above judgment. When the land is acquired for the benefit of third party, state need not file the appeal against the judgment and award passed by the reference court. It is only an acquiring body. It is for the beneficiary to challenge the judgment and award passed by the reference court if agreed by the award. Therefore, in view of the said judgment, it is hereby directed for the state government to avoid filing appeal in such and similar cases, kindly treat. It has been sent to all the departments, especially serial number 4 and 3, 4, 2, 3, 4, and 5. That is minor irrigation, major irrigation departments, my lords. Then is the next circular also, my lords, at NHD page 77.
March 2024.
March 2024. There are then again it says 78, my lords, at annexure E. That is 7th August 24. At page 79, I may be permitted to read, my lord. On the background, page 79, last paragraph. On the background of above points and the point discussed in the circular dated 7th March 2024 and corridum thereof dated 19, the opinion given by the Law Department and Justice and Human Rights, so and so, so and so, so and so. These 4 nigams under the Water Department having separate legal set is thereby direct nigam shall take suitable decision its level regarding impleading, filing appeals, making payment of compensation, etc. regarding the land acquisitions filed before the High Court and after due verification of review from the legal point of view. So throughout, my lord, it is the whole purpose and object. Your lordship, I won't repeat, my lord, the circular at annexure D, page 77 onwards, my lords, all goes to show that it is only for the nigams to contend. And even the Supreme Court, my lords, when the nigam had gone, had remanded the matter because they have not made a party. Ultimately, my lords, your lordship will see this as an implication on all the litigation throughout the state with regard to 4 nigams, my lords. Any judgment passed in this will have serious financial, one is the financial implication, one is the whole authority of the 4 nigams, my lords. Therefore, my lord, rest of it is already stated by my learned friend, my lords. I don't want to repeat. And one of the last aspect, my lord, the special land acquisition officer is only deputed to these nigams for the purpose of acquisition and discharging. He doesn't become an authority by himself, my lords. He's only deputed for that limited purpose, my lords.
Firstly, my lord, certain personal remarks were made, my lord. I would believe, my lord, that would have been avoided. My lord, I'll not.
Sorry, I didn't make any personal remarks.
No, I'm not. I'm not
ನೀವಲ್ಲ.
against stage, my lord.
Senior counsel.
That would
That's
have
the
been
last
avoided.
thing I'll do, my lord.
That was regarding the orders
I-
passed by my brother,
Hmm.
which was sought to be relied upon by the learned counsel for the appellant.
Please. Okay.
That
Little other,
regard
but-
some
but-
submissions per me.
Yes. Lord, my lord, I would.
Judgment also. Though the matter is remanded. In last para 21, they have observed that we have already held that the post-acquisition authority had no right in the matter. They have clearly observed. Well.
Lord, selective reading of the judgment has taken place.
Matter is remanded, remand is for enhancement of compensation only, not for this point.
Lord, your lordships are referring to which
Para
one?
number 21, last line. Page compilation 2.
ಅಲ್ಲ, that was not arising from
ಅಲ್ಲ ಇವರು ಅದು ರಿಮಾಂಡ್ ಆಗಿದ್ದ ಇವ್ರು ಗಮನಕ್ಕೆ ತಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಇದೆ ಮೇಡಮ್. We have already held that the post acquisition authority had no right in the matter.
No, not in the Supreme Court remand.
ಅದಲ್ಲ.
Not in the Supreme Court. order.
When they made submissions before you in that matter where you were passed that order, ಎಲ್ಲಿದೆ ಅದು? ಇದು. ಇದರಲ್ಲಿ
ಅನ್ನಪ್ಪ.
ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಸಬ್ಮಿಷನ್ಸ್ ಮಾಡುವಾಗ he should have brought it to your notice that the Honorable Supreme Court in the case of the KNNL itself has passed certain orders which was not brought to your notice ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು.
Lord, in fact, para 8 of that order, your lordships have been persuaded to decide the matter based on MSA 20005 of 2018 and other related matters. All these matters relate back to 591 of LAC 591. And those orders have been set aside. 591, the remand order says you can't rely on it.
Yes.
But that is pertains to Mattimadu village, acquisition of some other year.
Yes.
Yeah, 90.
Lord, one thing, Lord, the AG has made it clear. Lord, this judgment, Lord, will have a repercussion on, Lord, many cases.
Yes.
Lord, 700, 2000, whatever it is, Lord. The position of law, my lord, may have to be, my lord, carefully scrutinized. Otherwise, my lord, it will open, my lord, at least 10,000 cases, my lord. The lordships are dealing with at least, my lord, 10 to 15 cases daily. None of the cases, KBJNL is a party. State is filing appeal, lordships are granting, my lord, time, interim orders. Lord, now, my lord, the irrigation department wants to work through, my lord, 3 companies.
Yes.
And they say that, my lord, these companies are all whole and soul, my lord, of the government. Firstly, my lord, what's the role of the state? State is a participant here through, my lord, SLO. Lord, there are 2 provisions, my lord, which may have to be, my lord, carefully scrutinized. My lord, at the cost of repetition, I'm saying this, my lord, because it will have a larger repercussion. The provisions under the law which provide for, my lord, notice are section 20 and section 50. These are the 2 provisions which provides for who should be, my lord, issued notice and when. Section 20 Karnataka amendments states of 3, my lord, propositions A, B, C. May I read that, my lord? Not just to, my lord, get it right, my lord. Entire issue is confused with the, my lord, proposition whether beneficiary is a necessary party. Lord, I started my argument with a statement that, my lord, I believe that beneficiary is a necessary party. I am trying to put across this, my lord, cases in a way that, my lord, I am contesting that they are not.
Understood.
Yes, my lord.
Your contention is that
Yes,
it is not a beneficiary.
they are not the beneficiary. Now, my lord,
Yes.
what to hold somebody as a beneficiary? What is the criteria?
Correct.
My lord, there is a difference.
Yes.
Lord, I hold that, Lord, any person for whose benefit preliminary notification is issued, who sent the proposal to the government for acquisition, he is the beneficiary. The other side says, Lord, a person who pays is the beneficiary. Lord, that's the, Lord, distinction which your lordship may have.
Yes.
Section 20, Lord, Karnataka amendment is relevant. If they say that, Lord, they are the government, they are part of the government, Lord, they fall under A. Deputy Commissioner is the sole person, Lord, who is required to take care of the litigation.
Yes.
B is, Lord, all persons interested in the reference. Lord, they cannot be interested in the reference because these are people, Lord, who are seeking enhancement. C is, Lord, if acquisition is not made for the government, the person or authority for whom it is made. So there is only three possibilities, out of which one possibility is for the claimants. The other two possibilities is government, non-government. What's the, Lord, requirement is if the acquisition is not made for the government. If I show that acquisition is made for the government, which they also admit now,
Yes.
then, my lord, A will come into play. It is the deputy commissioner, he is made as a party. He will have to take care of the litigation. Second is, my lord, section 50, my lord. And my lord, their pleading is that they are part of the government. They are assignees, they are special work purpose vehicle of the government. If that is the case, it is only the deputy commissioner. 50, my lord, is this is, my lord, acquisition for the company. My lord, I hope, my lord, I'm not, my lord, burdening the court, my lord. I'm just to be, my lord, on the cautious side, my lord, considering the repercussion, my lord. The acquisition of the land at the cost of a local authority or company. Here, your lordships may kindly, my lord, consider subsection 1, where the provisions of this act are put in force for the purpose of acquiring land. It is not, my lord, a case where, my lord, the post-acquisition, if the provisions of this act are put in force for the purpose of acquiring land at the cost of any fund controlled or managed by a local authority. 50 will come into play if the provisions of this act, that is, my lord, section 4.1 was put into motion by the funds, my lord, of the local authority. If that is not so, intervening parties, 50, my lord, will not be applicable. All judgments are under section 50. Subsection 2, my lord, may kindly be seen. I will read, my lord, UP Awas Yojana, the conclusions after reading, my lord, provision 2. In any proceedings held before a deputy commissioner or court, in such cases, the local authority or company concerned may appear and adduce evidence for the purpose of determining the amount of compensation. Proviso, provided that no such local authority or company shall be entitled to demand a reference under section 18. It is under this context of, my lord, understanding and explaining proviso to, my lord, subsection 2 of section 50, my lord, that 24, my lord, they said that, my lord, subsection 2 of section 50 does not entitle the company to seek for a reference. However, it doesn't bar them from, my lord, filing appeals or filing writ in respect of, my lord, any claims. That doesn't, my lord, straight away, my lord, entitle them for, my lord, entitle them, my lord, an opportunity for filing writ. Lord, another point I want to make it very clear that, my lord, I'm not, Lord, defending my award, and I'm not saying that, Lord, my award should not be tested before the court. It is not my case. My case is it should be tested in a manner known to law. Lord, let us assume that, Lord, what will happen if this writ appeal is allowed? Are they, Lord, out of the court? If your lordships hold that 226 is not maintainable, they can file an appeal. The consequences of filing an appeal is, I will have a right of, Lord, defending my award. In writ, my lord, the difficulty is...
No, but there again, you will raise the same issue.
Yes, my lord.
Maybe you are trying to say, there is a provision, they can go and file an appeal. But then, you will continue to raise the very same issue.
Yes.
that you are not permitted to file an appeal. That is why they have come to this court.
Aitu. My lord, that's one part. My lord. Let us assume that, my lord, I raised that.
Therefore, the request is, please decide this issue.
Yes, my lord. Yes. My lord,
For other contention that it is open for them to file an appeal.
Yes.
Because the provision itself says so. That was your contention. You are pointing out to that judgment to the Supreme Court.
Yes.
At any rate, writ petition cannot be maintained.
How?
They can go and file a appeal. That was your contention, isn't it?
Yes, my lord.
But again,
Yes.
their apprehension is that you will again raise the same issue. If they file an appeal or an application for impleadment, you will again raise the same issue. That they are not beneficiaries, they are not interest persons, and therefore an appeal cannot be maintained at their hands.
Aitu, ನಾನು raise ಮಾಡ್ತೀನಿ ಅಂತ ಅನ್ಕೊಂಡ್ರು ಕೂಡ, does that entitle them to take a shortcut of?
We will consider. We will consider everything.
Yes, my lord.
Yes.
My lord, firstly, my lord, that order, if your lordship sees, my lord, the UP Awas Yojana, which, my lord, entitles them to file, my lord, as they claim, my lord, that is the judgment which entitles them to, my lord, file a writ petition, and, my lord, they need not go in, my lord.
Yes.
Paragraph 24, my lord, 160 page number, there, my lord, compilation. This was read in, my lord, to show that, my lord.
Yes. Page number?
Page 160, my lord.
160. Yes.
To sum up our conclusions, my lord, this is the majority opinion. My lord, 1, 2, and my lord, 3, 1, 2, my lord, they said they are not relevant. They are not, they are at the stage of, my lord, at the stage before passing off an award by the reference court. 3 is, my lord, my lord, they said that this entitle us to file a writ petition. 3 says, my lord, the proviso to section 52, which I just read in, only precludes a local authority from seeking a reference, but it does not deprive the local authority, which he feels aggrieved by determination of amount of compensation, the collector or by the reference court, to invoke the remedy under 226 or Constitution, as well as remedies available under LA Act. So, my lord, this is not an enabling provision. This only, my lord, explains that what is excluded is you cannot seek reference. You have remedies other than, my lord, seeking for a reference. What remedy you have is under 7. 7 cannot be negated, my lord. Holding that, my lord, you also have remedy under 226. 7 specifically says, in the event of enhancement of amount of compensation by the reference court, if the government does not file an appeal, local authority can file an appeal against the award in High Court after obtaining leave of the court. So, my lord, this is the correct procedure. My lord, I may contest, I may not contest, or, my lord, I may fail or I may succeed. That's a different aspect. But this is how, my lord, it has to be done.
That is with reference to local authority.
No, that's again, my lord, a wrong. I will kindly see, my lord, 9.
Yes.
My lord, they are trying to put across, my lord, their position as 3 different things. Once they say, my lord, we are government. The other time they say we are, my lord, company. My lord, this cannot happen. They can either be government or, my lord, something other than the government. Section 9 may kindly be seen. The paragraph 9. Since a company for whom land is being acquired has the same rights as a local authority under so and so, whatever has been said with regard to a local authority would apply to the company too. So this is for company as well. If the company wants to agitate an award of the reference court,
what do you mean by company? What meaning does it have? You will again once again say it will be in terms of the definition of the word company.
I didn't
Isn't
follow.
it?
Yes.
The word company has been used here.
Yes.
You will again go back saying company means as defined in the act.
They fit in that definition. Our registered company.
Registered company. But the provisions would exclude a government company.
No, the provision does not exclude.
That was what you initially pointed out from the definition itself.
They pointed out, Lord, they say that government companies have a different, Lord, proposition altogether. Lord, that cannot happen. If you are, Lord,
Excludes government company. That's the law.
That's what.
And section 44B makes it clear. It excludes government company. Yeah. 3E. 3E.
Allah, my lord, if that is the, my lord, proposition, my lord, this judgment is not applicable to them at all. It applies to two persons.
That is why they have pointed out that the Supreme Court had an occasion to consider these kind of cases also, where an entity formed by the government steps into the shoes of the government and takes over all the assets and liabilities.
Yes.
And it is undisputed that it is paying the compensation. Therefore, Supreme Court had an occasion to consider such cases also, which may not strictly fall within the definitions or the words employed in the provision, like local authority, company, all these, which are the words that are employed in the provision, may not suit the entity like KNNL or whatever.
Yes.
So Supreme Court had an occasion, it has considered such a situation also, and thereafter rendered these judgments.
Yes, my lord. Then, my lord, we will have difficulty under section 20. Section 20 qualifies only two kinds of, my lord, persons.
We will see, we will consider. See, if there were no decided cases at all, then it would have, it would have become that much more difficult for this court.
Yes, my lord, Abdul Razak case, my lord, is, my lord, deviated by, my lord, Satish Kumar Gupta case. Now they are both, my lord, staring at each other. Abdul Razak case, my lord, they say somebody who has come subsequent to acquisition is entitled to contest, based on, my lord, the judgment in UP Awas Nigam, this UP Awas Yojana Nigam. Here there is no such proposition. But there was a specific question raised whether somebody who comes into, my lord, picture after, my lord, acquisition is required to be made as a party or not. In Satish Kumar Gupta case, my lord, that will be the case that will be applicable, not, my lord, this Abdul Razak, my lord, case.
All right, we'll consider. We'll consider.
My lord, I am not, my lord, holding the court, my lord. I need, my lord, I need some more point. I will answer, my lord, the one single judge judgment which they are referring and saying that, my lord, there is a bar for the state to, my lord, contest. It is the beneficiary who will. The second is, my lord, the remand orders. My lord, the remand order. If I'm given, my lord, day after tomorrow, I will be done in, my lord, 15 minutes. So I'll recompose myself and, my lord. I'm not, my lord, trying to, my lord, get away from the court. It's only, my lord, my concern is, my lord.
No, you should understand that the Supreme Court has in recent orders that I've got it clarified now. Again, in a recent order has made such observations and it has directed that it has to be implemented. In light of all that,
that's the difficulty, my lord. Your lordship, my lord, is referring to, my lord, page 81.
Page 90.
90. That
yes.
It starts from 81, page 90.
90, yes.
My lord, I have also attended this matters, my lord. Your lordship may kindly turn to, my lord, page 91, second paragraph.
Yes.
What was the nature of remand? This very order, my lord, said, accordingly, we keep all the contentions available to both sides to be considered by the High Court on its own merit and in accordance with law. My lord, a specific, my lord, a contention was raised that we are also objecting, my lord, the entitlement of, my lord, the Nigam. That was, my lord, kept open. It is not yet decided. My lord, insofar as remands are concerned, my lord, there are 4 orders of, my lord, Honorable Supreme Court. What is now read, my lord, in this order, which starts from page 81. If your lordship sees, my lord, it starts from page number 4.
Yes.
They conveniently, my lord, missed page number 1 to 3.
Yes.
Page 81, your lordship may see.
Yes.
Bottom, my lord, page 4. This order starts from, my lord, page 4. I will read, my lord, page 1 to 3 of this very remand order, where Nigam agitated all these ground. Lord, it's there in my compilation, Lord, at 1 146. Sorry, my lord. 146. 146. Leave granted. In all these appeals, the land involved is in village so and so, acquired by so and so. This was again, my lord, this is, my lord, page 1, 2, and 3.
Yes.
Same judgment.
Yes.
Here, my lord, the one batch of cases, my lord, the claim of the Karnataka Niravari Nigam is rejected. Considering, my lord, the case on merit. What was relied therein was, my lord, again, what is, my lord, again and again quoted as, my lord, Mattimadu case. That was the basis for determination of another judgment. And that was, my lord, held to be proper. And, my lord, what the court said was that, my lord, for 1985, this is the value. It appears to be proper and it is dismissed. So here was also a case where they agitated that we were not arrayed as a party. We were necessary party. It was the same set of arguments. It was the same single argument. Some matters where we could find, my lord, the court was, my lord, kind enough to, my lord, hear regarding that, my lord, the reliance placed was proper and, my lord, the judgment was proper. There, my lord, they have rejected. It is not that, my lord, blanket, my lord, all cases has to be, awards has to be set aside and matters have to be remanded.
No, not on that.
Yes.
This the issue as to whether KNNL can be considered as an interested person or not is something that is required to be decided by this court.
How?
How? This order,
yes,
that you just pointed out now or read out now.
Yes.
The Supreme Court has taken note of the fact that the awards are sought to be executed against KNNL.
They were not
It has been noticed.
Your lordship is referring to page 90, second paragraph, I believe, Lord. Their compilation.
Yes.
Further, in most of the appeals, the appellant so and so was not made as a party, not made party in the appeal proceedings before the High Court. No, there is no, my lord, observation that executions are put against them. Lord, let them come up with, my lord, certain execution petitions which are put against them, where, my lord, they are not arrayed as parties.
No, it was pointed out by the Learned Senate Council.
ಇದೇ ಕೇಸಲ್ಲಿ ಇನ್ನೊಂದು ಹೇಳ್ತಾರೆ page 90 ಅಲ್ಲಿ Lord, the nature of remand also has to be learned counsel. Last paragraph I'm reading, Lord, page 90. Learned counsel appearing for the landowners were at pain to point out that some matters pertaining to some of the notifications referred to in the present appeal proceedings have reached up to this court and decided in favor of the landowners, including in some cases the appellants have acted upon the decision by paying compensation amount. Even the effect of such orders passed by this court can be examined by the High Court on its own merit and in accordance with law.
Yes.
Now, my lord, the second remand order also your lordships may see, my lord. It starts from, my lord, page 109, which is again based on, my lord, the earlier remand order.
Yes. You want another day?
My lord, I will be done with, my lord, just to, my lord, recompose myself and, my lord, subject to lord's accommodation, my lord. It is not that I'm getting away from.
When?
May request for, my lord, 19th, my lord, or else, my lord, 15th, my lord, or 9. Because, my lord.
No, 15th, not possible.
19th, my lord.
19th?
Yes.
It might not be available, Lord.
But my learned friend can finish.
Yes. Your presence may not be necessary. If he wants some 10-15 minutes, let him. Heard.
Then with a cap of 10-15 minutes or. I'll not be taking much time, my lord, but not, my lord, 10-15 minutes. I'll.
Yes. Heard learned senior counsel for the respondents and the learned advocate general. Full stop. Next para. At the request of learned counsel for the appellant. Release this matter on 19th of November at 2:30 p.m.
Let.
Yes.
Was an interim order.
Interim order granted earlier stands.
My lord, it was not extended last time. I missed, my lord, but earlier it.
All.
It is, my lord.
Forty-nine, date ಬೇಕಾ? ಯಾವ date? Ravi B. Patil. Next week. 21st. 21st ಅಂತ.
Yes, sir.